Hey guys, good morning. Happy Tuesday. Day 2 of our full week this week. What do we think? Is Judge Canoni really going to have the stamina for a full week? Five whole days? We'll see, won't we? Well, so we're going to continue today with the cross-examination of Dr. Marie Russell. Dr. Russell, always a fan favorite. She's just such a cool lady. You know, what a cool life story. What a good testament to just, work hard and follow your interest. And next thing you know, you could end up being a dog bite expert. The most qualified person in the country on something really, really obscure like dog bite injuries. And then the next thing you know, you could be that skill could be in high demand for some reason. I really admire Dr. Russell's life path, the way that she's had adversity, she's worked through it, and she's just continued to grind. Um, it's just an impressive thing to see somebody who has that kind of internal motivation and drive. I don't think she is where she is with her multiple residencies and board certifications and qualifications and publications and all that stuff because somebody was pushing her to do that. Yeah, don't get that impression at all. It's really just a self-motivated thing that's what she values and that's what she's pursued. And I find that very admirable myself. So we'll continue with her cross-examination, and I think the big question for today is, does Hank actually have a be nice gear? Does he have a be nice gear? He's trying real hard to be nice to her. Uh, just even the little bit that he started yesterday with his cross, it's like he's realized that going after Dr. Russell is not going to land. It's not going to connect with the jury. The jury is not going to want to see you accuse this nice old lady of being a fame whore. It's just not a look that they're going to see eye to eye with you on this one. So he's trying very hard to be nice, praising her about her qualifications, her experience, apologizing when he has a little snarky moment because he just can't help it. He just can't help it. I'm not sure he actually has the be nice gear. He's so dripping with contempt that he can't not spew it at whoever happens to be in front of him. So, Hank trying to be nice is an interesting experiment. Interesting thought experiment for one thing. Like, can I even picture this? If I picture this, what does it look like? And then is he able to pull that off? Is he able to deliver that in a consistent and believable way? Guys, my hopes are high. They're really not. He just seems to have this habit, this persona that he's developed as a lawyer that is just angry and defensive and contemptuous. So I'm kind of expecting, that's the treatment Dr. Russell is gonna get, whether that's Hank's intention or not. I'm just not sure he can really move out of that to deliver something else. But that's the challenge for today. We'll see. He seems to know, signaled many times yesterday. He seems to get it that this is not a lady you wanna try to soften up in front of the jury. We've got some reports from Dr. Turtleboy that The next witnesses that we expect after Dr. Russell, Lucky Loughran. We knew Lucky Loughran was in court in the courthouse on Friday, so he's probably coming up very soon. Lucky Loughran, Karina Kolakithis, and Nicholas Barros. So it's kind of an interesting lineup that gives us a little bit of a perspective on what the defense is doing, what they're going after, the little bricks that are forming the defense that they're constructing. So we've already seen the first part of the tech analysis. And the first part of the tech analysis is just straightforward. The Commonwealth's experts are wrong. They, even if you take everything that they say at face value, it does not prove that there was a car accident because you still have John locking his phone after this, the conclusion of this trigger event on Karen's car. That is only loosely, if at all, kind of correlated with an accident, period. But, the Commonwealth says this is the one where it happened. So even if we take them at face value, we still end up with a problem of several seconds. The group text, got a preview of the group text. Now, granted, that wasn't entirely on the defense. Defense just wants them in evidence, just want them in, and then go in and discuss them with somebody else. But Hank did deflate them. The element of surprise a little bit was taken away by Hank having the friend read them. And then the ones that are particularly offensive, Hank read himself. Except for that old C word. He just wrote a check he wasn't prepared to cash. Offering to read those texts. Couldn't bring himself to say the C word, Michael Proctor said. Of all the things to be sensitive about, why so sensitive, Hank? So genteel all of a sudden. We got the text messages. We got Officer Kelly Dever, and it was just kind of weird. I mean, Kelly Dever was just kind of a weird witness. So defensive. So accusatory. So full of all this spitfire for the defense. Because they want her to tell the jury what she told the FBI about seeing Higgins and Berkowitz inside the Sallyport with Karen's SUV for a wildly long time, and that it seemed weird to her because Brian Higgins was a witness. And there he is with this key piece of evidence with the police chief. Can definitely see how that would seem a little weird. But now she's explained that away as a false memory. Couldn't have happened. It's something she made up in her mind because her shift ended at 3:45. Therefore, she could not have been there at the Canton Police Department when Karen's car was brought into the Sallyport at 5:30. I don't necessarily see the logic of those things. Okay. Because clocking out doesn't necessarily require you to go anywhere other than to the clock. Or that this couldn't have just happened maybe the next day. Don't know, but she wants us now to think that this is a false memory. And it's not a very compelling explanation, is it? It's a very specific memory that you have. You had a lot of, reasons for why you felt the way that you did. I remember from the Richard Allen trial, we had the expert in false confessions talk about some of the ways that you can tell, some of the verbal ways that you can tell, you can distinguish between a false memory and a true one. And it's that a true story is associated with sensations, feelings. You put yourself back in the place where you were when that thing happened, and you can kind of relive it. You can smell the things, you can hear the things. And so it's very physically grounded, that kind of memory. Whereas a false memory, it's a narrative. It's a story that you've told. It's something that you've worked out in your head as far as like it makes sense, but it doesn't have that same connection with the process of having experienced it. And so that's what stood out to me with Kelly Devers's testimony, is the weirdness. It was weird. That's what made her remember it in the first place. It felt weird. Whereas then her explanation for why it wasn't true, it sounds a little bit more explanatory, doesn't it? Doesn't sound like she had a moment where she realized, and what that felt like, realizing this memory was false. No, nothing like that. Just an explanation, very dry, very academic almost. I realize it was a false memory, and I've been exposed to lots of media, and I'm no longer able to distinguish between what I remember independently and what's been tainted by the media. Well, we know that your memory wasn't tainted by the Sallyport video, because the Sallyport video wasn't even produced to the defense until like a week before trial last year. So it wasn't in the media. There wasn't Sallyport video in the media. Don't know where you got Sallyport video from. Don't know where you got Higgins and Berkowitz from the media. Yeah, just not really sure about this explanation. But it sounds like something that you're more like writing a paper than telling a story. I had false memories, and so that was weird. It was kind of weird, but the point of that appeared to be to elicit that that recollection, whether we believe it or not now, that that Higgins and Berkowitz were together in the Sallyport with Karen's SUV. At least, I guess, shortly after the incident, maybe not the same day, but close in time. And now we have Dr. Russell, the dog bites. Going to start going after John's injuries, and the arm. The arm is the big tell. The arm is what says this is not a motor vehicle collision. This is not road rash. This is not a broken bone. This is not a serious contusion. These are dog bites. They do look an awful lot like dog bites. Once she points out the groupings, you can really see that. Really visualize it. So it's been a lot of chipping away at little pieces of the Commonwealth's case, just little fact by fact bricks that the defense is building. And we're not at a point yet where I can really see if there's a logic to it. It does seem, frankly, a little bit scattered at this point. We've jumped from the Lexus data and the analysis of the Lexus data to Proctor, to Berkowitz and Higgins, to John, and now then following up on Turtle Boy's announcement, if we're to accept, coming up next is Lucky. And Lucky would be, John was not out on the lawn at 2:30 to 3:30 in the morning when he was doing his plowing out on Fairview Road. But then there was a mysterious Ford Edge that ended up parked out there in between his passes. So going to, where was John's location during all of this? Why didn't anybody see John on the lawn? Because he wasn't there. Karina Kolakithis testified at the first trial. She was a Commonwealth witness in the first trial. And Karina is just a friend of a friend. I think she's friend with the McCabe's. And or she knew them from the basketball. I think she'd been at the basketball game earlier as well. So they're just out at the waterfall, kind of random people. Her testimony was that Karen and John had been, normal, affectionate, lovey-dovey. She called him lovey-dovey. Asked her husband, why aren't you like that with me? Oh. So now attacking the motive, little piece of evidence to try to undermine that motive that the Commonwealth is arguing. Oh, Karen knew John was going to break up with her, and so she's in a rage, I guess. It's always been such a weird, murky motive anyway. Even when Aruba was in there in the mix, like, dude, that was like a month ago. I don't know. Strange stuff. But so one piece of evidence to come in and kind of chip away at that argument that there was a motive. And then Nicholas Barros, the Dighton police officer who was present for Karen's car being towed, saw the taillight, described it as cracked but not completely broken. What exactly does that mean? We don't know. We don't really know, because it's the kind of description that both parties can make it work for them. You can have the defense arguing, he said crack, not completely broken. And look at that taillight. It's completely broken with big chunks missing. Commonwealth can point to the taillight and be like, look at that massive taillight. And it's just this one piece that's broken out. There's all this other part of the taillight that's still intact. It's not completely broken, but that part right there, seriously cracked. So both sides can kind of use that the way that they think it benefits their case. Nobody wanted to show him the photograph of the back of the SUV when it was in the Sally port. When we finally get a good look at the condition of the taillight days later, nobody wanted to show him that and ask him, is that what the taillight looked like when you saw it? And so I wonder if that's going to change this time. I do. I wonder if that's going to change. It's a little bit of a gamble on the defense's part if they don't know. If they don't know exactly what he saw or exactly how he'll describe it, it's a little bit risky to put him on the stand. He's not necessarily married to the same lingo that he used in the first trial. Doesn't necessarily have to use that same description. So if you don't know exactly what he saw, that's maybe a little bit of a gamble. But if you do, then we know they're going full bore on the taillight and the cover up. The taillight sprinkles on the lawn, the 47 pieces, plastic, whatever it ended up being, none of which was there in the morning when they did the search with the snowblower, only gradually appeared in the weeks following this storm, when the scene is no longer secured and everything is run through the hands of Sergeant Buchanan and former Trooper Michael Proctor. So if they can nail down with Officer Barros that Sally port image of the taillight, not what he saw in Dighton, that would be big. That would be quite big. It would be a massive adjustment in his testimony from the first trial, a big clarification of what exactly it was that he saw. And would that be devastating for the Commonwealth? Yeah, I got to think it would. Kind of got to think it would. To have a police officer blowing the cover on how this taillight changed condition after it was in the possession of the Massachusetts State Police, and right about the time all this taillight starts appearing on the lawn. Yeah, I'd say that would be pretty devastating. And that's why it makes me skeptical that that's going to happen. It does. I'm skeptical that that's going to happen. Not just because we have another cop. Okay, so we've still got the thin blue line influence on that guy's testimony, even if he's not the same unit, same department. just declined to be suspicious, that he's going to credit the law enforcement officers over everybody else. It's just kind of the norm when you're on team state, team Commonwealth. But there's that but, isn't there? He's just kind of lurking out there because we don't know. And why would the defense call him if he's real uncertain? So a little bit of a scattershot approach from the defense in terms of what they're attacking, how they're attacking it. It's not a case where the defense is getting one and systematically presenting their own version of events, their own story. It's much more just piecemeal, taking little bits of what the Commonwealth presented and then going in and undermining that. So starting that off right off the bat with Matt DeSogra, your facts, science, and data, we're going to take that away from you. We're going to take that out of your case because you've got a timing problem. And the only way you can get to, this tech stream data shows the moment when Karen hit John O'Keefe with the car is to actually suggest it doesn't. It must have happened, this is just the data being recorded. It doesn't mean it corresponds with the real life event of what Karen's car was doing. And if that's the case, then why are we even here? Why are we even here? The data doesn't show us there was a car accident. Why are we even talking about the data then? It's a little nuts. But starting with him, going through everybody we've seen so far is just kind of chip. Not chip Michael Proctor chip, but just, slowly chipping away, fact by fact. And so we can anticipate more of that, I think. We know we're going to get, for example, Dr. La Posada, forensic pathologist. Got a little preview in the opening of what she's going to have to say. As far as John did not, in fact, have signs of hypothermia. Kind of sounds like from that Alessi cross of Dr. Scorti Bello, John may have had some alcohol-related disease. Or at least that's going to be the opinion of the defense medical examiner, more consistent with some kind of pathology that's the result of alcohol consumption than being left out in the cold. I think perhaps we're expecting a little bit more of a technical take on frostbite, hypothermia, all of those types of things. So just one more thing that's chipping at the Commonwealth's case and their story of what happened here. That's a big piece of it. If John is outside for 6.5 hours in the blizzard, the worst blizzard, guys, the worst blizzard in January in Massachusetts history. And John has been out in that for 6 hours. What would we expect the biological effect of exposure like that to be versus what do we actually have on John? Question we had all the way back to the first trial, really didn't get any answers about that. Wondered, John's body temperature, the interaction between how do we know when John died? Do we know when John died? Somebody commented, messaged me on Instagram with a good example. Because this has just been something I've been hung up on for a long time. If somebody dies in the cold, I am to take it, I guess, from the EMTs and from the doctor, the medical examiner, that somebody's not dead until they're warm and dead. So you got to warm them up, see if they come back to life, because it's just too, I don't know, there's too much noise. You just can't distinguish enough, I guess, between the effects of death and the effects of the cold to know what exactly you're dealing with until you get the person warm up. And so anyway, the example was, all those people up on Everest, I guess they're not officially dead yet. They're kind of Schrodinger's, Wallace up there. Mallory, you know, Schrodinger's Mallory up there. He's been on. Well, I think he vanished. Mallory was up there for like almost 100 years, and they found him in like the 90s or 2000s or something like that. But then he disappeared. I think there's theories that the Chinese government went and took him off the mountain. I'm not sure, but anyway, you know, he's been cold on Everest quite a number of years. But if he's not warm yet, do we really get to say that? So there's obviously some point where we get to say that.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors.
Good morning, jurors.
I have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about the case since we left yesterday? Everyone said no or should get. Is Dr. Russell in the back there? Mr. Brennan, you can set up if you want to.
Shut up, Mr. Brennan. Get your prop notebooks all out there, ready to go.
Doctor, I'll remind you, you're still under oath. Thank you.
Thank you.
Good morning, Dr. Russell.
Good morning, Your Honor.
May I?
Yes.
Good morning, Doctor.
Good morning, Mr. Brennan.
I had asked you yesterday if your opinions regarding the wounds on Mr. O'Keefe's arm changed between when you testified last year and then the more recent hearings that we've had over the past 4 or 5 months. Do you remember that question?
Yes.
And when I asked you that question, I asked if you had help with your report, and you told us that there was a woman who helped you with your report.
I told you that there was someone who helped me or made suggestions in organizing the report, having certain sentences placed in certain categories.
When I asked you about the identity, the person who actually helped you, I asked you if it was one of the attorneys, and you had said no.
That is correct.
May I approach, Your Honor?
Yes.
May I ask a question?
Yes.
Thank you. You had testified in December 22nd, 2024 in this case?
I believe it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say?
I wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
Then I said, okay. And you answered?
No, I wrote the report.
And then finally I asked, who helped you with your report? What did you tell us?
I said, Mr. Alessi.
Devastating.
And Mr. Alessi is that gentleman, the attorney who asked questions on direct examination?
Yes.
Okay. And so, did Mr. Alessi help you with your report?
What I recall is we discussed the report, but I recall that it was someone else that actually helped me rearrange the report. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but, you have something in writing.
Do you think you would have testified to that if it was inaccurate?
Mr. Alessi did not help write the report. He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have any help trying to describe methodology?
No.
You had any help talking about differential diagnosis?
No, I'm very familiar with differential
And
diagnosis.
so, after that report was written, is there any reason why some of your opinions have changed?
I don't believe my
Objection.
opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty, that is absolutely correct. And I'd like to see that, but yes, that's my recollection.
If it's your recollection, I'm happy to show you what
Yes,
you
please.
testified to. You want to
Yes,
see it again?
yes.
Okay. And by the way, between last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I ask you a question? Did that advice come your way?
That's my general advice from previous times.
Or did you have any advice last night about that?
Yes.
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Alessi.
So did you and Mr. Alessi, you know there's a sequestration order, don't you?
Yes.
That's a sequestration order that you're not supposed to discuss the case at all with anybody?
Well, we
during the-
didn't discuss specifics.
Do you know that the sequestration order mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
I understand that there is a sequestration order.
Do you understand the sequestration order mandates that you're not supposed to speak to people, including the attorneys, about this case overnight? Did you understand that?
There were no specifics discussed.
Or did you understand that you weren't supposed to, is what I'm asking? Did you know that's a violation of the sequestration
No, I
order
didn't.
to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
There's a driver.
Okay, who else is in the car when you left court yesterday?
The driver.
When
Oh,
you-
no, I wasn't with him yesterday, no. Not in the car yesterday, no.
Well, you just said that you spoke to Attorney Alessi yesterday. And I'm trying to figure out when was it that you were having conversations with Mr. Alessi relative to this sequestration order that you're under?
This morning, riding to court
Okay, so you and Attorney Alessi drove to court?
with the limo driver, yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
That was just us.
Just you two?
Yeah.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
the entire ride here, there must be more you spoke about other than just the sequestration order.
We did. We spoke about Boston, how I love Boston area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride back to the hotel yesterday with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case. What else? Not about the Red Sox or the weather. What else did you talk to Attorney Alessi about this morning other than you should ask for a transcript every time I ask you a question?
We talked about what I did last night.
About this case?
No,
I'm sorry, but I'm asking about this case.
that was it.
I want to know what all the discussions were between you and this attorney today or last night about this case.
Just that I should ask for a transcript.
Well, there must have been some there must have been some context. He didn't just turn to you talking about the weather and say, hey, you should ask for a transcript. You must have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony, what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
Okay. What else did he tell? How did it come up? Hey, by the way, ask for transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well, it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
No.
Do you have any memory issues?
No.
May I approach?
Yes.
Transcript.
Well, she didn't like that, did she?
Since you've asked for the transcript, I have it for you. Dr. Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there's no need to try to refresh your memory, but I'm going to show it to you because you asked. Take a look at line 16. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than 100%? You couldn't be 100% certain.
That looks consistent.
Okay. You want more time with the transcript?
No.
This taste on her face.
Has anybody else talked to you about your testimony today overnight, Dr. Russell?
No.
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date?
Yes,
May I see the
of
transcript?
course. Pursuant to Attorney Alessi's advice, let me approach.
Objection, Your Honor.
I'm going to strike that. Disregard that, James.
May I approach?
Yes. What page you want us to?
As if it's Alessi's fault that he's never prepared to cross, needed to go overnight and find all his transcript bits because his binders are just a prop.
June 21st, 2024, Doctor?
June 21st.
Page 23, line 14. Will you ask the question based on everything we've discussed today? Is it your opinion based on a reasonable degree of medical certainty these injuries were from an animal attack, possibly a large dog? And what did you say?
I said yes.
Thank you. Can I have that back?
Yes, you may.
Okay, thank you. When you gave your opinion, not this year, last year, you agreed when you were assessing the wound, you used the word or adopted the word possibly, didn't you?
Explain the context of it,
Sure.
that sentence.
Sure. Go right ahead.
No, you. I'm sorry.
Okay.
I'm sorry. Please rephrase the question.
When you were asked about your opinion last year, not this year, last year, about whether to a reasonable degree of medical certainty the injuries were from an animal attack, possibly a large dog, you agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination, there were tons of questions about this word methodology. Do you remember all those questions you were asked?
In June?
Yesterday.
Yesterday, okay, yes.
Yes. And when you were asked about methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes.
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
When you described methodology, you were asked by attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance, on how to determine something is a dog bite. However, I did use different methodologies, including what we talked about, the differential diagnosis, the pattern recognition. Pattern recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There is no standard. There is no recognized standard anywhere for methodology on how to identify a dog bite wound, is there?
There is no published standard from an organization that I am aware of.
So there is no source, there is no recognized community, there's no certification, there is no recognized method in identifying a superficial abrasion as a dog bite. Isn't that fair to say?
As in many conditions in the medical field, there are no certifications.
How about published standards? Is there any published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
No, but there would have to be thousands of published standards to identify the causes of the thousands of different types of abrasions. So no, there's no published standards.
No published standards. There is nowhere you can point to where the so-called methodology that you were telling the jury yesterday is a readily accepted standard in the dog bite community. You can't point to anywhere, can you?
Community?
There are peer-reviewed articles which list recommendations on how to determine something is from some wounds are from a dog. These are peer-reviewed articles written by esteemed physicians that have analyzed dog bites and have published these and have published an approach to identifying, particularly a forensic approach to identifying dog bites.
Let me ask you the question again, Dr. Russell. Can you point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites? One article, one journal, one book. Can you point to any?
Well, I'm going to mention the articles I mentioned earlier. The article with the lead author of Dr. Munnynck and the article with the lead author of Dr. Pollack. And although they're not standards, they are recommendations.
I'm going to ask you the question one more time before I approach. Can you point to one place, one, where there is a readily accepted standard in the dog bite community for identifying dog bites?
No.
What is the dog
And so
bite
with no
community?
readily accepted standards in the dog bite community,
What is the dog bite community?
no defined methodology, when you look at a photo like you do of John O'Keefe's arm, you're just eyeballing it based on your personal experience with dog bites, rather than relying on some type of scientific foundation that has been published and accepted in the community.
Objection, Your Honor.
I'm going to allow that.
Isn't that fair to say, Dr. Russell?
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet doctors make and nurse practitioners and the like make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment. There are not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking about a stuffy nose or a broken leg. We're talking about dog bites here. So let's focus on dog bites, if you would, if you can indulge me, doctor. Regarding dog bites, since there is no standard practice, there is no accepted methodology, and since there is no accepted and approved guidelines, you are essentially simply looking at a picture, a photograph, and just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years, and the methodology and the articles that I read. The numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a methodology for determining that those are the result of a dog.
Well, you say coming up with a methodology. Are you saying that you're creating your own methodology, that you're the person who has the standard and nobody else? Is that your position, Dr. Russell?
No, the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine, dog bites. There is no accepted methodology, is there?
That's true.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely wanted to be in this case. You weren't sought out. You sought the case.
That is incorrect.
And you said you had a strong interest in dogs, and that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
No, that's actually an unfair statement. I did not want to get involved. I wanted to offer my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case. And I used, again, as I do on just about every medical condition that I look at and every wound that I look at, I do a differential diagnosis. What else could this be? What else could have caused these scratches and abrasions and wounds? What else before I come to my conclusion?
On your ride over here today, were you instructed that when I ask a question, rather than answer it, give a long explanation about something else?
No.
I would like
Russell's
to
not objecting much.
put up an exhibit of Mr. O'Keefe's arm, and I want to ask you some questions about it.
I'd be objecting more. Just you're
You and I
gonna
have had many
protect your
conversations
expert.
about Mr. O'Keefe's superficial scratches before, haven't we?
Yes.
And would you agree, looking at these, they are superficial abrasions? Do you agree with that characterization?
Yes.
When we last spoke, just for background, to remind ourselves, we broke these into separate parts so we could discuss them by number, just for a sense of clarity, and we discussed this as wound number 1. Do you remember that?
Grouping number 1, yes.
Number 2?
Yes.
Number 3?
Yes.
4?
Yes.
5?
Which did you call
sorry, this
4?
one.
4,
5.
5, 6, maybe.
Okay. So as we go through, I'm going to identify them by number. That wasn't done by anybody else. It was just during our discussion so we can have clarity. Is that fair?
Okay.
Sustained.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
I think so.
Okay. When you testified on June 18th of 2024, last year, when you came in, you were asked questions before the actual hearing. You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe
course.
so, but I'd have to see the transcript.
Do you remember when you were first giving opinion testimony about this specific abrasion, wound number 1? Do you remember you saying that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
So, do you remember your testimony?
For each specific day, no. I remember generally, but not for each specific day.
If you
I've
have
been
an
here many
opinion-
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always be the same?
Generally, yes.
Okay. So let me ask you before we talk about what you said at the beginning. What is this from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't be so much uncertainty, would there? You'd be able to look at this, consider the methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
You know, Mr. Brennan, perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape, and very similar to the nails that the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
Are you saying that nails of a dog are so similar to the teeth that you can't tell the difference between them when you're looking at a wound?
I'm saying that they can cause similar-looking abrasions.
Are you able, as the premier expert in the United States on dog bites, able to tell the difference between teeth and claw nails of an animal when you're looking at a wound?
Individually, well, okay, that's a very interesting question. Sometimes it's difficult because they can have similar appearing wounds. So you have to look at the overall pattern in order to make some conclusions.
But when you first started testifying in this case, you never suggested you had to look at everything in totality. You were giving opinions regarding individual wounds. Isn't that fair to say?
No.
It wasn't until I began asking you questions and you had inconsistent answers that you've now changed from, rather than identifying individual wounds, now you're saying I can't identify individual wounds, but I can tell you in totality.
No, Hank, you did exactly
I
what you're
disagree
doing
with that.
here.
I believe that in the very
asked
first
about
time I
individual
testified, I
wounds.
mentioned that the overall pattern was important.
When you first testified, so today, before we get to your testimony, you're saying this could be either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth, to a reasonable degree of medical certainty? You're not sure? What is the value of your certainty or lack of certainty about what caused this wound?
Reasonable degree of medical certainty.
What is a reasonable degree of medical certainty? That what?
That those are caused by teeth.
Teeth. Okay. When you first testified, your position was it could have been teeth or nails. That is different than saying, to a reasonable degree of medical certainty, teeth, isn't it?
No, there is a small possibility that they could be caused by nails.
When you first testified, you didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered. Do you remember when you were asked about it and you answered? You talked about that it was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
saying that this is a pattern close to the shoulder, right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Nails on a dog, oftentimes or most times, are horseshoe shaped, aren't they?
They're generally conical shape.
You don't think that nails on a dog in your studies have a horseshoe shape?
I think it depends on the grooming of the dog and if the nails were cut recently. But in general, they come to a point. They're at the, at the end of the paw. They come to a point, and by the way, the paws can open and close, so the distance between the nails can vary depending on how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you think that the teeth in a dog are different shapes and sizes?
Oh yes, depending on the tooth, there's different shapes and sizes, absolutely.
When you testified the first time and you said that you thought it was teeth or nails, do you remember testifying a couple days later in front of a group of people and you again iterated that this could be teeth or claw marks? That was your testimony last year, teeth or claw marks, right?
Your Honor, I'm going to object to the characterization of that prior proceeding.
So just prior proceeding, folks, that's all that we need.
Did you testify at that prior proceeding last summer that this could have been teeth or claw marks?
I would need to see the transcript.
May I approach?
Yes.
When you first testified on June 18th, Doctor, you were asked questions trying to identify what you thought that wound was. And this is your June 18, 2024 testimony. On page 37, line 7, the questions begin, and you were asked what you thought they were. You can read any part you want, but line 7 might be a starting point.
Yes, I said that which are consistent with teeth marks. They also could be possibly consistent with nail marks.
Dr. Russell, I'm just going to ask you to keep your voice up, okay?
Okay.
Oh, where's the inconsistency in any of this? We're just showing her her prior testimony where she says it in slightly different words, basically the same thing.
Thank you. That was your first testimony last year, yes?
Yes.
And then did you testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking if you remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report?
Yes.
After your consultations, do you remember changing that opinion regarding number 1? Do you remember changing that opinion?
No.
Do you remember changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
No.
Are there different types of teeth in a dog?
Yes,
Okay. The pointy teeth, the big ones, those are called canines,
correct,
and the smaller ones are incisors.
correct,
There are 6 incisors in a healthy dog on the top and bottom between the canines.
correct.
Okay. Did you, when you testified subsequently to the original proceedings, did you change your opinion from teeth or claw marks to specifically teeth, and even more specifically canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony from teeth or nails to being very certain that it was canines, not just teeth, canines that caused that wound?
I became more certain, yes.
You had never said that the canines caused these wounds before you filed the report, ever, did you?
I may not have, that's true.
And so after you did your report, you shifted from teeth and nails to canines. Do you remember that?
I don't think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes,
That would be a mistaken use of the word.
I believe so.
When you testified December of 2024, you didn't say nails could have caused this wound. You didn't say generally teeth. You said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have any new information about photographs that would help you change your opinion from teeth and nails to canines?
Well, I had been challenged. I had testified several times. I reviewed the case several times and challenged, and each time I reviewed the case, I became more certain that these were from canine teeth. And actually, there's other marks there, but these are from teeth.
You say more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth. Canines are some of the teeth.
Upper or lower canines?
Upper.
And if it's upper canines, you testified previously that the point of entry would be here at the bottom and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there, and the dog pulled this way, or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be in backwards. Remember that conversation we had?
Objection, Your Honor.
I'm going to allow.
Do you remember that conversation? You said that the point of entry would be the bigger circle, pulled this way, and then I questioned, how could a dog's arc look like this if the teeth went that way?
No, I don't recall that at all.
Remember that conversation
No.
we had? Okay. And so, inevitably, when you look at this part of the wound alone, have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog?
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that was from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However, as a group, they are highly characteristic of a dog
So if
injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound up
Yes.
there, closest, I agree, yes.
In fact, you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
You can
Correct.
say it's consistent.
I'm going to go through all of these just so we're
Kind of
clear.
rule out is
Same
what I
thing with
think
number
the issue
3.
is.
You've provided opinions on this before. If you look at this wound alone, in isolation, you would not be able to say that it came from a dog bite.
Correct.
4, pardon me, yeah, 4, same. Looking at the wound alone, you would not be able to say it came from a dog bite.
Correct.
Same for 5 and same for 6.
Correct.
Now, when you testified before your recent testimony, you never had that qualification. When you came into court, you were saying that when you looked at these wounds individually, you were saying that you could identify it as a dog bite.
I disagree with that characterization.
Number 2, what caused this wound, Dr. Russell?
Number 2, I believe that was dog bite or scratch, but mostly I believe dog bite. And because there's a punctate, little tiny, pinpoint almost, lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about a reasonable degree of medical certainty. So when you look at this wound here, you said that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is what I am convinced of.
I want to go through each of these wounds separately so we understand what you actually recognize with your methodology and what you don't. So looking at wound number 2, based on whatever methodology you've been using, are there any signs, indicators, objective criteria you can look at and tell us this is or is not a dog bite based on this methodology you have?
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and many of these, overall, by the way, parallel lesions are in the same general direction. So there are parallel lesions, and here they're associated with some punctate or point-like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but my question is more pointed. Is there anything about your methodology, something that stands out about these wounds, that you can say to a reasonable degree of medical certainty that these are consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
You said on this first wound, you thought this was from the canines. Those are the big upper teeth is what you're claiming, right?
Yes.
And you're saying today, anyways, starts here at the bottom and goes up. Is that
No.
your position today?
That's not what I said. I said the exact opposite.
So it starts here and comes down.
Correct.
Okay. And these 2 scratches, they're linear, just like these are linear, aren't they?
Yes.
But you have a problem with these because if these are the canines, you see the spacing there?
Uh-huh.
This is nowhere close, is it?
I didn't say that these were caused by canines. And spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second. Are you suggesting that these exact, well, not exact, these 2 linear abrasions, just like 1 and 2, are you suggesting the canines caused these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testified last year on June 18th, you said that this was either teeth or claws. Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Excuse me? No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2, the top 2 linear abrasions, you believe were either teeth or claws. You shared with us now you have improved your study and have new opinions. Do you have a clearer opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently, Mr.
Do you have an opinion whether this is teeth or claws or not something totally different than a dog?
I believe they are teeth or claws caused.
when you testified at trial and in that hearing that they were teeth or claws, you changed that opinion as well at the most recent hearings, didn't you?
No, I'm going to object to the word that was used has been done before.
Mr. Brennan, word it differently.
Sorry?
Word it differently.
Okay. Did you testify at a more recent hearing that teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
May I
Can
approach?
you just hold 1 second? Could you please turn the fan off, Paul? Jurors, is it okay if we turn the fan off so we can hear better? Thank you very much, Officer Delano.
When we can hear that airplane jet fan, it's got to be very loud in that
May I
courtroom.
approach?
Yes.
From your December hearing, page 100, line 5, when you were asked about that second wound in December, and I asked whether you changed your opinion from teeth or claws to just teeth, weren't you asked specifically about that on page 100, line 5?
Yes. But may I read it?
Sure, I'll read it with you.
Okay. I said, I'm not sure on the second set. So this is the set just above the elbow.
I'm not sure exactly what teeth made these. They could, one of them could, one set of these could be canine, one part of this, and then adjacent incisor tooth. But I'm not sure on the second set, so this is the set just above the elbow.
Yeah, I think the first part of that paragraph is talking about the first set
Yes.
up there close to the shoulder, and then the sentence, but I'm not sure on the second set, so this is the set that's just above the elbow. I said I'm not sure.
And then, sorry,
Go ahead.
Are you done?
Oh. Yeah, actually, I did make another comment. What is it? So, however, what is interesting and certain is that there's an upper set and a lower set. So, this mark was an upper tooth. This is a lower tooth. What I was referring to is this mark here and that mark, and then this mark here and this mark here. So it appears that this is from upper, and these are from lower. That's what I was referring to.
So once again, not a change, not an inconsistency.
And so when you first described this wound as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth. Correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter-of-factly, not with any qualification. Your claim at the last hearing is this was from teeth.
That's what I believe.
And today you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell. You were
Yes.
asked, what do you think? And you didn't say with 100% certainty. Your claim, the first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Suffice to say, looking at wound 2 alone, you cannot say this was caused by a dog.
In and of itself, no.
What tooth do you think caused this wound?
I don't know.
Do you think this in any way could be caused by dog teeth if you're claiming that this is dog teeth?
Excuse me?
Do you think there's any way these two could be caused by dog teeth if you're saying that these two were caused by dog teeth?
Yes, it could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing, Dr. Russell.
Did you say strike or strike?
Strike with a K.
Look at the spacing, Dr. Russell. A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
They don't, and I'm not claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
It's possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I did.
Posterior side?
Excuse me. Pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
This is his posterior arm.
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm, the fleshy part
That's
of the
exactly
arm?
what I'm asking. It's a question I've asked before. When you look at the other side of Mr. O'Keefe's arm,
Don't
did you
get
notice
pissy 'cause
anything
you used the wrong term,
conspicuously
Hank.
absent?
Yes, there's an absence of wounds.
When a dog bites, I don't care if it's a law enforcement dog or a domestic dog, you know it's like a lever, a dog's mouth, isn't it?
It can be if both jaws strike the skin. However, there are many times when only the upper jaw strikes the skin.
The lower jaw is a lever, locks, and that's part of the clamping and pulling process of a dog, whether it's a law enforcement dog or a domestic dog. You know that, don't you?
I know that they are attached.
Your claim is that there's many, many different dog bites on Mr. O'Keefe's arm. Are you suggesting, to a reasonable degree of medical certainty, that these are a number of different dog strikes and coincidentally every single one of them lacks any wound to the underside of his arm?
Yes.
Your claim is that a dog penetrated the sweater on the top, but the lower jaw did not leave any wounds?
I'm claiming that that's not what I'm claiming. No. As I mentioned earlier, these could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your medical opinions. Your medical opinions. Do you have any evidence that the dog's lower jaw, you said maybe upper, maybe, that the lower jaw, even just once in this whole event, penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions. But I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, can you tell us to a reasonable degree of medical certainty whether or not this was caused by a tooth?
Yes, Your Honor.
We're going to strike the first part. Why don't you ask the other part?
Can you tell us to a reasonable degree of medical certainty whether this superficial abrasion you put that back up, please, was caused by a dog.
In and of itself, that part only, no.
Can you tell us anywhere on Mr. O'Keefe's arm to a reasonable degree of medical certainty where the lower jaw impacted Mr. O'Keefe to leave even a scratch?
Not with a reasonable degree of medical certainty on individual wounds.
And not just individual wounds, I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower jaw caused any of those abrasions?
I believe there are several areas where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you first talked about these wounds, again, is it fair to say that you described that it could have either been teeth or claw?
I'd have to see it.
Okay, I'll bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so I want to be.
Well, you have the
Specific.
opinion today, and I'm getting the transcript for you, Dr. Russell.
Thank you.
You have the opinion today that that those were either teeth or claws?
Yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. To a reasonable degree of medical certainty, can you give us an opinion regarding the cause of those marks?
Objection, Your Honor.
So I'll strike the comment.
Can you tell us to a reasonable degree of medical certainty whether these wounds were caused by teeth or claws?
Individually, no.
Dr. Russell, you said you had a collection of photos. Would you share some of your collection? Just imagining the redirect.
Did you ever change your mind about the source of these abrasions?
Can you be more specific?
Did you ever claim that any of these abrasions were from upper or lower teeth?
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth or claws?
I have an opinion.
To a reasonable degree of medical certainty?
No.
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either dog teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
Individually, no.
The one near the wrist, you had testified yesterday, there's lines in what you believe to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's 2 linear abrasions on the outside borders, wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
If this was an arc, like you claimed, you think different teeth other than the canines could have caused the outside scratches?
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound, given the distance between the inside and outside.
First of all, I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic. It bends. It depresses. So you could have two prongs, for instance, of a pitchfork, for instance, just as an example, impact the skin in different places, and the measurement between the two can be slightly different depending on the elasticity of the skin and the underlying structures.
This is not a slight difference, Dr. Russell, is it? The distances?
Again,
Objection, Your Honor.
So there was a question at that, so I'm going to let that in.
Again, Dr. Russell, the distance here, it's not insignificant, is it?
Mr. Brennan, I already mentioned that I did not think that these were caused by two canine teeth.
And these, the distance between these two, have you measured them?
I approximated them, yes. And
what did you come up with?
visually, and I can see that there's a difference.
What was your measurement for this one?
I think about 4 centimeters, and this was a little bit more.
Did you note that in the report? Did you
No, I
actually
did not.
measure them, excuse me, did you actually take out a ruler, measure them, and document them as you studied these wounds? Did you go through that process during your methodology?
No, because this is an image, and there's no scale in this image as to how far away different points are. So my own measurement would not be accurate because there's no scale in the picture.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper or report, notes?
That's correct.
Why would you even go through the process if you're looking at it and your explanation is, it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite obvious, doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis. Do you remember using that term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with a car accident. That's what a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition
So
methodologies.
if you're going to exclude a cause of the injury, in this case, a collision, you have to know a little bit about collisions, don't you?
Yes, I don't know how to answer that.
Well, try.
Can you be more specific?
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
Actually, I disagree. However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with. And that forms a basis for me.
Do you really think?
I'm sorry, please.
Did you finish that answer, Doctor?
No.
Did I cut you off?
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case?
Yes. Yes.
I didn't have a lot of information, that's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit and run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
Do you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of accident
Yes.
investigation, yes.
Have you ever testified as an expert anywhere in accident reconstruction?
No.
Do you know what ACTAR is?
ACTAR?
Yes.
No.
It's a certification group for collision specialists, accident reconstructionists. Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
No, and I don't know any physicians that are.
Have you ever gone to a scene of a car collision and done an investigation and written a report and reached a conclusion about the cause of the car collision and the injuries that were related to that car collision?
No, that's outside my scope.
It's beyond your expertise.
Beyond the expertise of a physician, yes.
Right. Yet, yesterday, you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion yesterday?
Wounds are in my area of expertise. So yes, I am very comfortable talking about wounds from a variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay. Yeah, wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes.
Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those factors,
Have you
yes.
studied that before you
Studied.
gave this opinion? Yes. Did you go and actually look at the photos, do any measurements before you came up with this opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if it was in similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
I have looked at photographs.
And when you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight? Did you notice that?
I noticed that there was a similar, that the height would be similar. The height of the elbow and the taillight, yes.
Did you look at photographs of Miss Reed's broken taillight and see if where the break was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
I did.
And did you see that it matched up height-wise perfectly?
Close, yes.
You have really no, respectfully, comprehension about the details of the car collision in this case, do you?
I have
Objection.
some understanding of the allegations
Thank
of
you.
a
Good job,
possible
Russell.
collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling on
Fastly.
January 29, 2022 at about 12:32 a.m., right around the time that you think these wounds happened?
I have some knowledge of the alleged speed at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft or frozen?
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body first landed on that ground?
Several inches.
Where did you get the information that there were several inches of snow on the ground when Mr. O'Keefe landed?
You said
Photos?
you asked me when?
Where did you get that information from?
A report that I read.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved from the ground, there was grass and dirt under him?
Yes, I saw a picture.
Okay, not 2 inches of snow. the ground, the cold, hard ground. Did you see anything that said that?
Yes, I saw an area of grass in the picture.
Have you ever looked at Mr. O'Keefe's pants to see if there was any dirt or grass stains on the back of them?
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence of grass on the pants.
Did you ever actually look at the pants?
I don't know if I looked at the pants.
When you say you didn't see any evidence, are you saying you didn't look, or you looked and you didn't see anything?
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the pants, photographs, the actual pants themselves? Did you look at them?
I looked at the pictures that were available at the hospital of his clothing that was on the floor.
Were part of the photographs that were available for your review and your conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion about something outside your expertise, that this was not consistent with a collision, wouldn't you want to see as much information as
So
possible?
let's, yes, we'll come to Sidebar's turn.
Well, this is annoying, isn't it? But he is incrementally making at least some small progress. I don't know how effective it is to point out the difference between looking at these wounds individually. You can't form a lot of conclusions about them versus looking at the pattern as a whole is what gives it the characteristic features of dog strikes. On one hand, it kind of seems like that's not really very logical, right? If you can identify multiple dog strikes, then surely you could identify a single dog strike. But on the other hand, we can also kind of look at it, be like, yeah, I could see how if all you have is, that second one down from his arm is just a couple of abrasions with some stuff on the bottom. Where I think she is maybe not tracking his question so closely is that I think she could say it's consistent with a dog bite. Of course, she could say it's consistent with a dog bite. She just couldn't say definitively it is. I'm going to identify it as a dog bite. But you could say it's consistent because it doesn't become inconsistent just because you're looking at it individually. So I'm not sure if that has been like too confusing to land, or if that is something that is gonna get the jurors' attention and be like, that doesn't make any sense. That it's bites if you look at it in a group, but not if you look at it individually. This whole "you're not an accident reconstructionist," really not sure that any of this is landing. She saw grass and dirt in a picture, not under John. You didn't. I have to wonder now if this is that photo that they took when Gallagher and Good were out there in the morning. Remember, they cleared off part of the curb and took a picture. And it kind of looks like, because it's terrible picture, bad lighting. These guys don't know how to photograph, and they're using a potato to take their photos. But it kind of looks like it's just a broad expanse of snow with a bare area in between it. And if you don't know that you're looking at the curb, potentially looks like it could be a patch of bare ground just out there in the grass where John would have been found. So I do wonder if it's that, because of course the photos of the area where John was found, no grass, no dirt, nothing but snow. But does any of this matter? What exactly is the dog bite community anyway? Is there a dog bite community? Are we assuming facts not in evidence? Because I'm pretty sure she's opining, as a member of the medical community, medical and or forensic, pathology community, not a specific dog bite community. I don't know where Hank makes this stuff up sometimes. Might have scored with the whole chat with Alessi. You know, she's too honest to say no. No, we didn't have any sort of conversations about it. But you know, conversation, he told her to ask for the transcript. Is this a violation of the sequestration order? It's not about the case. It is about how to testify, though, or what might help her with her testimony. If you don't know specifically what you said before, or if he's asserting that you said something before, make him show you. Because one, you can't take anything that he says on faith. You need to question everything that he says. Two, he may not be prepared to show you that transcript. He'll just make something up and then not be able to back it up, which is kind of what we saw yesterday. Or three, you get to see for yourself. You get to see if it's being taken out of context. You get to see if it's cherry picking. You get to see if you explain further on down the page, you know, what's going on. Is that a violation of the sequestration order? They're not talking about the case, but they are talking about how to testify. Have to see the sequestration order. And the thing is, I don't think there is a written sequestration order. I don't think there is one. I think they just invoked the rules. Invoked the rules. And the rule just says, at a party's request, the court may order witnesses excluded so that they cannot hear other witnesses' testimony, or the court may do so on its own. But the court may not exclude any parties in a civil proceeding nor the defendant in a criminal proceeding. There's nothing in here about discussing the testimony. Still not a great look, though. Makes it look like they scored, and the way he asks his questions, where he loads them up, he assumes the answer. Did you not realize this was a violation of the sequestration order? It's I'm objecting to that. It's assuming facts not in evidence. We haven't established it is a violation of the
Dr. Russell,
sequestration
before
order.
you gave your opinion to this jury, suggesting that Mr. O'Keefe's wounds on his arm were not caused by an impact with the motor vehicle, did you go to the scene of 34 Fairview and look around in the corner of the yard?
I did not need to.
Did you?
No.
Did you look at photographs to see if you could identify the land, the dirt, whether it was flat and smooth or whether it was bumpy, whether there was rocks or debris in that area?
Yes.
And you went there and looked at it?
No. You asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from the photos, were they close enough so that you could see what the makeup of the ground was?
No, most of the ground was covered with snow.
The
Did
mineral
you know that there
composition.
were bushes right near the area where Mr. O'Keefe was found? Bushes with branches. Did you know that?
Not very
branches.
close, no.
Did you see the bushes in the photographs near where Mr. O'Keefe laid?
Right where he laid, no.
How about next to him on the left? Did you see those bushes?
There was some other stuff there in the photograph, but the photographs I looked at were not of excellent
The
quality.
bushes caused injuries now?
Do you have any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I don't see any medical evidence that there was impact with the vehicle.
Do you know Mr. O'Keefe had other injuries other than just the superficial abrasions on his arm?
Yes, but no significant injuries below the neck.
How about on the head? Was there a significant injury?
Oh, yes.
When you considered excluding car collision as a source of those wounds, did you consider in your history that you've seen, or have you seen, let me strike that, have you seen in your history multiple victims of a car collision where
Many.
they were
Sorry.
hit by the same car?
Probably, but I can't recall a specific case.
Would you agree with me if a car ran into a group of people and caused a number of injuries, those injuries to different people could vary wildly from one to another?
Yes.
Even if the car was going at the same speed and ran into a group of people, those injuries could be totally dissimilar from one another, couldn't they?
Yes.
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way. Yes?
Yes.
Another person could have a less severe injury, maybe a broken bone.
Yes.
Another person in the same exact collision could have scratches.
Yes.
In fact, there are cases, I'm sure you've studied, where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
Could you repeat that?
Are the instances that you have considered where a person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
No significant injuries, correct.
So a car collision can cause wildly different injuries depending on many, many unpredictable factors. Isn't that fair to say?
Yes.
When a vehicle's involved, have you ever been involved in treating patients that received injuries from broken plastic or broken glass in a car?
Yes, many times.
And when you've seen them, have those injuries differed on a person as far as cuts and abrasions from glass or broken plastic?
Yes.
When you were considering excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip type event rather than being run over?
Yes, I considered multiple scenarios.
Had you, or do you agree that injuries from a side swipe or from a clip could be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or impact as the source of Mr. O'Keefe's abrasions, about what his body posture was, how he may have hit a motor vehicle? Did you consider that?
I considered several scenarios,
And when you
several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact. There were no significant injuries from the neck down. No fractures, no bruise, no internal injuries, no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity. No significant injuries from the neck down, and so yes, I used that and tried to put that in a scenario of his various positions. What could he have been standing, kneeling, sitting, lying down on the ground? I did all that.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived at scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
Debris.
Debris field, yes? Did you look at the debris field in this case?
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
I couldn't tell on
Did you
the
ask any
photographs.
question? I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries, lining up in a certain fashion to cause those regular striations.
Rather than imagining, did you make any effort to actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you ever, as a police officer looking into car collisions, ever hear of the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian, yes. Not as a medical expert.
Could I have Exhibit 74B, please? In your study, before you gave an opinion excluding an impact or a collision as the cause of Mr. O'Keefe's abrasions on his arm, were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that there was one shoe off, correct.
Were you aware that it was wedged right up against the curb? Were you aware of that?
I'm aware, I have been aware of that, yes.
And when you came to your conclusion that you offered that the injuries are not consistent with a impact or car
Yes.
collision,
What does
was
this
this
shoe
photograph
have to do
part
with
of your
his
consideration?
injuries?
No.
Could I have Exhibit 99D, please? In your study to give an ultimate opinion, where you suggest that a car collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
No.
Do you see underneath that hat there was not 2 inches of snow? It looks like dirt and grass.
Yes.
When you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
It could be important. However, it could be. If the ground was frozen, if it wasn't frozen, it could matter a little bit.
Exhibit 73, please. When you were reaching your conclusions, you said you considered some of the debris field. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
Is that facts not an evidence
76A,
that it
please.
matched? Because that one didn't match.
Same question. Did you consider this piece of the debris field when you were coming to your conclusions that you offered us yesterday?
I considered that there would be several pieces of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No.
What does that have to do with the injuries?
Would it-
Since
you
when
can
is
take that down,
evaluating
please.
a photo of
Would there
taillight
be any significance in
injuries?
your study, in the foundation of your opinion, that a collision or impact did not cause Mr. O'Keefe's wounds on his arm? Was it important for you to determine whether or not the taillight to the defendant's Lexus was broken early that morning?
I think there needs to be more to the question.
Okay. When you were considering potential causes of injuries. Did you know that the defendant's Lexus rear right taillight was broken in missing pieces?
Yes.
Was it important to time when that taillight was broken?
What do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2022, yes?
Yes.
Early morning hours.
Yes.
When you were making your differential diagnosis, was it important for you to learn
can't just not
whether around
spit
that
that out.
time the defendant's taillight was broken?
Diagnosis.
It was important to know. I still don't understand the question. I'm having a trouble
Okay.
understanding the
It's
question.
my fault. I'll try to ask it a different way. You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes.
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle. Yes?
That's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes.
And you learned that her right rear taillight was broken and missing pieces, yes?
Yes.
Did you want to know if there was any evidence depicting when that taillight was broken? In considering this conclusion,
Yes.
did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
Objection, Your Honor.
I'm going to allow that.
Not at the time, but I expected that if there were a collision, that there would be pieces of the car, involved. So it didn't really make any difference.
When you were trying to rule out a collision between Mr. O'Keefe and Ms. Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and timer?
A broken taillight in and of itself could not cause those injuries. There would have to be multiple projections from the vehicle that were lined up in a certain pattern to give those parallel marks all in the same direction. So, that's why a broken taillight could not have done that.
So you, in your investigation, you did not want to know when that taillight was broken.
Oh, I did, but for information only.
Did you review the ring video from 5:07 a.m. at Meadows Ave?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Oh, after.
So you had already arrived at your opinion, then you received new information, which was that ring video, correct?
And it confirms, yeah.
And then you received more information. Did you receive photographs from a dash cam during a wellness check showing the defendant's Lexus missing pieces of her right rear taillight at about 8:03 a.m. that morning?
Objection.
Would that be? I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10. It actually was from a video. Did you look at this picture during your differential diagnosis?
I think I've seen that picture before.
And
The
could we
car,
have
the vehicle parked. Yes.
Exhibit 11, please. Did you consider this picture in your differential diagnosis?
I didn't. I don't know that I ever saw this picture.
Seeing this picture, do you see that the right rear taillight is missing pieces?
I can't even see that. Oh, yes, I do see that. But again, these pieces would have to be lined up in a certain configuration in order to cause those wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No.
You had, as a police officer, when you're excluding the source, and in this case you're saying the cause of Mr. O'Keefe's scratches on his arm could not have been from a collision, do you listen to witness testimony or do you review witness statements?
Objection, Your Honor.
I'm going to allow that. Just, do you do that?
As a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Did I listen? Did I take witness statements?
Yes.
Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to be the veracity of the witness.
Have you listened to the statements of the defendant herself in this case regarding potential impact?
No. What do you mean?
Well, have you seen any statements made by the defendant to any media about potential impact or collision in this case?
Oh, are you referring to what you've asked me previously about? Did I hit him or something of that? What do you mean specifically?
Have you seen any of the media statements by the defendant, 2020, Nightline, docuseries? Have you seen any of these statements in your analysis of whether or not there was a impact or collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
I did see some statements, but that was after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 2020 or Nightline?
I've never seen that situation.
No. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year and a half later?
A grief reaction can last years. It usually is very brief, but it can last years.
Now, when you looked at the clothes in this case, Mr. O'Keefe's clothes, you are aware that those clothes were swabbed for DNA traces, weren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Right. Could we have Exhibit 147B, please?
But we don't have the results in, do we?
On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor. I'd like to approach, please.
Okay, come on up.
Yeah, it's not an evidence. He's trying to elicit hearsay, not coming in. They haven't called it. If he wants to ask her about it, he should have elicited. You should have called the dog DNA tester and elicited that. I don't think he's going to be allowed to go into this. At least he shouldn't. He shouldn't if you don't intend to call this person and you haven't called them already. Because now it's not a fact and evidence. Well, I definitely like how Dr. Russell keeps emphasizing that she didn't see any medical evidence that there was an impact at all. There was no broken bones. There was no lacerated organs. There was no collection of fluid in the torso. There was no significant bruising. Nothing like that. She was able to get that in a couple of times because when would a doctor look at a photo of a taillight at a scene and be like, oh, I therefore I diagnose? Like it's maybe it's just me. who finds Hank extremely annoying in so many ways. But when would a doctor ever be like, no, I can't determine the cause of this injury, but the photo of a piece of taillight in the snow now tells me what that injury was? That just doesn't really seem to add up to me. He's trying to turn her into an accident reconstructionist, but she's there to evaluate injuries and the injury pattern. She's been able to point out a couple different times too, this broken taillight, it's not going to cause those injuries. They're too parallel. She's treated glass and plastic injuries resulting from car accidents. It's not going to cause a pattern like this. They'd have to be lined up in a certain way to cause wounds like that. Doesn't make any sense. The acute grief reaction is a good explanation for Karen's behavior at the scene. I think it definitely makes sense and is the kind of thing that is going to register with people. I don't think she's trying to say, yes, that's what then happened at Dateline. That's what Karen's statements to Dateline were grounded in. But I think she is saying that's what Karen was talking about on Dateline is, being in that particular state. How it was affecting her, what her thought process was, why her mind is racing. Could I have clipped him? Is it possible? What if I this? Not that she's going through that at that moment in time when she's giving the interview, but she's describing what it was like to be going through that at the time that they found John. So that seems to make a little bit of sense. Is she up there at Sidebar asking Hank if he's about done yet? Not rushing him, of course, not trying to rush you in any way. But just want to know if you're about to wrap it up here because it's just about break time. Just about time for a little morning break. Not to rush you, Mr. Brennan. What are we going to get on redirect? I wonder. How's he going to redirect this, Mr. Alessi? Surely a lot of this has been anticipated. Does the photo of a taillight, is that medical evidence that you would rely on? Don't know. Whether John landed on snow or solid ground, would that affect the injuries on his right arm? You weren't evaluating the rest of John's injuries, were you? Just the right arm? Maybe we'll kind of clarify that. The whole individual versus the grouping. I'm not sure how you redirect on that. It just seems like it would be helpful to, because it's not entirely clear. It's not entirely clear, like, why we can look at these differently as individual injuries versus the group as a whole. Like, what is distinctive about the group that allows you to say, yes, as a group, these are dog bites, but if it was just the one, we wouldn't be able to say that? I don't know. I do think they could redirect on, Hank had phrased the question as not consistent. You can't say with a reasonable degree of medical certainty that the single group is consistent with a dog bite. No, I think she can. She absolutely can say it's consistent. It's not suddenly inconsistent with the dog bite because it's on its own. She can say it's consistent. She just can't say that's probably what it is if it's just standing alone. So maybe some redirect on that. Not really sure how you do that, but unfortunately, Alessi is quite a lot smarter than I am.
Taking longer than any of us wanted to do while you're sitting here. So we're going to continue what we're doing, but we will give you the morning recess. So that's about a half an hour or so. Okay?
Yeah,
All right,
kind
for
of
the
saw
corner,
that
please.
coming home.
Those are your notebooks, follow me.
Kind of saw that coming. He's really, gone hard on trying to cross her on her opinion changing, but he really didn't have the goods to deliver on that. He really didn't have the goods. The teeth versus the claws,
Sam, watch your step coming down.
the lack of certainty.
Jury, exit to the courtroom, please be seated.
They're all very consistent.
All right, Mr. Alessi, I'll hear you. Mr. Alessi, I'll hear you.
Thank you, Your Honor.
Excuse me, Mr. Brennan.
I'm going to go to the podium and your jury is there. If you'd like to
Mr. Brennan, can you remove? Oh, okay. It's being removed.
Mr. Brennan, could you get all your shit off the podium? Your props. Not helping.
Thank you, Your Honor. Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal Dr. Crosby, who would talk about the supposed absence of DNA, the
It's
alleged
hearsay.
absence of it.
Testimonial hearsay.
The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object and object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The
It's not
fact
just
that they did it in another
confrontation.
trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
He's on fire. Pissed off.
Brennan?
Inquiring
Crosby
of
can bring it
Dr.
up.
Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury. Let's be clear. The defense is on notice that there is no dog DNA in the sweater of John O'Keefe. Let's be
That's
clear.
not
The
the
defense
thing.
is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal. It is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it. She discounted it. She created false
that's not
theories
this
about
trial,
the
is
potential
it?
destruction of it. But she did testify this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient. It might be hurtful for the defendant's theories, for the creation they portrayed.
No, it's not an evidence,
for
Hank.
this jury yesterday, but it is not
And it's a
improper,
confrontation
it's
clause
not
problem, and a big one.
unconstitutional, it's not irrelevant, it's very relevant. It is powerful evidence that the Commonwealth has
So
to
call Terry
undermine
Kuhn.
this
Why didn't
idea
you?
that the linear superficial abrasions on John O'Keefe's arm were somehow caused by a dog.
Dog.
They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are important and not important. Because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense, about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion, because you can't come in and just take the favorable factions to yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence, because it shows her inherent bias in all of her opinions, where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead.
Thank you, Your Honor.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds of the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
May I have 30 seconds?
Sure.
The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 22nd, December 12, 2024 transcript, I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words, we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alessi on direct examination.
Alessi.
And there are more. There are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alessi. Wholly.
All right, thank you.
Doesn't matter
Give everybody
anyway.
a half an hour. So
Taking a half an hour. Oh, this is where I do kind of wish Mr. Alessi were a full-time criminal defense lawyer, because I would like him to be screaming confrontation right now. And here's why, guys. I got something to show ya. I got a couple of things to show ya. So first, we're going to look at this case. This case out of Massachusetts. Department of Youth Services versus a juvenile. This is like one of those kind of landmark cases that get cited all the time for what is the standard for admitting an expert opinion. Let's just take a look at what they say, don't we? The issue here, the juvenile asserts that the judge should not have permitted the expert to state his opinion because the expert relied on facts, not on evidence. What facts? Family history, psychology testing, medical, neurological histories, interviews, etc. So what's the rule? The settled and traditional rule in Massachusetts is that the competency of an expert witness to testify to his opinion rests upon unusual knowledge and extraordinary experience superior to that of ordinary persons. The witness being qualified in this particular then may base his opinion upon facts observed by himself or within his own knowledge and testified to by himself, or upon facts assumed in the questions put to him and supported by either admitted facts or by the testimony of other witnesses already given or to be given at the trial, or upon facts derived partly from one source and part to the other. So they're looking at this Rule 703, which we've read before, bases of opinion testimony by experts. This is actually, we're going to skip this because this was a proposed rule that was equivalent to the federal Rule of Evidence 703, and the rule that Massachusetts, Massachusetts never adopted a rule. They don't have rules of evidence. So the common law in the rule, they acknowledge the federal rule is very different, and the Massachusetts common law doesn't track that. So the proposed rule was to broaden the basis for expert opinions beyond that current in many jurisdictions, to bring the judicial practice into line with the practice of the experts themselves. They're concerned about a doctor can't come in and testify because he gets reports from the patient. They tell you what their symptoms are. How do they feel? How much does it hurt? And if they can't rely on that, then how are they going to be able to give you a diagnosis? So the proper inquiry is not what the court deems reliable, but what experts in the relevant discipline deem it to be. And so, talk about all these different things that in different cases, particularly in the federal court, experts have been allowed to talk to. However, Federal Rule of Evidence 703 has been described as raising a serious potential for abuse. By permitting experts to base opinions on data not admissible in evidence, Rule 703 encourages litigators to look for experts who will base their opinions, at least in part, on evidence that is otherwise inadmissible, but which the proponents of the experts would like the juries to hear. Whether or not using Rule 703 in this manner is an abuse, it is an increasingly common tactic. You're backdooring. You're backdooring inadmissible evidence by getting an expert to rely on it. So, it's controversial. It has plagued the courts. Whether or not some places you might even be able to describe the inadmissible stuff to the fact finder. That is what is known as a backdoor, and no matter how many limiting instructions you may have, it is an ominously large door. So because of the problems, we are not persuaded we should adopt it. We should, however, take a modest step by permitting an expert to base an opinion on facts or data not in evidence if the facts or data are independently admissible and are a permissible basis for an expert to consider in formulating an opinion. Such a charge will eliminate the necessity of producing exhibits and witnesses whose sole function is to construct a proper foundation for the expert's opinion. So we're trying to balance these things, right? You can't just backdoor hearsay, but if they could get it in anyway, then we're not going to say that the expert couldn't rely on that. So if this is all that we had to consider, hey, they could call Terry Kuhn. She could be a witness. It is potentially admissible, the testing that she did. So we wouldn't foreclose it for those reasons. However, that isn't all we have to deal with, because we have a confrontation problem, which is what gets us to Commonwealth versus Barbosa. So 2010 case. Same kind of issue. What can the expert base their opinion on? In this particular case, I'm not going to go through all the facts because you can see it's fairly extensive, but it's about DNA testing. And so one person testifies about the results of DNA testing performed by another analyst who wasn't employed by that same department at the time of trial. So the defendant argues and the Commonwealth concedes that Delator, this is the non-testifying analyst, Delator's table showing the results of the DNA testing was testimonial hearsay, admitted in violation of the Confrontation Clause, as was Lynch's testimony conveying the information in the table to the jury. The defendant also argues that Lynch's expert opinion regarding the significance of the DNA test results violated the Confrontation Clause because her opinion was based on Delator's work product, which itself was testimonial, and essentially repeated her findings. To address this later argument, we examined the intersection between our common law rules of evidence concerning expert testimony and the constitutional right of confrontation to illustrate that our evidentiary rules and the Sixth Amendment are in harmony. So they have to establish these 5 foundational requirements to bring in the expert testimony. It will help the trier of fact. Witness is qualified as an expert in the relevant area. Expert's opinion is based on facts or data of a type reasonably relied on by experts to form opinions in the relevant field. The process or theory underlying the opinion is reliable, and the process or theory is applied to the particular facts of the case in a reliable manner. Any of those things are missing, you can ask for the Daubert-Lanigan hearing, and the judge has to perform the role of the gatekeeper to make sure that it meets a minimum standard of reliability. If here there's no motion in limine and no invocation of the judge's gatekeeper role, expert's opinion may be admitted into evidence. Where a Commonwealth expert testifies to her own opinion, the opinion is not hearsay because the declarant of the opinion is testifying at trial. Similarly, because the defendant may confront the declarant of the opinion through cross-examination, the defendant is not deprived of his right of confrontation. However, if a Commonwealth expert on direct examination were to testify to the conclusion or opinion of a second non-testifying expert, that conclusion or opinion would be inadmissible hearsay. If the conclusion or opinion of the non-testifying expert is testimonial, because a reasonable expert would anticipate that their findings would be available for use at trial, its opinion would also violate the defendant's right of confrontation because the opinion of the second expert would not be subject to cross-examination. So this comes up with DNA stuff. It has come up repeatedly in the cases. I pointed this out back when we had the original motion in limine about Carl Miyazaki, and he's going to testify as a substitute witness. All the way back in, I want to say, was it 2010? Bullcoming was decided. Bullcoming versus New Mexico. What year was that? 2011. Sorry, my bad. 2011. And dealing exactly with this issue, that if you don't have the person who did the testing at trial to be confronted about it, you're not getting a right of confrontation. You're not getting a right of confrontation if you don't get to ask the person who actually did the testing and the analysis and reached the opinions about their basis for it. If you just have some mouthpiece who doesn't have personal knowledge of any of that to just come in and you know, vocalize this this ghost tester, then you haven't been able to confront that witness. And it was just like last year or the year before that the US Supreme Court revisited it again, and they continue to say, no, you don't get to bring in an expert to testify about the results of testing of another DNA expert. You don't get to just substitute experts like that. It's a confrontation problem. So you don't, Hank, you don't get to go bring in defenses on notice that there's dog DNA on the sweater. That is not actually in evidence. It is not in evidence. And they don't have to concede that because you haven't proved it. If you want to use that fact, it's your burden to get Terry Kuhn over here as a witness to testify so that that fact is in evidence. You just take that fact for granted and try to bring it in through your cross-examination through another expert. Then Karen is not getting to confront the expert who conducted the original testing. That's the problem. That's the problem here. And so, you know, me, I am absolutely screaming confrontation over and over and over again. If I'm in court faced with this particular problem, it isn't just a foundational problem. He's right that the foundation is at issue, but it's not just a foundational problem. It is a testimonial hearsay problem. That's why the foundation is a problem. So it's just one of these things that I think when you're a criminal defense lawyer, it's what you do. You're used to focusing on certain things like testimonial hearsay. For me, it's like a knee-jerk reaction, okay? There's that joke, if you fall asleep in trial and, as soon as you wake up, very first thing you should do is objection. Anytime you hear the words, they said, or I heard, or anything like that, instantly I'm objecting to hearsay. These are kind of common sayings or ideas that are out there about legal practice. You instantly take it the next step. When you're in criminal defense, testimonial. Okay. Is it testimonial hearsay or not? And there's no question that Terry Kuhn's testimony is testimonial hearsay. She was hired by the Commonwealth for the purpose of conducting testing to prosecute Karen Reed with a crime. It is absolutely without any ground for dispute on this going to fall within the realm of testimonial evidence. So that's the problem. And it wasn't said. It wasn't said. So that's disappointing. Of course, Judge Cannoni is not going to grant a mistrial. Certainly not with prejudice. With prejudice is appropriate when you have prosecutorial misconduct that has essentially goaded the defense in needing to ask for a mistrial. They don't get to poison the well and then get a second bite at the apple. So if the prosecutorial misconduct has necessitated a mistrial, then it needs to be with prejudice. We know she's not going to do that. She's not going to declare a mistrial here. The only question at all is whether she's going to allow this particular line of questioning to continue. As we sit here right now, I'm not sure they preserved a confrontation clause objection. So if Bev is being, real crafty, thinking about it, she would know, hey, confrontation isn't necessarily a bar that they have preserved to being able to consider it. It is an actual bar. It is a reason why that should not come in, and it shouldn't be admissible. But if the defense hasn't raised it, then they've got the limited ability to come back later on appeal and say that was a mistake that I made because they didn't preserve it. It's constitutional magnitude. Sometimes that gives you a little bit more leeway to raise things. But yeah, if I'm Bev back there being crafty, hey, they didn't raise the confrontation issue, so do I have to consider it? Well, if you were a good judge with integrity, concerned about doing the right thing, of course you would. You would realize that whether they've said it or not, this is a confrontation problem and it shouldn't be allowed. But is that what Bev's going to do? Yeah, color me skeptical, guys. Color me skeptical. But she needed some time, needed a half hour or so. Go think about how she's going to justify what it is she wants to do. Well, with that, what have you guys been thinking about all this? How's this hitting you? New Orleans lady. If you can be the lead defense attorney on any high profile case, past or present, which case would you choose and why? Oh boy, any high profile case, past or present? Man. Which one? I mean, there's so many different reasons, you know, why you'd want to be defense lawyer on different cases. On the one hand, you know, the answer is, well, something that's a winnable case, you know, because of course every lawyer likes to win, you know. So look at what kind of material you have to work with. Richard Jewell, be a good example. Winnable case. Not that, you know, it ever got to the point of trial. O.J. Simpson, you know, winnable case. Maybe on its face shouldn't have been, but with all they had to work with, Furman, the tainted blood, all that stuff, definitely gave them some material. Don't often have material like that to work with as the defense. So, I mean, I think there's easy answers like that, cases just that are winnable on the facts. You know, the other side of it is from the public defender standpoint. You're there to represent the worst of the worst and make sure that they get treated fairly. Even if they did do it, that doesn't mean that we bring out the torches and the pitchfork. We have a system. We do things the right way. And so that's, you know, such a critical part of the job. And so when you're talking about something like that, you know, then you want to represent the Jeffrey Dahmers of the world, the Richard Ramirez's of the world. Not because you're going to get them off. Chances are pretty good you're not going to get them off. There's a massive amount of evidence against them. But to make sure that they are treated fairly along the way by the process, that they aren't just overrun by, you know, people like Hank who don't have any real respect or regard for the rules that are supposed to apply to this type of proceeding. So it's kind of a harder question to answer than, you know, you may have thought when you asked it. I mean, I do. I tend to err on the side of I would rather I think I would kind of represent the really, really bad guy to make sure that it's fair, even if I'm going to lose, because I'm not really invested in winning or losing. You know, if you're worried about losing cases, you don't become a public defender. It's just you know, you can't have a lot of ego in it. So that's the best answer I can give you on that one. Greg S. Cops like Deborah getting on the stand and swearing in front of a judge to tell the truth. Then without hesitation, they proceed to lie their asses off. I mean, she, you know, her testimony really speaks for itself. Her testimony really speaks for herself. Her demeanor just said so much. I think it said far more than anything substantive that came out of her mouth. Just very, very hostile, very defensive, very accusatory. And it just seems so out of line, so discordant with what she's being asked to do. You're just being asked to do what everybody else does, which is get on the stand, tell the truth. You did tell the FBI that. It's not a lie. Not a lie. Not trying to get you to lie to point out that you told the FBI that. Just because you've recanted it after the fact, nobody has to believe that. Recantations are disbelieved quite regularly. Quite regularly. Lucid Visionary Girl 88. The ME took the word of law enforcement when they said he was outside for hours. Otherwise, those W spots would have been due to his drinking ulcers. See his meds. Yeah, I mean, I think that's one possible explanation. You know, we'll lean as far as we can in favor of the Commonwealth theory, but with no point of impact, no motor vehicle injuries, having a hard time getting to, you know, all the way to the Commonwealth's theory that this is homicide. But okay, if we'll grant you he'd been outside for hours, then this could be early hypothermia. They don't necessarily have a lot of information about John's personal history. I guess before her final report, she would have known. Would have had his medical records and his med list and all that stuff too. So yeah, you know, the medication list, that does seem like a little bit of a giveaway. Shouldn't she know if she has jurisdiction to get his medical records? Shouldn't she know? She should have his history. She should have his medical history. And so shouldn't she know what the Pepcid was prescribed for? What was the initial complaint that led to him going to the doctor, that led to him being prescribed Pepcid? And is that something, was there any testing associated with that? I mean, I have to assume John's a Boston police officer. He's got good health insurance. So did he get some kind of testing so that they could, you know, diagnose something that would be treated by Pepcid? Surely that's all in the records. KH, prop notebooks. Andrea with the truth bombs. It's what it was. He goes up to the stand yesterday with these big fat notebooks. And he does it all the time. He likes to slam them around and move them and stick stuff on top of them. And then there's apparently nothing in them to use in his cross-examination of the witness. It's just kind of bizarre. You know, you're up there with 2 notebooks yesterday, but you didn't have your stuff ready. You had to come back to it. And we all know it's because you had to have like your assistant go and get the transcript last night. You weren't prepared. Karen Els, thanks Andrea for allowing Lana's TNT group watch you live. I really appreciate it. No problem. No problem. Josh H. Didn't Carrie Roberts testify she spoke with Brennan in between her days of testimony? Why is he so fixated on the topic today? Well, he thinks it's working. He thinks he's got him, and you know, you violated the sequestration order. But I don't see that you know, has been established. We went and looked at the rule. There's no written order, as far as I know, no written order saying they can't talk about the manner, the procedure of testimony. It's just, you know, of giving testimony. It just says you can't talk about other witnesses' testimony. So I don't see that being a violation. But Hank doesn't require facts and evidence to be able to to go in and make his arguments or make his points. He'll just assume it in his question. Given that that's a violation of the sequestration order, didn't that cross your mind? No, because it isn't. Those are questions too. If I'm sitting at the defense table, I'm absolutely objecting to that. It's assuming stuff not in evidence. Alyssa Ramirez, Hank is really out here LARPing as Alessi, prop binders, apologizing, and now attacking the methodology. So sad. Well, he doesn't have the gear that Alessi does, that's for sure. As far as talking to the experts on their own level. And that's why he keeps getting schooled on substantive stuff. It's why the only thing that's really working for him is to try these underhanded kinds of things. Suggesting, saying that there's opinions that have changed, but now when it comes to put up or shut up time, he has nothing to put up. He hasn't demonstrated anything here that I can see that's a change in the community. He's had no aha, ooh, that changed. She's like consistently said teeth or claws. Can't be 100% certain. Continues to agree with that today. So, animal, possibly a large dog. Not really inconsistent. But to the extent that there is more certainty there, she's explained. Reviewed the case an awful lot more now. Looked at it a few times. Come here on multiple occasions, been asked a lot of questions about it. But when it comes to the methodology, he's getting his ass handed to him, because that's when she's able to keep coming out and pointing out things like there's no way that a taillight would have caused this pattern of injuries. There's no medical evidence that he ever had an impact from a motor vehicle. So, he can try, but he just doesn't have the skills. He doesn't have the he can't hang with the experts the way that Alessi can. So that's why he's got to try this underhanded stuff and the facts not in evidence and the, loading up his question. You violated no. If in fact she had violated the sequestration order, perfectly well, we would have been here before the jury got in and you'd be asking for her to be stricken and removed as a witness. But you didn't do any of that because perfectly well she didn't. You just want to be able to make a show, a little puppet show in front of the jury, a little shadow puppet show. You didn't behave as if you think that's what happened. Sabina D, bit behind. Hank Brennan saying she can't say for sure these are dog bites because there is no methodology. Then how can he bring a witness to say the opposite? Yeah, if there's no methodology, how do you say they aren't dog bites? I don't know. We didn't get the many, many days of voir dire of Dr. Crosby that we got of Dr. Russell. So we don't really know exactly what Dr. Crosby's opinion is or what it's based on or how he got there or what methodology he used. So this remains to be seen. How exactly how hypocritical is this position that Hank's taking? Sin, how do we explain the red plastic found in John O'Keefe clothing? It's the only thing that stands out to me from Commonwealth perspective. Otherwise, they got nothing. Yeah, I got an explanation. The clothing has been in the unsecured possession of Yuri Buchanek and Michael Proctor for days and days and days. And we also have a Sally port with the car in it where taillight pieces are being, removed from that taillight and then, busted up and scattered out at the scene. So if we're willing to entertain that there was a frame job like that involving, taillight being busted out and planted at the scene, then I don't have a hard time entertaining the possibility that the same guys involved in that unsecured evidence who also had the unsecured evidence of the clothing wouldn't just use John's sweatshirt as a rag to wipe up the floor, pick up the pieces, something like that. None of that would surprise me. I think if you're willing to entertain that law enforcement engaged in some frame job stuff here, then there's, why would you limit what they would be willing to do or not do? The problem is all of this was unsecured. All they had to do was book this stuff into evidence when they got it in the timely fashion. And you wouldn't have to ask any of these questions. then how did the taillight get in John's clothing would be a good question. Then maybe we would have to focus more on, well, she just said it was consistent with the taillight. She says it came from that or from some similar source. So could there be other sources of that plastic? Maybe. I don't know. Maybe we'd have to focus more on that if, in fact, there was a proper chain of custody and securing of John's clothing and this plastic was still on it under those circumstances. But we'll never know because that's the counterfactual situation that we don't have in order to deal with. English Kate, could we not have had this many questions about taillight forensics? The contrast is startling. Well, I mean, he is a badgering type of lawyer, and to some extent it does work. You know, you keep the people on the stand long enough, they get tired. You might start to get just some wins kind of by attrition more than by merit. We kind of saw a little of that with Yuri, right? After going on to his third day on the stand, which I don't think he had anticipated. He's getting tired. He's getting tired after all this. So he stops being so resistant. He stops being so difficult. He stops fighting so much. You just go ahead and, go along with the stuff that he has to say that, is reasonably substantiated, supported by the record, whatever. Like you can't put all that energy into nitpicking stuff that maybe isn't that nitpick worthy. So he could just be going for something like that too. Get her tired. We're just asking a ton of questions here, not because they matter, but because we're just kind of trying to get her tired and then see where she would go after that. Aaron White, Hank is purposefully conflating his focus on Taken individually with Taken as a whole. Shameful. I have to say, I don't necessarily... more thoroughly.
All right, so the motion for mistrial is denied. Your rights are saved. And Mr. Brennan, you can continue with this line of questioning.
No, I did not address sidebar, the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation. So if you can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Could you do that outside the presence of the jury so that I don't ask the questions in front of the jury?
No?
Yes, but not right now. They're on their way. All right. Do you have
I'll work around it.
Okay.
When do you get to do your questioning?
Outside the jury, that it should be done like I've had to do with several witnesses in front of the jury.
Okay.
Yeah.
If that's what the defense wants, are you sure, Mr. Alessi?
Oh, wait, I'm sorry, let me confirm with my... Yeah, okay. I am going to, yes, Your Honor, we are going to...
Oh, dear.
Thank you, Your Honor.
Okay.
Do it as a voir dire.
They're on the way, Your Honor.
Thank you.
I'll be done very quickly, so I'll have to make that decision.
Is the
So
lunch is
Barbosa,
here?
that we just read should be written in a document, placed in the court
Are they
file
still
under her nose,
over there?
revisit. But confrontation wasn't argued here.
I don't know how far along they are.
Did you start yet, or can you turn?
If they're downstairs on their way up, I don't want to stop them.
I can do it in 2 questions.
Yeah, please.
Oh. Excuse me?
They're still over this way.
Great. Okay, they're going to stay.
Your Honor, if it might help, obviously we're subject to whatever, because based upon if Mr. Brennan only has 2 questions, I may have 30 minutes that I could, most 35 to finish up whatever redirect that I have, if that affects your Honor's scheduling.
I just didn't want to stop them if they were on their way. They haven't yet gone downstairs.
No, I don't think they made it downstairs.
All right, we'll do this now.
Be quick.
Okay?
Dr. Russell, during your review of the case, did the defense offer you the report of John C. Walsh, MD, Deputy Medical Examiner?
I didn't hear the whole
I'm sorry.
question.
During your review, the defense provided you materials. Did they provide you the report of John C. Walsh, MD, Deputy Medical Examiner?
I don't recall.
May I approach?
May I-
Yes. Can we turn the fan off over here, Tony, please? Thank you.
Dr. Russell, did you ever review or receive that document from the defense?
Flame one, I actually agree with this, but Hank
yes.
needs to commit
And
that
regarding
he's going to
Dr.
call
Walsh's
jury
opinion,
Kuhn in rebuttal.
Did you consider that when
You never did that.
formed your ultimate basis that the wounds on Mr. O'Keefe's arm were consistent with the dog bite?
Yes.
Did you disregard it or agree with it?
I disregard. I disagree with his assessment.
Thank you. Yeah. Sorry, I'd like to inquire.
Your Honor, I would object. This is the same exact issue I had here with Re-cross, where witnesses disregarded it, and I was not allowed to pursue questioning. So
Good
I
point.
do not believe, under the standards that's been set in this trial, that a proper foundation has been set.
What do you say about that, Mr. Brennan? How is this any different?
Pardon me?
I'm talking to Mr. Brennan. How is this different with this witness's analysis?
Because they specifically opened the door when they had her vouch for her own credibility, extolling her uniqueness and ability to determine that these were dog bite wounds. And so when they opened their own door to vouch for their own credibility and suggested that they're the only person or a limited person in the entire country that could do this, they should be confronted that they are not alone. There are other experts. And so this isn't affirmatively bringing it in. This is when the defense continually opens the door and creates these issues.
What do you say, Mr. Alessi?
Thank you, Your Honor. My response is this. I'll give two quick examples. Dr. Welcher, Trooper Paul, Dr. Scordy-Bello. They talked and opened the door under Mr. Brennan's theory of opening the door widely. They even had, as part of their direct examination, documents in Dr. Welcher's slide that mentioned Dr. Scordy-Bello. You'll recall that slide. They even had material from the CARS team with a file named Trooper Ball.
I'm not letting it in.
Thank you.
All right, I'm not letting it in under that, Mr. Brennan. So you can mark the report if you want, but for that reason, I'm not, for the reasons stated by the Commonwealth, I'm not letting it in.
I don't need to mark it.
Okay. All
The
right,
reasons
bring-
stated by
thank
the
you, Hunter.
Commonwealth, you can't even bring yourself to say it for the reasons stated by the defense. The reasons were stated by the defense, Bev. You rolled for the defense. Not letting it in. Oh, she's very attuned to that double standard. There's a way she's already said it. Well, gonna stick with that. And yes, she absolutely did. That was the whole
Objection.
point. Of
Where
not
are
being
we?
able to.
Is it in evidence now?
It's not yet. It will be.
Okay.
Your Honor, just say it in evidence.
The DNA. It's not, right?
It is not. And
Okay.
is there any question? Yeah.
Yes, it's open. I denied the motion and allowed the line of inquiry.
It's funny because I came across the Barbosa case when I was looking at Dr. Welcher's testimony, because I was looking at the basis the basis for it, and the whole problem with Welcher's testimony, of course, is that his ultimate opinion, this was a car accident, is not based on anything scientific that he did. He even says it explicitly. It's a taillight, the totality of the evidence, the statements of the witnesses and things like that. But that's literally the jury's function, to take all that and to decide if there was an accident or not. That has nothing to do with the engineering type of problem that he was presented and asked to solve. His own testimony seems to be that from an engineering standpoint, you can't reach an answer because there's too many variables and they just don't have enough information, and so on and so forth. So he didn't actually have an expert opinion about anything. But just, based on all this other stuff that has nothing to do with engineering. That's why I think that there's a car accident here. So yeah, it's not in evidence. I think you have a problem with, you still have a confrontation problem if they put it in after. You typically have to have a prior opportunity.
Jurors, I appreciate your
cross-examine.
patience. All right, Mr. Brennan.
Thank you. Good afternoon, Dr. Russell.
Good afternoon.
Dr. Russell, we were talking about your differential diagnosis and your opinion that Mr. O'Keefe's abrasions on his arm were not consistent with impact or collision with a car. I was asking you specifically about some of the things you may or may not have reviewed before you formed your opinion. You looked on direct examination at a photograph in Dr. Welcher's presentation, and it had a photograph of a person who had been hit and died as a result of a collision. Do you remember that photograph you looked at?
The photograph of which one specifically?
There was a gentleman
I've
lying
seen.
on the ground. His face was redacted, and there was
Oh,
some
that one. Yes.
Remember that one?
Yes.
And when you discussed that, what was the reason? What was your point in discussing that?
I was answering questions.
Do you know what the point was? What you were trying to deduce or?
No, I was
suggest?
just answering questions.
Okay. You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with the car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over. There's a difference, right?
In general, yes.
When you talk about the absence of lower body breaks, do you have any studies about the frequency or the likelihood of lower body breaks in a clipping impact as opposed to being directly run over?
No.
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body breaks?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide that there were no lower body breaks?
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and showed the height and the location when
Watch
it
the smart
touched?
video.
Alexis, did you see that?
Objection, Your Honor.
I'm going to allow that.
Yes, I saw that image.
Did you consider what's called the text stream data? Do you know what text stream data is?
What?
Text stream, the black box that shows the operation of a car, how fast, how slow, acceleration. Did you look at any of that information before you formed your opinion?
I looked at it, but I honestly did not understand it.
Did you ask anybody to help you interpret that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or different or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that information about the text stream data and the information that was available regarding this allegation? Did you want to understand that before you came back and offered the same opinion you had before that information was available?
I didn't. Well, I didn't understand it. And I didn't know that if any of the attorneys understood it actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the collision or impact as the cause of those wounds?
Well, I considered that. However, he had. My understanding is he had been in and out of that car, on many occasions, and so therefore there would be reason for either skin cells or DNA or possibly other, hair, fabric to be on that car.
So when you consider testing your conclusions, do you look at it as an advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate? You're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, can we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve, yes.
Having an interest in dogs and dog bites, certainly you're aware in your experience when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
It can actually, a dog can froth, is what they call it. Excessive saliva when it's in the moment.
Some dogs, yes.
And some dogs, they can shed hair, especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items sometimes like DNA, correct?
Yes.
And that's considered oftentimes very important trace evidence.
Yes.
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Objection, Your Honor.
No, are you aware of that?
Yes.
You've heard of UC Davis, haven't you?
Yes. And in reference to that previous question, however, the swabbing was done many weeks after the death, and there were images of clothing on the emergency room floor. So, yes, I am aware that there were some swabs taken at some
Also
point.
sopping wet.
Is that gratuitous answer part of your advocacy or part of your medical objective opinion?
Objection, Your Honor.
And so you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes.
UC Davis, do you understand they specialize in dog DNA?
animal DNA, I believe.
And you also know, and giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes.
In fact, what was found was pig DNA,
That's correct.
and there's no identification where the pig DNA came from, is there?
I don't
Clearly
think so.
it came from the taillight, Hank.
So when you saw the information, after you claimed there is a dog for John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes.
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
Yes.
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons, didn't you?
Objection, Your Honor.
So the objection sustained. Can I ask you
Yes.
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree of certainty?
It would be best to go through a process to determine, or at least come up with a list of reasons as to why dog DNA was not found. There are a number of reasons. You know, if you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA, yes?
Yes.
You can't tell us anything based in fact. Wait,
No.
I'm sorry.
Oh, sorry.
You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have
Wasn't
to
there
go through a
interference?
process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialize, then you wonder why, and you want to know, was the test done correctly, you know, was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after the incident. So there was a delay in processing or swabbing to begin with. And then, of course, I don't know about the transportation or the chain of custody.
You were a medical examiner, weren't you?
Yes.
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
Yes.
Did you know at the time Dr. Scotabello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
Yes.
Did you know that claim didn't come about until over a year later?
No.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even where there was absolutely no claim or evidence whatsoever that a dog caused these wounds?
Well, again, a complete investigation.
You can't tell us one step that went wrong. with that DNA process, can you?
The process, no.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
Correct.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle?
Objection, Your Honor.
I'm going to elaborate.
Not in evidence.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please? Dr. Russell, this is a photograph.
Can we approach on this, please?
Okay.
She didn't know that, so she didn't rely on it. So under the same standard, we don't get to question her about it, right? That's the standard that you set with Dr. Welcher. She didn't consider it, then we don't cross on it. Was that gratuitous answer part of your advocacy? I don't know, Mr. Brennan. Is that ridiculous question the best you can do in lieu of having a case? To me, the biggest problem with this swabbing the sweatshirt is that the clothes were sopping wet. The clothes were sopping wet, was the testimony. John's been out in the snow. They've been sopping wet. They've been thrown on the ambulance, thrown on the hospital floor. I don't know why we'd expect dog DNA to still be present on the clothing. It's been sopping wet.
Dr. Russell, were you aware that very small fragments, shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt?
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr. O'Keefe's arm abrasions were not caused by a collision or an impact?
After.
And when you learned that, did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And would you agree that broken plastic, like broken glass, can tear fabric?
Yes.
would you agree that broken plastic, like broken glass, can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
Yes.
Would you agree that if fragments like this were randomly in the sweatshirt, that it could cause cuts or abrasions to Mr. O'Keefe's arm?
I don't believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
Do you know how Mr. O'Keefe fell to the ground and what movements his body and arm made as he fell to the ground?
Not definitely.
No, that's your job to
You
prove,
don't know?
Hank.
How? No.
Do you know how much distance or little distance he moved when he was on the ground?
Yes, approximately, I think it was 20 feet. I initially heard 60, but around 20 feet, I believe.
Do you think, do you know where his body was found on the side of the road?
Yes.
Do you know if his body, before it rested, moved or slid on the ground?
Yes, it did.
And it's your opinion that fragments like this could not have caused the superficial abrasions to John O'Keefe's arm?
You know, in reference to that last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after the collision.
I wasn't asking about the collision, I was asking about his body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused the superficial abrasions on John O'Keefe's right arm?
They can cause superficial abrasions, but not in that pattern that we saw on the arm.
I'm going to ask you the question again. Are you saying to
You
a
answered
reasonable
it.
degree of medical certainty that these fragments did not cause the superficial abrasions to John O'Keefe's right arm?
Correct.
I have no further questions.
Okay. Mr. Alessi?
Thank you, Your Honor.
Okay.
I don't think Hank thought he was going to get that answer, but yeah, she's willing to say to a reasonable degree of medical certainty, the taillight pieces did not cause the abrasions. I guess he thought she was going to waffle on that.
Thank you, Your Honor.
Okay.
May I, Your Honor?
Yes.
Thank you. Your Honor, I would like to have published what is in evidence is 201A, and then I'm going to proceed after that with 201E.
Okay.
Dr. Russell, I have up this exhibit, and with regard to the questions of Attorney Brennan that he just asked about these alleged shards, can you tell the size of them from this depiction?
I don't even see any shards in that depiction.
Can you read that slide and see the handwriting that is there?
Yeah, it looks like clear plastic collected from 7/18/18. There's another date over to the left side, and then it says AMV 6/29/23.
Right. And if Mr. Wolk, you could go back. Can you determine at all from this whether the shards are microscopic or not?
I cannot see any shards.
All right, let's go to 201E. With regard to this depiction, do you recognize what is in this depiction?
It looks like irregular, red-colored pieces of debris.
Thank you. And do you recognize the
little hair on
ruler
them?
above those pieces?
I'm not sure if this is the same ruler as in the previous image, but there does appear to be a ruler.
If we could go back to the previous slide, does that at all assist you in determining whether or not it's the same ruler?
Not exactly, but there are similarities.
So let's go back to, flip back to the next slide.
And if
Does
we assume it's a ruler.
what is up in black help you reach any conclusion about whether those pieces are microscopic in size or not?
Well, so those are, again, I'd like to go back, but I think those might be 16th or 32nd of an inch if we're using the same edge of the ruler. Those pieces that are depicted are not microscopic because we can see them with our eyes, but they're extremely small.
All right, so they're extremely small. You've asked, you want to go look back at the ruler. Does that further assist you in your analysis as to the size of these pieces?
16. So those looks like they're maybe a 16th of an inch or less.
Okay, so let's go back, Mr. Wolk, one more time. So these pieces are a 16th of an inch or less, correct?
Yes, if we're using the same ruler.
Right. So with regard to, and if we could, Mr. Wolk, now go to Exhibit 1.
Brennan was
Attorney
all
Brennan
over
asked
with
you several questions
what caused
with
the
regard to
scratches.
whether those 16th of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would like you to answer whether those pieces, a 16-inch or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern.
I don't believe so.
And with regard to that answer, how do you come to that conclusion? What is your thought process?
Okay, again, there are multiple parallel abrasions. So these pieces would need to be lined up in a certain configuration to cause those abrasions, and they'd have to be oriented in nearly the same direction because many of these groupings of wounds, and if I may use the pointer, are oriented in this direction a little bit, well, anatomically a little inferior to superior, ever so slightly this way. So they're oriented in the same way. So not only would they, those abrasions are rather large for those tiny pieces of plastic or glass, but they'd have to be oriented in a certain way to cause those wounds.
As an emergency department physician, as a forensic pathologist, what is the likelihood, if any, that those shards could cause those wounds?
You have to ask it differently, Mr. Wilson.
Dr. Russell, please state your evaluation and conclusion and the basis for it as to whether those shards of glass, or excuse me, shards of plastic, 1/16 of an inch and less, can cause those abrasions on and wounds on the right arm of Mr. O'Keefe.
I do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
Not at all.
You were asked several questions by, please keep that depiction up, Mr. Wolf. You were asked numerous questions by Attorney Brennan where he wanted you to go section by section by section and evaluate each. He grouped these, I think, 5 or 6. Do you recall that questioning?
Yes.
Is that a scientifically proper way to evaluate this wound to determine whether or not it is from a dog? Is that a proper methodology to look at each individual section only?
No.
How, at a scale, is it improper to evaluate them that way under your methodology?
Objection.
Sustained.
Dr. Russell, what is the proper way to evaluate the wounds on the right arm to determine whether or not they're caused from a dog?
To look at patterns, because individual wounds can vary, but the pattern is what is significant.
And
I like that answer.
on your direct examination, did you go through this method that you just described, a pattern and pattern recognition? Did you go through that in some detail and discuss that?
Yes.
Now, you were asked questions by Attorney Brennan, and in his questions, it was asserted that you don't have a standard, a published standard. Do you recall that questioning?
I'm going to allow it.
Do you recall the question asking whether you had a standard to reference for your
In the dog bite
methodology? You recall that questioning?
In reference to dog bite wounds, yes.
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 And with regard to the question and assertion in the question with regard to a methodology, you referenced
Your methodology for tail light plastic injuries?
and as part of your answer, do you recall that discussion with Mr. Brennan?
Yes.
Do those, and are those studies peer reviewed?
Yes.
And give the name, please, again, that we had gone over on direct, but give the name of the lead authors of each of those studies.
Yes. So one of them was by Dr. Munnynck, and the other one was Dr. Pollock. And by peer review, that means that the article was reviewed by other physicians in those respective specialties of the authors.
I'm sorry to interrupt you, Dr. Russell.
I'm
you
sorry.
finished?
The specialties of the authors, yes.
We could take that down for a moment. Your Honor, may I approach, please?
Okay.
If I could have, Your Honor, from Madam Court Reporter, exhibits marked for identification PPP and QQQ.
Right.
And I'll start with PPP if I could, please. Thank you, Madam Court Reporter. May I present PPP to the, thank you, Your Honor. Dr. Russell, you have before you PPP. Is that the study with the lead author, Dr. Munnynck?
Yes.
Do you recall Attorney Brennan in his questioning asserting that you had no basis and there was no support for your methodology of pattern recognition. Do you recall that discussion?
Objection.
Sustained in that form.
Do you recall questioning on the cross-examination by Attorney Brennan as to your basis for a methodology in terms of pattern recognition with regard to dog wounds? Do you recall that?
Yes.
Can you please take a look at Exhibit PPP for identification and identify whether there's any section in that study that talks about and documents the methodology that you used in that study?
Yes. So this is an article that was published in the International Journal of Legal Medicine, and it is entitled Forensic Approach of Fatal Dog Attacks, a Case Report and a Literature Review. And so it's several pages long, talks about a specific case, and then on page 298, there are some significant passages that I would like to read, actually. So it says here, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower. Usually the mandibular dental arch is narrower and shorter than the maxilla, and that means upper, lower and upper. Maxilla is the upper. Maxilla, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed. The canine masseter pterygoid complex is short and strong, and its insertion on the mandible provides powerful mechanical advantage. So that's talking about the muscles, how powerful they are. And then goes on to measure the forces.
If you could find the location, if there's any in there with regard to pattern, is there any discussion about attributes and patterns in that study?
Yes, this next paragraph. The above features attribute to the characteristics of dog bites. The maxillary teeth distal to the mandibular teeth allow the so-called scissor bite in which the dog can lock onto his prey. The tremendous force of the bite muscle complex can develop, allows the dog to twist and tear, and cause great damage. The injuries caused involve a combination of biting, crushing, tearing that results in characteristic patterns of punctures, lacerations, avulsions of the skin and soft tissue. Forensic pathologists noted the multiple torn wounds with adjacent puncture wounds, the so-called hole and tear combination. That's in this case. The puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretching lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to one another, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis with bites of other animals, which are not accompanied by pulling and shaking, nor by the usage of prominent canine, and with stab wounds caused by sharp instruments.
Does that study support or not support in the literature a pattern recognition methodology?
Objection.
That's sustained.
What do you conclude from the language you just read in that study with regard to methodology of discerning dog bite wounds?
that pattern recognition is very important.
Now what I would like, if I could approach Your Honor.
Okay.
Hank's gonna get up and be like, "There's no puncture wound here, though. There's no puncture wound." Is this
If I
part of
could
your
return this to
advocacy?
Madam Court Reporter and please request Exhibit QQQ for identification. Thank you, Madam Court Reporter. May I hand it to the witness?
Yes.
Thank you, Your Honor. I've now handed you what is marked for identification as Exhibit QQQ. I would ask, please, that you, is that the Pollock study that you referenced in your direct and in your cross-examination?
Yes.
Could you please, as you did with the Munnynck study, can you please articulate the relevant, just the relevant sections with regard to your reliance upon that study?
Yes, so this is an article from the Institute of Forensic Medicine at the University of Vienna.
Is that a peer-reviewed study?
Yes.
Please continue.
Excuse me?
Please continue.
Okay. The title of the article is Fatal Dog Bite Injuries. And there's a summary. It says the dog's front teeth. So let me preface this. This was talking about a deceased child, and they describe the features. It says the dog's front teeth left marks of individual circular or scratch-like abrasions, as well as slit-like skin severances. Slit-like skin severances of the skin, arranged in curved lines. The pattern of the skin lesions largely corresponded to the anatomy of the dog's set of teeth. No tissue defects could be detected.
And is there any other section of that study that references pattern and pattern recognition methodology? Any other
Yes.
words, any other section? And if so, could you please read them?
Yes. So on page 491, there's a section called the Morphology of Dog Bite Injuries.
What does morphology mean?
It means the shape. And so it goes on to say the anatomy of a dog's teeth is the key to interpreting injury findings. The particularly long, cone-shaped, pointed canine teeth often create sharp-edged wound slits that can be mistaken for stab wounds. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors leave an impression, smaller skin lesions, parentheses, round pressure marks or streaky glide marks, can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors will act uniformly.
I'm sorry, I didn't hear that sentence. Could you repeat that?
In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly.
Is that sentence relevant at all to what you've referenced as an incomplete bite?
Yes.
How is it relevant?
Because if not all the teeth impact, then you get a partial bite. You know, you get irregular appearances. There's another sentence that's important here. A gap in the injury pattern can have several causes. Oblique biting, so what that means is not dead center on, but off to the side a little bit. Oblique biting. Curvature of the body surface, which we could have in this case around the arm, the edges of the arm.
Mr. Wu, can you please put Exhibit 1 back on the case? And Dr. Russell, would be helpful as you're discussing these items if you could determine whether or not what's discussed in that study is at all depicted in this exhibit.
Okay. So we discussed oblique biting, which is off at an angle. Curvature of the body surface. So here we have a body surface that's actually quite irregular. There's curvature down here. There's definitely curvature around the elbow, And so there's curvature around the bones. So curvature of the body surface can change the appearance of the wounds. Interposition of textiles, so that would be clothing.
Is there an example of interposition of textiles in this case?
I don't think so.
Well, was the decedent in this case wearing any, is textiles mean clothing?
Yes, and I thought you meant in this article. But yes, there was textiles in this case. Mr. O'Keefe was wearing that hoodie sweatshirt or sweater shirt. So interposition of textiles. And then it goes on to mention some other things which I don't think apply in this case, such as different tooth lengths, tooth loss, abnormal teeth.
And is there any other aspects of that study that are relevant to your analysis and methodology with regard to evaluating the wounds in Exhibit 1?
You know, a lot of this article is relevant, and I don't know if you want to keep.
I want to keep reading it, but if there is a section, because then I'm going to have a few more questions once you're done identifying the most relevant sections of the article.
Yeah, this. And then there's one section that said.
Thank you.
Yes, thank you. Then it does mention that in some victims, parallel scratch marks originating from clawed paws are found accompanying the injuries.
And is there any other section that you believe supports your evaluation of the wounds on Exhibit 1?
No, I think that's it.
All right, so thank you, Your Honor. May I approach?
Yes.
Thank you, Dr. Russell. Madam Court Reporter. So do those studies, the Munnynck and the Pollock that you just referenced, do they support the methodology of pattern recognition that you applied in evaluating Exhibit 1?
Absolutely.
And do they directly or indirectly support that methodology?
Directly.
And is that medical literature peer-reviewed support or not for your pattern recognition methodology?
Yes. So as to the form, Mr. Alessi.
Do those studies, each of them, those peer-reviewed studies, support your pattern recognition methodology that you applied with regard to Exhibit 1?
Yes.
Did those studies look solely at individual wounds, or did those studies' methodology look at the overall pattern to evaluate and discuss wounds from dogs?
Objection.
Ask it differently.
How did those studies evaluate wounds with respect to individual wounds and overall wounds? How did the study evaluate those?
They described some individual wounds. There were numerous wounds. Described some individuals, but they looked at the overall pattern to make recommendations.
Was the pattern, overall pattern in those studies important or unimportant in the analyses and conclusions that those authors reached?
Important.
Now let's switch topics. Attorney Brennan asked you about various considerations you made with regard to differential diagnosis. Do you recall those?
Yes.
Let's just start with your differential diagnosis methodology. you describe whether or not you took into consideration additional information that was presented to you in determining whether your initial hypotheses was correct or not. Describe just generally that process and whether or not you took new information and retested your hypotheses. Describe that process that you undertook just generally.
So in general, when a physician is presented with a set of circumstances or wounds or symptoms or whatever, they come up with a possible diagnosis, but have to consider other diagnoses as well. That's what a good physician does. They consider what they think is the most likely, and then they go through a process of eliminating the or including and the other possibilities. Would you like me to give an example, like chest pain or
Well, I'd like to
pain?
give you an example of what you used here in this
Yeah,
case as
okay.
the application of that.
Well, okay, so I'm just describing the overall process because if you came to a diagnosis and narrowed in on it and never considered any other information, sometimes your diagnosis is going to be wrong, and so you have to allow for other information, and so I did that in this case. I examined the circumstances, examined the wounds photographically, and came up with my impression, but I also considered other possibilities. What else could cause those scratches or those abrasions?
And did you honestly and scientifically consider those other possibilities as you continue to review the information, old and new information in this matter?
Yes.
And did that process allow you to avoid confirmation bias?
Yeah. Yes.
So in terms of that process, now let's go through some of the items that Attorney Brennan discussed with you. He asked you several questions, one of which, did you evaluate news clips and audio clips? You remember that questioning?
I remember a question about some news clips.
And did you recall your discussion with Attorney Brennan about acute grief reaction? You remember that discussion?
Yes.
Now, in terms of acute grief reaction, you talked about it, and do you recall discussing that sometimes people who have a traumatic event, that acute grief reaction occurs? You recall that discussion with Attorney Brennan?
Yes.
Now, do you recall also mentioning that sometimes these patients engage in self-blame?
Yes.
And my question, among others, is when they go to self-blame, from your experience as emergency room physician, seeing patients with this, as you discussed with Mr. Brennan, are there instances when patients blame themselves for something when they're not to blame?
Sustained.
Can you discuss what you meant by self-blame in acute grief reaction?
Sustained.
Your Honor, may we approach?
Okay.
Why do we not get to ask questions about the acute grief reaction that was elicited on cross? What exactly is the problem here? Part of why I'd like to see the defense being more aggressive with their objections is just, again, to hold Bev's feet to the fire as far as the standard that you're going to apply. If you're going to, be super critical of the form of Mr. Alessi's question when he's not asking a leading question, but apparently it's like just not quite good enough for you for some reason, then again, you need to hold the same standard to Mr. Brennan. If you're going to consider Mr. Alessi's formulation to be argumentative, then I don't even know what the hell you think Mr. Brennan is doing over here. It's one of the reasons I'd like to see them object more is to put her on the spot to show that you're applying the rules that you're coming up with here even-handedly. It's not fixing the problem of some basic things, you know, being overlooked here. Major confrontation problem, you know, just kind of is out there. But at least it gives you some consistency. You know, I may not like where the umpire is calling the particular strike zone. Maybe he's calling it particularly large. He's calling, you know, a bunch of strikes that are way outside the outside. But if he's calling it for both teams, you can't really complain because at least they're getting the same standard to work with. Problem, of course, is when it's a massive strike zone for this team and a tiny strike zone for the other team. That's why I'd like to see more objections so that we have more to work with here. We have a better picture of what is the pattern of what Bev is doing in response to these objections. I mean, we can have the anecdotal, heard a lot of I'll allow it with Mr. Brennan, and now all of a sudden sustained. And since we don't get any explanation for it, we don't know what her thinking is. We don't know what her rationale is. But I think part of that is just because what's triggering the objection from the defense tends to be something different than what's triggering the objection from the Commonwealth. The defense is not objecting on a lot of occasions when there are bad questions, formally, assuming facts not in evidence, argumentative, etc. They're just kind of letting that go. And I personally would like to see a little bit more pushback on that, if that's what the Commonwealth is going to be doing here. I did see we finally did get the pleadings. We got the motion for reconsideration of Michael Easter. We got the defendant's proposed jury instructions. And we got the motion for the missing witness argument. So we'll have those to be able to take a look at when we break for the day. Or maybe, you know, come back for lunch or something like that. They are fairly long, so there will be quite a bit to go through. Don't know why we have to have such a long sidebar chat about acute grief reaction questions. Hank brought in the interviews, you know. So the defense gets to ask questions about the interviews now. Guys, you may have noticed this is just a little observation I have that I'll share with you in case it's helpful. But you may have noticed that when Hank is questioning, you have a reaction to it. You don't like it. It's annoying. It makes you angry. It makes you frustrated. It makes you infuriated. Why does he load things up like this? Why is he so rude to this particular person? Why does he assume all of these things that haven't been proven? Why is he allowed to do all of this? Guys, I just want to submit to you the possibility that this is also deliberate. This is an attrition strategy. If you make cross-examination of the defense witnesses annoying, aggravating, painful, something that everybody would like to avoid and wants to be over as soon as possible, then what you're doing is you're putting a little bit of incentive pressure on not calling more witnesses. The fewer people you call, the less we have to go through this song and dance and have all of these all of these reactions and deal with all of this unpleasantness. Easy fix for Hank Brennan. Just don't call more witnesses. What do you guys think? Little bit of a strategy here. The attrition, just make it painful. Make it painful to call witnesses. Creates an incentive to not call as many. Well, I'm gonna fully backpedal now on this all about being polite to the ARCA witnesses. Things like this with Dr. Russell, the ARCA witnesses, he's going to be at his most childish and infuriating.
May I have a moment, Your Honor?
Yes.
Thank you. Dr. Russell, do you recall questioning by Attorney Brennan with regard to some alleged clip with regard to a motor vehicle, the Lexus and the pedestrian in this case? Do you recall that discussion?
Yes.
And have you reviewed and Attorney Brennan asked you about the slide presentation that what Dr. Welcher did with regard to this supposed accident reconstruction? You remember those questions?
Yes.
Mr. Woke, if you could please publish the slide from Dr. Welcher's presentation with the arm out in the glass in the back, not that one, the one in this case of the Lexus and Dr. Welcher dressed up as Mr. O'Keefe and with the clothing in the back, but with his
It appears not, copy under stars. Here's he had to move on from
the
that.
back of that slide presentation, probably around 130-ish, 120. That's it, yes. And what slide number is that? 109. So, Dr. Russell, can you see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay.
Look where his hips are.
This is a direct impact. And now, from your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in reverse with a direct impact on the arm. From your experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect at least significant bruising, at least. But I would also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
Well, from this image, if it impacted that section of the arm, and let me use my pointer, right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Could you please stand up and with your Honor's permission, show where the radius and where the ulnar bones are of the arm? The lights on, please. Thank you. You can keep the lights on.
So the radius and ulnar are the two long bones in the forearm right underneath the skin. And then they join with the humerus bone here in the upper arm at the elbow. And those, of course, these bones are they're susceptible to fracture with a significant impact. And also the elbow would be susceptible to fracture.
How about the hand?
The hand could be injured. It depends on where the hand was in relation. And also, if there was a fall, there are other mechanisms that could contribute to a fracture from the actual fall onto the ground. So there could be a wrist fracture, digital fractures. It depends on the circumstances.
Thank you. And do you, you can be seated. Thank you very much, Dr. Russell. From a direct impact to the arm, as you said, is depicted here. What is the likelihood of there being any fracture to any bone?
Objection.
Sustained in that form.
Do you have an opinion, based upon a reasonable degree of medical certainty, as to whether there would be any fracture to any bone?
I believe that there is a very high likelihood that there would either be a significant bruise or a laceration or a fracture of the bones.
Now let's go to, as I understand it, you have reviewed the autopsy report of Mr. O'Keefe?
Yes.
And you've reviewed the file, the medical records files, correct?
Yes.
Is there any indication at all of significant bruising to the right arm of Mr. O'Keefe?
No.
With regard to the lower extremities, from what is depicted here, meaning this impact, did you evaluate the autopsy and the medical records to see what evaluation was done of the lower extremities?
Yes, a very extensive evaluation of lower extremities was done.
What very extensive evaluation was done, and by whom?
By Dr. Scorbello, and it was both an external and an internal examination of the lower extremities.
Let's start with the internal examination by Dr. Scorbello.
He took the skin off.
Could you please describe what type of internal examination she performed?
Well, she opened up the legs.
Sustained.
Yeah,
May we
she's
approach
not
her?
why we don't get to ask about this.
All right, jurors, I'm going to send you out for lunch, okay? We'll see you at 2 o'clock. Yes, come on up.
Can't have the jury know that she actually looked beneath his skin for hemorrhages, bruising, any sort of sign of injury, and found none. The little small scrape on the outside of his right knee, that's it. What's our problem here? And they're coming up to sidebar. Can't have this chit chat out here where we, the public, might hear it. Got to go up to sidebar. Is this supposed to be beyond the scope or something? Asked about the absence of wounds on the other underside of the arm. what the different injuries were caused by. Different basis. Things she considered or didn't consider. Superficial wound. He even read parts of it about the superficial wound. She agrees with that. There's no penetration of the skin. It is a superficial wound. Got the punctate marks. She thinks could be from the lower jaw. Showed her the autopsy photo of that arm multiple times, direct, cross, all over the place. Try to get as much information as possible. Yeah, so wouldn't that include the autopsy? Didn't see any medical evidence that there was any impact with a vehicle. There were no significant injuries below the neck. So do we not get to explore that now on redirect? Pretty sure that's what we're talking about here. Then all of the non-medical stuff, photos of the taillight, statements the defendant made. I don't know, maybe this is a beyond the scope objection. I'm not really seeing it if it is, because he asked her many things about the medical evidence, lack of evidence of the impact, and so on and so forth. Scorty Bello didn't know a dog bite was alleged. That's his explanation for why they didn't swab it before. But to do a complete investigation, it should have been considered. So do we get to evaluate the thoroughness of her investigation? She looked for impact injuries to the lower extremities. Apparently didn't find any. So that's really all I can come up with here is thinking maybe it's beyond the scope. I think that's pretty weak if it is. But it sure would be nice to not have to guess, wouldn't it? It'd be nice to not have to guess what the problem is. I'm just waiting since they're still all up at Sidebar. At this point, I'm not really expecting them to do anything when they come back other than say, hey, it's lunchtime now. But we do want to be sure. I mean, we still have the bushes to talk about, right? Now, apparently, we've got multiple possibilities. Brennan is putting out there for these abrasions. Maybe it was his arm contacting the tail light and rolling off it the way that Welcher described, the pointy tail light. Maybe it was the microscopic pieces in the clothing that he slid on while he was moving on the ground. Maybe it was the bushes. He brought up the bushes in that cross-examination. Did you see there's bushes over there? So all of these possibilities, none of them proven, of course, by the party with the burden of proof. But all these possibilities to be ruled.
All right, Chrissy, does that help?
Yeah, we're just going straight to lunch now. Well, shall we recap? Shall we recap what we've had this morning? It's been all cross and then going into redirect of Dr. Russell. We had that motion for a mistrial midway through. So a lot of questions from Mr. Brennan suggesting that she has changed her opinions, but he's then presented her with prior testimony from all these different, the voir dire, the prior hearing, the other voir dire, etc. And by and large, really not seeing changes here. Seeing at best some minor inconsistencies that she explains as kind of being wording, like never 100% certain. Isn't that what Dr. Welcher told us about the Lexus shooting off into space to try to demonstrate? I don't think she's opined anything so unrealistic as that. But just considering different possibilities, you can't say with 100% certainty. Listening that conversation with Alessi about looking for the transcript and the implication that violates the sequestration order. I would have liked to have seen that objected to. I'd be objecting to it. It doesn't violate the order. You haven't asked for any sort of remedy. You haven't asked for her to be found in contempt. You haven't asked for Alessi to be found in contempt. You haven't asked for any type of sanction. You haven't asked to strike or limit her testimony as a result of the violation. Nothing. There is no violation because there doesn't seem to be a written sequestration order. There's just a grant of sequestration under the rule, and the rule is limited to testimony. You can't observe the testimony of other witnesses. So nothing says they can't have a conversation about whether it might be prudent to ask for the transcript if you're being, told that you said something before. But hard to know how that kind of thing sits with the jury. Does that land? Do they sit there and think, ooh, how shady of that defense team to have that conversation? Really hard to say. Little slip out there about the limo driver. They were in a car with a limo driver. Don't know how that's going to sit either. Caught my attention. A limo, huh? Some people who are, maybe a little more judgy might be like, what are you doing in a limo? Could also just be a figure of speech, You have a car that's being driven by somebody else and dropping you off. It's like town car type service, but a town car is, not necessarily a limo. Probably rarely a limo, but sometimes. Sometimes a Lincoln is a limo. So then, and then as through part of that, don't you have memory? Do you have any memory issues? What an asshole. God, he's just such a dick. And so it makes me wonder if he undoes his own work a lot of times with some of that stuff. Like you might have found a thread there that you could pull on to make it sound like the defense and Dr. Russell are being real shady about coaching her testimony or so forth. You might have had something there, but then I feel like you go and undo that work by being an uncalled for asshole like that. Do you have any memory issues? So her original opinion was an animal, possibly a large dog. He wants to argue with her about the methodology. The methodology is pattern recognition and different diagnosis. There's no standard in the dog bite community. Well, if you can tell me who the hell this dog bite community is of which you speak, Mr. Brennan, then maybe we can talk about whether there's an understood standard or not. But she relied on the medical stuff, these articles that described the methodology that you should follow. Where is the written standard? Where is the written standard for diagnosing injuries by broken tail light, Hank? Where's that one? That peer reviewed somewhere? You gonna pull that out in your rebuttal case? Something tells me there's not a standard like that. Probably not a standard to identify the source of a lot of different kinds of injuries. But doctors, would still need to do that on occasion. I would expect. Still with the trying to make her a fame whore. She interjected herself in the case. She invented the methodology to do it. Dr. Russell, par for the course with the defense experts, has remained, she's clearly not pleased, but she's not like retaliating. She's not fighting. She's not getting mad with him. So it just speaks to, again, the disconnect between the rudeness that he's showing and the lack of necessity for it. She's given you no attitude that warrants being rude with her. But some people, I mean, that's like as deep as their approach goes when it comes to leading and pacing the jury. They think if I demonstrate emotion, the jury is going to like follow along with that. So therefore, if I get up and I show contempt for everybody, the jury is going to follow that, and they're going to feel contempt for that person too. And I just tend to think that's not really a valid strategy most of the time. Oh, there might be some people that's all they're going to do. We're going to identify with one attorney or the other attorney, and then that's the level on which I'm going to register what's happening. Is my attorney showing contempt for these people or not? But I think for most people, that's just, it's not going to work. You're going to notice. He's being really contemptuous of her, and I haven't seen anything that she's done that deserves that. She disagrees with his case, and this is how he responds. It reminds you a little bit of how sometimes disagreements get aired on the internet. What happens when you disagree on the internet? Do you guys just go, "Oh, well, I respect your judgment. Let's go our separate ways now. Good to have a nice substantive chat." No, of course not. They start name calling and doing things like that. And it's just a very similar thing that Hank is doing. She agrees at superficial abrasions. She thinks it could be teeth or nails. Sometimes it can be difficult to tell those apart. Go through a lot of the reasoning about why that is, the shape of the nail, what's what. Then went through the groupings and the analysis that she's given to the groupings, while recognizing you have to consider everything as a group, but alone. Individually, you wouldn't be able to say, "Oh yes, that is certainly a dog bite." You need the entire pattern as a whole to be able to recognize that. And I like how she explained that too. Finally, at the end, it was because there's so much variation in individual injuries. It's not just that there's variation in individual injuries, there's variation in people. I'm kind of waiting to hear this too, and it hasn't really come out. But that's one of the issues with a car accident. And like, would you expect this injury? And this guy had these injuries and so on and so forth. People can have widely different injuries. One of the points that was brought out on cross. Yeah, if multiple people are hit by the same car at the same time, they can have wildly different injuries, not just because they're having different interactions with the car, but because individuals' own susceptibility to or resilience against injury is going to differ. The same, contact with one person that's going to make them bruise is not going to register at all on another. It's a very common sense experience that I think lots of people have, but it hasn't really been explicitly called out. That it's very hard to gauge. You can look at the tolerances, which is why we need the biomechanical people to testify. You can look at what the tolerances are, like what's the absolute limit that's ever been observed of a human bone resisting a break against, what degree of force. But that doesn't allow you to say whether or not an individual person would suffer an injury at a lower degree of force. You just don't know. There's too much variation among individuals. So just you know, a lot of time going into badgering her about the different groups. He doesn't think you can't possibly say these are caused by the same teeth. The skin is plastic, and you have to take into account that it's in motion. It's moving not only against the dog, in relation to the dog, but also to its own underlying structure. You know, the skin does slip. You can pinch the skin. So the fact that there are different gaps between the striations does not seem to rule out that they are caused by dog bites. I'm just not seeing that. If you can have so many variables with how a pedestrian gets impacted by a car that can change the scenario, I can't imagine there are not any variables when it comes to how a dog leaves teeth marks on somebody's body. I think there's going to be quite a few variables. She disagrees that you need to know about collisions to be able to do the differential diagnosis. She knows what she knows based on having treated the wounds. And so therefore, walking through all of these things she didn't do, like going to the crime scene, looking at the photos of the car, going to 34 Fairview, you know, et cetera, looking at the pictures of the broken taillight. I would have objected to all of this. She said it doesn't matter. She doesn't need to know about that. Her analysis is based on the injuries. And so no, of course it wouldn't change her opinion to see all of this non-medical stuff. It doesn't change the injuries that he has. I think at best all it's going to do is help you brainstorm possibilities for how the injuries might have been caused. At best. We brought in the fact that there were bushes near where John was found. Why are we talking about bushes in the context of interpreting John's injuries? This is the first time now on cross in the defense case that we're hearing a possible Commonwealth theory that the bushes scratched John's arm like that. And they just happen to all be, you know, oriented in the right way and so forth. That I'm not going to buy. Somebody who has spent more than my fair share of time, up in tree canopies doing my pruning, out in the bushes doing the pruning and so forth. I'm going to have a hard time seeing a whole bunch of parallel injuries like that coming from some bushes. She considered all kinds of different scenarios, but didn't see any medical evidence that there was an impact at all. No broken bones, no lacerated organs, no collection of fluid in the torso, no significant bruising. She tried to evaluate different positions he would be in. Was he standing? Was he sitting? Was he bending over? Was he lying down? Et cetera, et cetera. His injuries here were so characteristic and parallel that she could not imagine the plastic or glass or even metal just lining up in a way to be able to make those particular marks. If it's that obvious that there's some kind of pattern here that lines up with parts of the taillight, then Hank, why don't you show us what that is? Show me. Show me the configuration of the pieces of plastic in the taillight and how that worked. That would create these injuries. I understand there's lots of variables. You don't have to show me every single configuration, just a single one. Just a single one. Just show me that. But we didn't get that. We just have more possibilities now from the party with the burden of proof. She didn't really care if there was a broken taillight because it couldn't cause those injuries. You would need multiple projections from the vehicle to cause that injury pattern. I'm not even sure what that means, multiple projections from the vehicle. I mean, I guess a lot of things sticking out. Is that what she's saying? I mean, I would think that yes, you would. We don't have multiple things sticking out from the taillight. Trooper Paul back in the day, Trooper Paul was like the taillight exploded, and it was the contact with the pieces that ended up in the shards that cut John's arm. But of course, there's no blood or flesh or anything like that on any of those shards. So Hank is apparently not pursuing that theory. Not really clear why. Then we got into the swabbing of the clothing for DNA. So that's when we had our morning recess, the motion for a mistrial. It's an intentional elicitation of facts not in evidence for which there is no foundation by the prosecution. It violates her constitutional right to a fair trial, but the magic word I was looking for that I didn't hear was confrontation. This violates her right to confront the witness who conducted the DNA testing under Bull Cumming and God, what was the new case? What was that new case? I want to say it was in 2023 or in 2024. Was it substitute? Smith v. Arizona. Smith v. Arizona. It's such a normal name that I couldn't. I can remember Bull Cumming. Okay, who's not going to remember that? Who's not going to remember that? But Smith v. Arizona, couldn't remember that one. Been reiterated multiple times, guys. You can't have one expert come in and just state the findings of another expert. This is like not a new issue. It is a confrontation problem. So might be curable. Might be curable. What's going to happen now if Hank doesn't call Terry Kuhn? What's going to happen? Didn't make him commit that he was going to call her. Still shouldn't do it because it's a prior opportunity to cross-examine. So you should have to have that foundation in before you're allowed to go down this road. But it's not. And here we are. Overturned, motion denied. You can do the line of questioning. When it comes to this Dr. Walsh report, she disagrees with him, so doesn't get to get cross-examined by it under the standard that was set by Bev. I mean, the whole thing is such a shit show. Isn't this such a shit show? I mean, imagine a standard where expert disagreement is not a subject of cross-examination. It's just nonsensical. It doesn't even make any sense. But that's the standard that Judge Bev has set. And so that's where we are. It's just the strangest thing to me. But you bend over backwards because you want the Commonwealth to not be confronted with the stuff that doesn't fit with their theory, the things that they've jettisoned from the first 2.5 years of their case. But now that corners you into a standard that applying it to the defense expert, now you're stuck. But then when you look at the whole situation from like the 10,000-foot view, it doesn't make any freaking sense. Really? You can't cross-examine experts about their disagreement with other experts? Isn't that like the fundamental thing that you do with experts? It's just baffling. It's just mind-boggling what an absolute shit show she has turned this trial into. I guess we're at lunch now, so I'll go ahead and change that. So we came back after the break and continued with the cross. Looked at the photo from Dr. Welcher's presentation and the paint video, reestablished that she doesn't understand the text stream data. DNA on the taillight, she was aware of it, but there can be lots of reasons. I would like to hear that also put in the very simple layman's terms. Absence of evidence is not evidence of absence. The fact that there is no DNA on something does not mean that there is no thing that could have produced DNA. It just means there's no DNA. There can be lots of reasons for absence of evidence. I'd like to see that just kind of spelled out a little bit more specifically. But yeah, there was, my recollection, there was interference with the DNA sample, the DNA testing when Dr. Kuhn did it. I have to go back and double check, but I vaguely recall that. And that's not uncommon when there's contamination or things like that. There's other substances. It came up because they use the marking. One of the reagents that they use is known to potentially interfere with being able to get DNA results. But there was pig DNA. No idea where it came from. No. Hank, why don't you tell us where the pig DNA came from? What exactly was the taillight snacking on before it went and took this bite out of John's arm? Is that where the pig DNA came? Or did it come from the bush? Did the pig DNA come from the bush that now injured John's arm? Don't know. Weird that the burden of proof, the party with the burden of proof, doesn't seem to have a theory for why there's pig DNA, but is still going to wield this pig DNA as if it somehow is like a cudgel against the defense. I don't think the presence of pig DNA on the sweatshirt is particularly harmful to the defense. We'll see once we get to that rebuttal case, won't we? I'm sure there will be a great double standard for why absence of dog DNA insignificant, presence of pig DNA very significant. So then just kind of the timing of this, the swabbing should have been a thorough investigation. It should have been considered as part of a complete investigation. So basically there should have been swabbing of the wounds at the time is what Dr. Russell seems to be saying. It would make sense to me. I don't know why you wouldn't, why wouldn't you swab the wounds? It seems like that should be kind of routine. I don't know. I mean, doesn't it seem like there's enough of a possibility to get evidence from a wound? If it's just from something blunt, maybe there's trace evidence. There could be transfer DNA, a blunt object that's already got DNA on it. I don't know. So she would normally expect a dog bite on the sweatshirt to leave DNA. She did not know about the scrapings or even really particularly care about the scrapings because to a reasonable degree of medical certainty, they could cause superficial abrasions, but would not appear in that pattern. And that was the end. That was the end of Cross. I mean, what a way to what a place to end it. No, Hank, to a reasonable degree of medical certainty, your theory doesn't work. Then we get redirect, and it's been this uphill battle to ask questions that seem like they're fairly reasonable things to ask, given what was brought out. No, continues to believe taillight didn't do it. We're going to reiterate that a few times, go through the study, talk about what the study describes, the individual marks, the patterns, the morphology of the dog bite, all of those types of things. Looking at the Welcher's presentation and What injuries would you expect from that? At the very least, serious bruising, along with possible fracture or dislocation of parts of the arm. Seems to make sense. You can't say it would happen because it's an individual and you don't know what his individual tolerance to injury is. But high likelihood of, at the very least, significant bruising. Of course, you're talking about a major amount of force that's, slamming into his elbow by the tail light. And then we got cut off at lunch because we're trying to talk about the examination of John's lower extremities during the autopsy and how she did an internal examination. She opened up his legs to look for evidence of an impact, and she didn't find one. But I don't know. That's impermissible for some reason. That is not evidently clear. Not evidently clear to me anyway. So, more Dr. Russell after lunch. There'll be redirect. There'll probably be recross. See what else we get to with our couple hours left remaining in the day. Guys, we got a few questions in the queue, and I also mentioned we do have some defense pleadings now that might be fun for us to go ahead and look through when we get a chance. So I am going to go ahead and pause real quickly, do my step away, refill my tea, all that stuff. I didn't hear her say how long we have for lunch today, but I'm assuming we still have a little bit of time. So I will be back. Give me like 5-10 minutes. Hang tight if you don't mind, and then we'll take a look at some of that stuff that's out there. So appreciate you chilling while I take care of my chores, and I'll be right back. All right, guys. Thank you for hanging tight with me. Everything is good around the home front. Just another normal, quiet day. The little baby chickens are not such babies anymore. They're still small. You know, they need to go through another molt before I think we'll be able to start to tell if we ended up with any roosters in this batch. Kind of hard to tell. I have a very hard time telling anyway, but until they start to get more developed, and then you have some differences in like the feathers. The feather shape on the saddle is what I go by. You have a long feather on the saddle. Probably got a male. Short rounded feather on the saddle, then it's probably a female. But can't really tell yet at this stage of development. But they are, you know, little birds with little bird personalities now, not just little baby chicks. All the way out there in the big grown up coop with the other birds. They're smaller than the starting hens, but they also outnumber them a good 2 to 1. So the blending seems to be going just fine. All is good. All is good in the rest of the world. So guys, let's go ahead and take a look at, actually, we're going to try to do it like this. Take a look at, that's too small. The motion to present a missing witness argument. Is that big enough for you guys to be able to read too? I don't want to read through the entire thing verbatim, but I do want everybody to be able to see while we follow along, and it's just easier to do it this way where I can scroll through the images. So starts with just the kind of basic legal outline here that the foundational requirements have been met. So set out in the case law where a party has knowledge of a person who can be located and brought forward who is friendly to or at least not hostilely disposed toward the party and who can be expected to give testimony of distinct importance to the case, the party would naturally offer that person as a witness. So if they don't, without explanation, call that person, the jury can infer that the testimony would have been unfavorable to that party. It's discretionary with the judge. However, cases supporting the need for judicial caution in permitting an adverse inference are inapposite when the inference is to run against the Commonwealth, because there are no constitutional concerns to warrant the call for caution in such instances. You got to be careful if you're gonna try to get this type of inference raised against the defense, because the defense has no burden to call any witnesses at all or to present any evidence whatsoever. So you run the risk of abridging that right if you're going to go and tell the jury to draw improper inferences from exercising it. So who are they talking about? Michael Proctor, Brian Albert, and Brian Higgins. All of them. They were all on the witness list presented to this court by the Commonwealth. There has been no showing of physical unavailability for any of these 3 witnesses. Additionally, the defense is informed that Brian Albert and Brian Higgins were both under subpoena by the Commonwealth. Not interestingly, Proctor. Very interesting. Very interesting. They're all friendly. They all testified cooperatively in 2024. No reason to believe they would not continue to cooperate. The fact that she could call those witnesses does not render the adverse inference impermissible, because the Commonwealth is more acquainted with them and would be naturally expected to call them. So even if they're available to both sides, if the witness is more friendly to one than the other, then the instruction is appropriate. We saw that when we looked at the rule yesterday. So they would all be expected to give non-cumulative testimony of distinct importance to the case. So neither cumulative nor unimportant. Michael Proctor's anticipated testimony would not be duplicative of other witnesses called by the Commonwealth. The lead investigator is of great importance to the case, as the role is inherently unique compared to other witnesses, both civilian and law enforcement put forward. He was responsible for recovering a significant amount of the evidence in the case. Buchanan's testimony confirmed that nearly every piece of evidence recovered in connection with the case, including all of the taillight pieces recovered at the scene, Mr. O'Keefe's clothing, Mr. O'Keefe's cell phone, the surveillance video from the Canton Police Department, were in Michael Proctor's sole possession for months or years before they were booked into evidence. It's really, I think, the strongest thing they have is everything that he had, for which there's no chain of custody. Similarly, neither Brian Albert's nor Brian Higgins's anticipated testimony would be duplicative of other witnesses. No one can testify as to their exact whereabouts within the home. Sarah Levinson and Jennifer McCabe's testimony are not sufficient to support the claim that John O'Keefe never entered the curtilage of 34 Fairview, as they were not all together the entire time they were at 34 Fairview, leaving Brian Albert and Brian Higgins each with the opportunity to interact with John O'Keefe within the curtilage of the home without any other witnesses being aware. The curtilage is outside the house, but it's the areas intimately associated with the house. So usually this idea is that there's kind of an expectation when you have a front door of your house that people are allowed to walk up the front door and knock on the front door. Like, that's nothing unreasonable about assuming that you're able to do that. Now, if you get to the front door and there's a sign that says no solicitation, that tells you you don't actually have permission. But absent something like that, it's implied that people have the right to do that. That does not mean, however, that people then have the right to go trooping through your yard and wander around the perimeter of your house and peek in the windows and things like that. Just because there's this implied right to go up to your front door does not mean that there's an implied right to go into any part of your property that's not fenced off. So this arises out of Fourth Amendment search and seizure jurisprudence and just the idea of what's a reasonable expectation of privacy or not. Choosing to use this language here, not because it's, technical in that sense, but just kind of explaining what that means in terms of a description. I think they really mean the yard, the yard, maybe the garage, not inside the main living area of the house, but in the areas that are closely associated with the activities of the home. Specifically, no other witness has testified thus far or even would be able to testify and be meaningfully cross-examined about the reasons for Brian Higgins visiting the Canton Police Department around 1:30. Additionally, no other witness has testified or even would be able to testify to the reasons why Brian Albert, a trained first responder, and his wife did not come outside when their bedroom was mere feet from the scene of drastic life-saving efforts. Response by police officers, cruisers with lights, and the sounds of 3 women discovering a loved one unresponsive in the snow. There is no logical or tactical explanation for the failure of the Commonwealth to call them. So if they provide, Your Honor, with an explanation for not calling them and the explanation is sufficient, then the instruction can be rejected. It's sufficient where the trial judge is satisfied that the circumstances thus offered would, in ordinary logic and experience, furnish a plausible reason for non-production. Here, the Commonwealth has not and cannot provide a sufficient explanation for not calling these 3 witnesses. The Commonwealth understands the risk that the testimony of these 3 witnesses poses for their case, as all 3 are highly susceptible to impeachment on relevant and non-collateral issues. The Commonwealth is consciously choosing to obscure and hide from the jury the complete picture of what occurred at 34 Fairview Road on January 28th and 29. Conceitedly, witnesses may be withheld because they are susceptible to cross-examination on collateral issues or for other tactical reasons, but that is not the position the Commonwealth is in with these 3 material witnesses. All 3 are subject to cross-examination regarding issues that are central to the case, not collateral. Proctor's handling of the investigation, relationship with the very witnesses who should have been suspects, and subsequent termination from the MSP as a result of his conduct in this case. Prior admissions by Brian Albert and Brian Higgins that they left the rest of the group at 34 Fairview Road for a period of time in the early morning of January 29th to look at photographs in some other part of the house. Then several other things here, 4 other things that it appears we don't get to see. What are some of the other things they'd be cross-examined about? Again, guessing, like we guessed yesterday, if there's stuff that's redacted here, it's probably from confidential materials, and that's probably grand jury materials or other parts of the discovery that was subject to the TUI. The TUI discovery that's subject to the federal protective order, so likely relating to the federal investigation. So then depriving Ms. Reed of the opportunity to present a missing witness argument and denying giving the subsequent instruction would undercut her ability to present a defense. So they're arguing there's a distinction between giving an argument like this with the Commonwealth and with the defendant. The defendant has wide latitude in any and every case to argue that the Commonwealth has failed to present sufficient evidence and that there is an absence of proof or that evidence is missing. A missing witness argument is distinctly different from this scenario. While both allow the defendant to argue the Commonwealth did not meet their burden of proof, in the former, the defendant argues that the evidence that has been produced is inadequate, and this can legitimately include pointing out specific witnesses or evidence that have not been produced. However, in order to argue or ask the jury to draw any conclusions as to the substance of the evidence that has not been produced, counsel must first seek judicial consent to present such an argument and have a subsequent instruction. A significant portion of her defense has been focused on the inadequacies of the investigation and a lack of consideration of other suspects. A judge is not required to take the adequacy of the police investigation away from the jury. Oh no, not only not required, a judge, I was going to say, a judge is required not to take the issue of the adequacy of the police investigation away from the jury. It's a jury question. The judge doesn't get to decide it. Not affording Ms. Reed the opportunity to argue that the jury should draw adverse inferences from missing witnesses in the Commonwealth's case that are deeply involved in the investigation itself will erroneously remove from the jury's consideration the precise issues sought to be raised by the defendant. The jury should be provided with a necessary framework. Wait, is this? Yes, this is correct. The jury should be provided with a necessary framework for considering the absence of evidence or witnesses, should they deem it relevant information to their deliberations, and assess the weight and significance of the missing evidence or witness in relation to the evidence presented against the defendant. So, answers our question: Brian Higgins, Brian Albert, and Michael Proctor. Those are the three missing witnesses that they're alleging are particularly friendly to the Commonwealth. No reason intuitively why the Commonwealth would choose not to call them. I still struggle, and I don't know that the motion helped me a lot sort out the difference between when can I tactically choose not to call somebody because they're going to get impeached versus that's what this missing witness instruction is about. I know if I call them, they're going to be impeached, and that goes badly for my case. So I don't call them so that the jury can infer it would go badly. Like, I have a hard time not seeing how these are just sort of two sides of exactly the same issue. But it seems to be that there's a distinction between impeaching them on irrelevant or collateral issues and impeaching them on stuff that is material and central to the case. They've got this quote in here: conceitedly, witnesses may be withheld because they are susceptible to cross-examination on collateral issues or for other tactical reasons. But I don't know what that quote is from. It's not cited. It's not attributed. I think it's still coming from either Wigmore's evidence, which is a very, very common, very well-known treaty on evidence, but it's also like a general common law rule. It's a treatise that deals with common law principles. It doesn't go like jurisdiction by jurisdiction, what's specifically allowed there, but it has been cited by some case that they're relying on. So you can typically treat it as being, adopted by the court as more or less the law on that particular point. So if it's not on a collateral issue, then maybe that's where it's the same side of the opposite coin. Take your pick. You get to call the person and get them impeached on something material, or you can not call them and have the inference that the reason why you're not is because it would be bad. That seems fair, doesn't it? Doesn't that seem fair? If you know that your case is going to be devastated because of this particular witness that you have to you have to deal with. Doesn't it seem fair then that if you don't call that person, you don't get the impeachment? If the person has got something that otherwise the jury would expect to hear, then it seems like a pretty reasonable inference to draw. So yeah. Is she going to grant it? What do you guys think? Is she going to grant this? Oh, I'm skeptical. I'm skeptical that she's going to grant this one. Then we have motion for reconsideration of Michael Easter. Let's take a look at this one too, see if we get a chance to get through it before they come back to court. If not, we can come back to it when the day is over. Moving for reconsideration, excluding defense expert Michael Easter's testimony regarding law enforcement's failure to adhere to standard investigative policies and protocols in this case. They allowed the Commonwealth's motion in limine to exclude. In doing so, the court explained that expert testimony is not needed because the defense, through zealous cross-examination of police witnesses, can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedures. The defense respectfully requests that this court reconsider its decision in light of the fact that the Commonwealth only called 2 police witnesses responsible for investigating O'Keefe's death in its case in chief, Canton Police Department Lieutenant Gallagher and Massachusetts State Police Sergeant Buchanan, both of whom refused to concede investigative failures. The defense should not be forced to adopt the self-serving opinions of these particular law enforcement officers regarding the reliability and adequacy of their investigation. Massachusetts law firmly supports a criminal defendant's right to challenge the adequacy of the investigation through the Bowdoin defense. They may consider the fact that certain tests were not conducted or certain police procedures not followed to assess whether the investigation was deficient. Evidence of investigative failure may raise reasonable doubt, and precluding such evidence improperly removes this determination from the jury. Importantly, expert testimony may be introduced to support a Bowdoin defense where the subject matter lies beyond common knowledge. Such testimony is particularly appropriate where the expert can explain how an investigation deviated from professional norms, especially when based on articulated standards such as departmental policies and procedures. The purpose of expert evidence under the Mass Guide to Evidence 702 is to assist the jury in evaluating the significance of technical failures that may not be readily understood through lay observation alone. Oh, guys. Here's where I think we might still have a little bit of a foundation problem. It's appropriate when an expert can explain how an investigation deviated from professional norms, especially when based on articulated standards such as departmental policies and procedures. I agree, that's really helpful, but that's what they didn't confront Gallagher or Buchanan on. They didn't confront them with any departmental policies and procedures. Of course, they didn't concede that anything was wrong because we didn't have a standard put under their nose for them to either adopt or reject. And then, try to explain if you can how what you did is consistent with what the policy and procedure calls for. But they haven't been confronted with it. I don't think it's going to get over. I don't think it's going to get over that hurdle to get her to reconsider. Because I think that's what she meant by, her vigorous cross-examination. If he's got policies and procedures and stuff, Mr. Easter, that he was going to rely on, present those to the witnesses. See what they do. If they reject them or they won't adopt them, or they're like, I don't know what this is. I've never seen this before. I don't know if you know, edited it, the game that Yuri played the whole time, that we can be pretty sure he'd play with this document too. But we don't know because we didn't try. But if they do that, then you've got a pretty good case to argue C cross-examination isn't enough, because they wouldn't even concede that this is their policy. They wouldn't even admit that it's their policy. But if you haven't confronted them with that, I don't think you have that foundation. So I'm a little skeptical that this motion is going to be granted. He shouldn't have been excluded in the first place. I mean, the exclusion is ridiculous. But given the logic that she applied to it, is this going to get her to reconsider? I don't think so. The order allowing the Commonwealth's motion to exclude presumed that zealous cross-examination would suffice to expose all investigatory deficiencies. However, okay, here we go. Maybe there's some case law. As set forth in Commonwealth v. Reynolds, the defense should not be forced to accept the Commonwealth's witnesses' testimony regarding what constitutes standard practices, policies, and procedures based on what they are willing to admit. Similarly, in, it looks like we're coming back to court. We'll come back to this, guys, after...
All right, Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Dr. Russell, we left off talking on the topic of differential diagnosis, and more specifically, we were talking about the lower extremity, the leg, and you were mentioning we reoriented to Attorney Brennan's questioning in the area. Could you please describe for the jury your basis of differential diagnosis with regard to the lower extremities and the leg, and specifically with regard to the autopsy's analysis of that area?
Well, the autopsy doctor did a very thorough evaluation of lower extremities, and to include, the external examination, which is very important, as well as an internal examination of the extremities, the tissues beneath the skin in both legs.
And just briefly, how did she perform that internal examination beneath the skin to look at what was beneath the skin?
Well, to directly visualize those tissues, she had to open up the skin. So she opened up the skin in the legs from the buttocks right down to the bottom of the legs near the ankle, and then reflected or folded back the skin to examine if there were any injuries to the tissues underneath.
Were there any injuries to the tissues underneath from that examination?
There were no injuries that she mentioned, nor no injuries that I saw on the pictures.
And no injuries, did that include analyzing whether there was any inflammation?
No, you can't tell about inflammation, but I specifically looked at the area adjacent to a very punctate little abrasion on the knee, and I looked underneath of that area very carefully on the photograph, and there was nothing, no injury underneath, no bruising, no hemorrhage underneath that abrasion.
With regard to that, how did you describe that punctate? I want to make sure I got it accurate. By the right knee?
Abrasion.
Abrasion. Could you determine from that even the age of that abrasion?
I could not.
No further questions at this time, Your Honor.
Oh, okay. Brennan?
Oh, we're back to Russell. Let me fix my banner here.
Could I inquire about scope?
See you at Sidebar.
What, he wants to go beyond the scope? Verify that he's going to be within the scope? I don't know. So whatever the objection was before lunch about the opening up the legs appears was, you know, once again, she sustains it on the fly. They go up and they have a sidebar, and then it's allowed. Then he gets to follow up on it. So just a thing we notice. Her knee-jerk reaction. No, you don't get to do that, defense. You don't get to do that. Then they come up and apparently explain why they can, and then do it. No bruising or hemorrhaging in the legs. Kind of seems important. Really does kind of seem important. I mean, even these photos of Dr. Welcher trying to do his arm test. I'm sorry, I'm not seeing his legs are in the way. I don't know. Would it have been impossible to try to create like a rendering of any of this? No, wait, you can't do that. You can't do that because there's too many possibilities. Not enough data to narrow down exactly how his feet are loaded and what his body position is, whether he's on the berm or in the street. So you can't model this. Could you give me just one? Just one. Just give me one. Just give me one model. It doesn't have to be the only way or like saying it's definitively the way that this all went down. But just one way that if everything, hypothetically, in reality was all like this, then we would end up with what we see at the scene. We would have John over there near the flagpole, on the ground, on his back, the injuries that he has, the phone activity. You know, just one where if we assume the facts to be one way, it would give us this result. Could we do just one? I mean, apparently we can't. We just throw up our hands. There's too many possibilities. To me, that seems like that's quitter. That's a quitter mentality. Really, you can't come up with just one? Completely understand that it's not exactly what you're saying. You know, the facts are, but you can entertain hypotheticals under the rule. As long as they're not like completely out of nowhere. Seems like you could assume hypotheticals. Apparently a lot of scope he wants to get into. Shouldn't be that hard to figure out if you're within the scope of the redirect or not. What did redirect cover? Redirect covered the small pieces of plastic. Her belief they could not cause those abrasions, which she also said in studies that she relied on.
May I?
Yes.
We'd rather you didn't, but if you must.
Dr. Russell, I asked you questions about your past testimony regarding methodology. And when I asked you those questions and showed you some of your transcripts, would you agree with me that you have testified that there is no recognized methodology on diagnosing dog bite wounds?
No, I believe I said that there was no standard methodology or no standard guidelines as to how to diagnose dog bite wounds.
There is no accepted practice directing you on what is appropriate and what is not appropriate to identify a wound as a dog bite, is there?
There are no accepted standards.
When Attorney Alessi had you look at a couple of case files from the Journal of Legal Medicine, let me ask you about that. You're not suggesting that those articles substitute for the absence of standards in identifying dog bites from photographs, are you?
Before standards are created, there are usually articles that have recommendations upon which the standards are subsequently based.
That wasn't my question, so we're going to listen to the question, please.
Okay.
Those articles, whatever their value you think they are, they do not create a standard to apply for diagnosing or looking at a photograph and coming to a conclusion whether the abrasions are dog bites, do they?
Correct.
And so when he had you read pieces of these articles, had Attorney Alessi gone over these articles with you before?
Yes, we discussed them several months ago.
Did he point out parts of them he would like you to read?
I pointed out parts that I thought were significant.
In this article that was marked for identification, parts of it are highlighted. Who highlighted those parts?
Mr. Alessi highlighted those based on my recommendations.
So Attorney Alessi highlighted the parts he wanted you to read to the jury?
Yes, and I believe they were the same parts that I read last time.
Can we have Exhibit 1, please? Now, regarding the Munnynck article, that was a case study on the unfortunate death of a young girl, yes?
Yes.
Who was attacked by or bitten by up to 3 different dogs.
Yes.
And it was a neck wound from which she bled.
Yes.
Very, very unlike what you're looking at here.
Yes, but that's very typical of an article, scientific article. They will present a case study and then present the research behind what they have seen in other articles and make recommendations.
I'm not asking you to defend that it's different. I'm asking you if it is different.
Oh, it is different.
Very different, isn't it?
Yes, that neck wound, yes.
Extraordinarily different.
Yes.
And so when you read this, let me ask you a couple questions. In this article, it talks about the characteristics of dog bites, doesn't it?
Yes.
And it talks about the maxillary teeth distal to the mandibular teeth allow the so-called scissor bite.
Yes.
So when the dog clamps down, the teeth kind of go to the side to tear the skin.
I didn't interpret it that way, no.
Okay. A scissor bite is when a dog bites down, yes?
Yes, I believe that what they were describing was the dog bites down.
And when it bites down, it anchors. That means teeth on the bottom, penetrate, puncture, yes?
They can, but they don't always puncture.
And then the top is a puncture. If you're going to scissor, it requires a puncture, doesn't it?
It's a mechanism. It's a movement. What they're describing is a move. In the way I read it,
That's not how I
they
understand
described
the
it is a
scissor
movement
bite.
like a scissor, where it's open and it's closed.
There
It
are-
No,
doesn't
it's with
mean
their
anything about
canines.
how deep they penetrate.
There are no scissor bites on that wound, are there?
I don't know. I see 1 or 2 things that show up what I think might be upper and lower, so it could be.
Would you define any of those abrasions as scissor bites, Dr. Russell?
We talked earlier about how these marks here may be lower. I'm not going to define it. No, I can't say for sure that there's a scissor bite, but I see things that appear to be characteristics of upper and lower teeth.
I'm asking you about scissor bites. Please listen to my question. There is nothing on that wound that is consistent with scissor bites, is there?
I don't know.
Well, you're the expert. So
I-
when you, when you look at that, can you point whether there's any wounds that are consistent with scissor bites?
According to their definition, and that's not an accepted definition, but according to what they were describing, and I believe what they meant was an open and closing of the jaw as the scissor activity, I believe that there's possibly 2 areas where I see that.
You're now saying this article that you relied on redirect examination is not an accepted authority?
I'm not saying it's not an accepted authority. It is a peer review article.
The injuries caused involve a combination of biting, crushing, and tearing. Do you see any crushing or tearing in those abrasions?
There's no crushing or tearing here, but does not mean that there has to be crushing or tearing.
I'm reading your article. I'm just reading verbatim, and I'm asking you about it.
Yes, and I'm trying to explain so that nobody gets nobody misunderstands this.
Crushing and tearing that result in characteristic pattern of punctures. A puncture is when a tooth penetrates the skin and there's some depth to it, correct?
Yes.
Show me one puncture, anyone, on that wound.
Okay, there are no punctures on this arm that I see. However, again, the wounds don't have to have every single characteristic. It is, it depends on the force of the bite, how the wounds are going to appear.
The injuries caused involve a combination of biting, crushing, and tearing that results in a characteristic pattern of punctures, lacerations, and avulsions. There is no punctures whatsoever in that wound. Would you agree with me?
I agree.
There are no lacerations in that wound. Would you agree with me?
I agree.
There are no avulsions in that wound. Would you agree with me?
I agree. However,
I'm just asking you the question, Dr. Russell.
So you can maybe ask her.
Specifically,
You can ask
this
her.
study says the injuries cause a combination biting, crushing, and tearing that result in characteristic pattern of punctures, lacerations, and avulsions. They name 3 things that are characteristic traits of a dog bite, and you would agree not one of those 3 traits is present on the arm of Mr. O'Keefe. Would you agree with me?
I agree. However, in that case, those were dog bites that killed the victim. In this case, we do not believe that these dog bites killed the victim.
When they were discussing this article on the victim who was killed, do you realize when they were giving background, this background has nothing to do with the case study? This is general background I just read. Do you realize that?
They were investigating fatal dog bites.
Do you realize that is not qualified in this article?
It's in the title.
You realize that?
I realize that they were commenting on fatal dog bites. This is not a case of a fatal dog bite.
This article, I'm going to show it to you. May I approach?
Yes.
In the highlighted paragraphs that Attorney Alessi had you read, that is describing the background of dog bites, not this fatal attack. Would you agree with me?
The title of the... No, I don't agree.
Okay. I move to introduce this as an exhibit, please.
Mr. Alessi?
No objection, Your Honor.
Yeah, no objection. Go ahead, put the study in. Does it have photos in it? That'd be great if it did.
Is it 210?
In the other article that you read from, that was highlighted as well. Who highlighted the portions you were to read?
Mr. Alessi.
It describes that teeth from a canine create a stab wound-like skin laceration. They can do that, right?
They can do
Do you
that.
see any stab-like wound lacerations to Mr. O'Keefe's arm?
No.
It talks about punctures. And again, we've discussed this. There is 0 punctures on Mr. O'Keefe's arm, correct?
Correct.
Want to put that one in too, Hank?
You said that when somebody is in a collision, that they can suffer injuries such as bruising or breaks.
Yes.
We've also discussed when a person is impacted by a vehicle, it can result in a variety of different injuries or no injury at all.
Correct.
There's a number of dynamic factors involved that are very difficult to assess and predict, correct?
Correct.
And in this case, you did not do any accident reconstruction to try to identify the details of the mechanism of injury to John O'Keefe, did you?
I did not do accident reconstruction.
And so, having not done accident reconstruction, would you agree it's fair to say that you are not in an informed position to give an opinion as to how the injuries could or would have happened in this case?
I disagree.
Specifically, you were asked questions about the impact or collision in this case. How fast was the defendant's Lexus traveling when there may have been an impact in this case?
I understand possibly 24 miles an hour.
Who picked that number?
I have no idea.
Well, you heard it from somewhere and you're just giving an opinion on it. Where is that number committed to or derived from?
I don't know.
Well, if you're going to give an opinion based on what you're portraying as facts to this jury, you should have some certainty about the source of your material, shouldn't you?
You know, I'm an ER doctor, so in the ER, I've treated thousands of motor vehicle accident cases, and most of the time I do not know what speed the vehicles were going at. I've never done accident reconstruction. I don't know any ER doctor that does accident construction or is trained in accident construction. It's not part of the job.
I totally agree, but you're having opinions you're giving on behalf of Mr. Alessi, and that's why I'm pressing you on these issues. Do you know, you don't know the movement of John O'Keefe before any potential strike or collision, do you?
I don't know the movement of most of the patients I've seen in my life before or immediately after the impact.
Of course, you wouldn't know the body angle because you weren't there.
Right.
So when you're asked to give an opinion whether this was a clip or a direct strike, you're really not in a position,
looking at a
having not been
photo.
an accident reconstructionist and not having been there, to give that type of information,
Give an
are
opinion
you?
about a
I wasn't
photo.
asked to give an opinion about whether this was a clip or a direct strike. I was asked to give an opinion about these wounds caused by a motor vehicle collision.
So you would agree with me, you are not in a position, based on your opportunity to view evidence and your experience, to give an opinion about what injuries would have occurred in this event.
No, I disagree.
And so you think you can give an opinion about the extent of injuries, even though you are agreeing, not only you're not an accident reconstruction expert, you have no idea about the details of the collision in this case, Dr. Russell.
Mr.
Is
Brennan,
that true?
I have no details about the collision.
About what happened during the collision. You have no details about the body movement, the placement, the speed.
Whose fault is that,
any
Hank?
details
Whose fault
that you
is
know
that?
of
Who
other
has
than
the
what was
burden?
told to you, correct?
Prove those things.
There are dozens, hundreds, thousands of motor vehicle accidents in which there are no lower body brakes. Fair to say?
Probably, yes.
You mentioned bruising. What do you do to treat for a bruise? If someone's has some type of pressing and the bruise before it really forms, what's the best way to treat it?
Well, it depends on the bruise. It depends on the location. It depends on whether or not there's continued bleeding in the soft
Is he going with
tissues.
the Amber Heard and
It
ice?
depends on whether there's compression of the blood vessels and or the nerves underneath. And then, and of course, you want to examine adjacent structures for fractures and other injuries. And then after all that, if you've ruled out major, other injuries, you treat the patient for pain.
You ever prescribe ice?
Oh, yes.
So if a person was lying prone in the cold winter on the front yard on the dirt
Yeah, that's
and was
where it
being
was
covered
going.
by snow, sub 32 degrees, and the body temperature were to drop from 96.8 to about 80 degrees, would that have a similar effect to ice on the area that may bruise?
Not exactly. You want me to explain?
I do.
Okay, yes. So as the snowflakes fall, yes, there will be a gradual lowering of the body temperature and gradual effect on the body. Now, if as opposed to in the ER or in a medical setting, if I or another practitioner, and by the way, nurses and nurse practitioners and PAs also treat dog bite wounds. But if another practitioner, a practitioner gives the person an ice pack, they get immediate coldness and immediate significant change in temperature to that area.
Assume the weather is so cold that the cell phone battery on someone's iPhone begins to plummet regularly.
We don't
in
know how
degrees.
cold that
I have
means.
no idea.
Objection, Your Honor.
The objections to
Nobody
When
knows
you
what
came
that
to your
means.
conclusion, considering what you see in this picture, and Attorney Alessi was asking you about fragments from a broken taillight, did you know or consider that Mr. O'Keefe, sometime around when he incurred these wounds, had a piece of glass stuck in his nose?
Objection, Your Honor.
Sustained.
Finally, Dr. Russell, you said during your differential diagnosis you consider information, you either weigh it, accept it, or you distinguish it and you disregard it, correct?
Yes, generally.
During your differential diagnosis, you've referred to a number of different people studies, things that you haven't done yourself, but you've looked at other people's efforts. One of the things you looked at was the deputy medical examiner from the Forensic Pathology Investigations Division of the Armed Forces, a person by the name of John C. Walsh, correct?
Objection, Your Honor.
I'm going to allow that.
Does
Didn't
me
we
ask that
object
again,
to this
Dr. Russell?
before?
No, you don't have to ask it. I read that report, yes.
And John C. Walsh is a doctor, correct?
Yes, that's what it says.
And do you have any understanding that he works with the Forensic Pathology Investigations Division of the Armed Forces?
Yes, and therefore his practice may be limited in scope.
Well, you are trying to qualify what he doesn't do. Do you know if his practice is limited in scope?
Typically, the medical examiners that work for the armed forces often have a specific practice that is limited in scope.
Do you know anything about Mr. Walsh and his practice?
No.
Why do you find the need to try to undermine the extent of his authority before you know anything? Why is that important?
Objection.
Sustained.
You don't know what his scope and practice is, do you?
No, but I always look at where the person works that writes a report in terms of physicians and what their possible experiences are. Do they work in a medical examiner's office in Alaska or Hawaii or a big city or a little town? I look at those things.
When you considered his opinions after his review of these materials, did you consider when he offered in his report that multiple abrasions ranging in size from 2 to 3 millimeters up to 7 centimeters were documented on the decedent's right arm?
Yes.
These injuries do not photographically appear to be, nor are described as puncture bite wounds, and thus are highly unlikely to be the result of an animal bite attack. The abrasions are non-specific. Abrasions occur as the body moves over a blunt or rough surface such as a skinned knee. Did you read his report and consider it?
I did. However, I don't know if he's ever had any experience with dog bites examinations. So I had to consider that and weigh it.
I have no further questions. Thank you.
Looks like a decent answer to me. He's never treated a dog bite. His opinion
Dr.
doesn't mean
Russell,
much,
there were
does it?
questions with regard to highlighting of articles. Did I determine which parts were to be highlighted, or did I merely perform the function of highlighting the parts you wanted me to highlight because you didn't have a highlighting function with you traveling from California?
That is correct. It's the second one.
With regard to these articles, you mentioned a methodology in connection with them and pattern recognition methodology. Was it the purpose of citing this article to say that they're just like this situation, or was the purpose to say that there is a methodology in the literature to determine how to determine whether a wound is from a dog?
Objection.
Sustained is to the form.
Dr. Russell, what is the purpose? Let's just start with the Munnynck article that was talked about, because these articles were discussed. What was the purpose of you citing to those articles?
The purpose was to identify that pattern recognition is an important component in identifying wounds, and particularly in dog bite wounds. It did not mean that the victim had to have every single characteristic that was listed, and it just was focusing on things to look for. And the patterns, it was not just that there's one individual wound that's going to be diagnostic, but that there are patterns for the physician to look for.
In terms of Attorney Brennan asked, and so now with regard to the Pollock article, in terms of the Pollock article, is there any discussion in this article about whether the spectrum of injuries to which you can apply the mechanism and the methodology, is there anything in there about whether the pattern of injuries can be diverse or whether they're all the same? Does Pollock speak to that?
He does.
And what does Pollock say about whether or not the spectrum of possible injury forms when you apply this methodology can be diverse? What does he say?
Well, he mentions about the actual surface of the body that is impacted, if there's any curvature to that surface, if there's any structures underneath that would affect the bite. So yeah, those are, and if there was material or textiles or fabric that were in between the bite and the skin, and there were other factors too.
Okay, thank you. Now, lastly, what I'd like to cover is Attorney Brennan discussed the Dr. Walsh. May I approach, Your Honor?
Okay. Did you show Mr. Brennan?
He's the one who gave me it.
Okay. I didn't know what you had.
Yes, thank you. So may I hand to the witness?
Yes.
Why don't you just wait and see if he objects, Bev? You'll have to micromanage everything.
May I stand here, Your Honor?
Yes.
Thank you.
Just step back a little bit.
Yep. Start back as Dr. Russell, what I would like to do is to give the jury a fair representation. I'll withdraw it.
Commentary and I'd like to be heard.
Why don't you bring the reports over? Okay.
What? Now we got to have another sidebar? Because Hank opened the door and now Alessi wants to give a fair representation of what's in the report, but we can't have that. We can't have that. We have to cherry pick out just that one line that he read, that it's highly unlikely to be the result of a dog attack. The abrasions are non-specific, no punctures, etc. Highly unlikely to be the result of an attack. You know what I feel like would be, it just would have been so helpful in all of this. She's got a collection of dog bite photos that she's taken over the years. Show us the pattern. Wouldn't that have been helpful? a bunch of photos of multiple dog strikes, partial bites, things like that. If it's pattern recognition, show us the pattern. And then we'd be able to look and we'd be able to see, oh yeah, here's a pattern that I see on what you're saying is a known dog bite. I see that pattern, or I don't see that pattern over here on these photos of John. Wouldn't that be super helpful? I don't know if they probably wouldn't be substantively admissible, but I don't see why you couldn't use them as a chalk. If she went and prepared a little PowerPoint just like Welcher did and like Burgess did, why would you not be able to do that? It's part of your pattern recognition. Don't know. I guess we'll never know. Guys, we've almost survived another Brennon Cross. We're almost done. He may have to have the last word after this redirect. We'll just see. We'll just see. Maybe he'll get his last word at sidebar, and Bev will be like, "No, Mr. Alessi, of course you can't ask about Dr. Walsh's report just because Mr. Brennan brought that up on Re-cross. Just because he brought it up on Re-cross doesn't mean that you get to now follow up on that." It's so frustrating in this courtroom how you have to kind of put yourself in just bizarro world mindset. You can't have this straightforward, oh, here's what the law is and here's what the rules are and here's how, here's like the reasonable range of expectation you'd get from applying this rule to these circumstances, highly likely outcome, highly unlikely outcome, all of the stuff in the middle. You can't do that in here because we got to account for it's Bev's courtroom. She doesn't really give a shit about the law. She's not very good at interpreting, analyzing, dealing with the law. So it doesn't tend to really guide her at all. Instead, we have to just sort of try to mentally project, well, what does Bev want here? And then is she going to be able to find a way to justify that or not? And it's frustrating because it's so contrary to why we have law in the first place. We have the whole rule of law so that it's the same standards applied to everybody, applied in all circumstances. It doesn't matter who is sitting up on the bench. You're going to have the same general field of play in whatever court you appear in front of. That's why we have judges on the bench and not, royal ministers or something like that. So many sidebars. So many sidebars and so long. I wonder what the jury is doing while all this is going on. I haven't really seen any reports about what the jury has been up to today. Don't know if there's been anything else like that.
Yes.
Thank you. Yeah, proceed, Your Honor.
Yes.
Thank you. Dr. Russell, I am handing you this letter from Dr. Walsh, and what I am going to do, and you just tell me if I do it correctly, I'm just going to read 2 paragraphs, okay? And you just tell me if I'm reading it correctly. In totality, the injuries documented in the autopsy report and photographs are non-specific and may be the result of a variety of different mechanisms. No additional information was provided regarding the possible circumstances or events surrounding the death, the absence of additional information prohibits the attribution of injuries and contribution of findings to a specific underlying cause of death. Did I read that correctly?
Yes.
No further questions, Your Honor. Thank you, Dr. Russell.
Their own expert said you
Dr.
can't
Russell,
know
you
what
are all
caused the
set.
injuries.
Thank you.
I'm going to have this marked for identification.
Thank you.
Is it RRR for ID?
Thank you.
Oh, what now? Do we need to watch him bully Lucky Lochran next?
And the next witness is who?
Sorry, Your Honor.
Who's the next witness?
If I may, Your Honor.
Yes, just tell me the name because I need to know whether we need to go to sidebar first.
Officer Barros.
Okay, thank you.
Officer Barros.
Officer Redirect.
Just Machado, 19 minutes ago. Jury check. 1, looking at the string. 2, arms crossed with annoyed look. 3, looking extremely bored. 4, head going back and forth between parties. 5, looking at the notes of the juror on the side of him. 6, can't see the juror. 7, taking notes. 8, staring at Karen. 9, note taking. 10, looking at her notes. 11, looking at Alessi. 12, looking across the room. 13, expressionless and void of emotion. 14, looking at Russell. 15, taking notes. 16, chewing gum, head tilted.
All right, Mr. Jackson, you are all set.
Thank you, Your Honor. Good afternoon, sir. How are you?
Good afternoon, sir.
Could you please state your full name, spell your last name for the jurors, please?
Nicholas Barros, Barros,
And where do you currently work?
the town of Dighton, Dighton Police Department,
How long have you worked for the Dighton Police Department, sir?
since 2011.
And what's your position there currently?
Currently, I am a sergeant.
What's your duty assignment as a sergeant? What do you do?
I supervise the 4 to midnight shift.
We'll get to that in a little bit more detail in just a second. A couple of more foundational questions. How long have you been a police officer altogether?
Since 2011, so going 14 years.
And what education and training and background do you have that qualifies you to do your duties as a sergeant, a supervisor at the Dighton Police Department?
I completed the police academy. I hold a bachelor's degree in criminal justice. I've been to many trainings as a police officer and as a supervisor.
When did you get your bachelor's degree?
2012.
Is the Dighton Police Department an autonomous police department for the city? In other words, is it a branch of, say, for instance, Massachusetts State Police, or is it an autonomous department?
It's on its own.
Okay. It's not in any way connected to the Canton Police Department, I presume?
Correct.
Is it in any way connected to the Massachusetts State Police
It
Department?
is not.
As a supervisor, are part of your duties to oversee subordinate officers in their daily fare, whatever that may be?
Yes.
Does that include anything having to do with crime scene investigation?
To an extent.
Witness interviews?
No, that would be the Detective Bureau.
What about working and coordinating with detectives?
To an extent.
Collection of evidence or working with detectives as they collect evidence?
They would collect evidence.
Maintaining crime scene protocols, things of that nature?
Correct.
All right. As a sergeant with the Dighton Police Department, are you a trained observer?
I am.
Would you consider all of your subordinates, the patrol officers, day-to-day officers, are they also trained observers?
They are.
Is that part of policing?
It is.
Describe that a little bit for the jurors so we understand.
We are in the police academy. We're told to watch everything. It's our heads on a swivel. We are always looking because we don't know what the unknown is.
When you say you don't know, is it true that you don't necessarily know what might become relevant later that may be needed in court?
Correct.
I want to draw your attention to January of 2022, a few years ago. January 29th, 2022, did you have any, you personally, officer, did you have any personal relationship with the Canton Police Department?
I did not.
Did you have any personal relationship with a trooper from the Massachusetts State Police named Michael Proctor?
I did not.
Do you have any relationship with a person by the name of Brian Higgins, an ATF agent?
I did not.
Do you have any relationship with a Boston police officer known as Brian Albert?
I did not.
Did you know any of the witnesses or individuals involved in an ongoing investigation related to the death of Boston police officer John O'Keefe?
I did not.
On January 29th, 2022, did you receive some sort of a call to respond to a particular location? I don't want the address of the location. We'll get to that in a second. Did you receive some sort of a call in the afternoon?
I did.
Describe that for the jurors, please.
Around 2:30 in the afternoon, I received a call from the troopers assigned to the Norfolk District County DA's office in regards to a vehicle that was at a residence in the town of Dighton.
What were you asked to do? Why did you get that call?
The troopers said that they were coming into my jurisdiction, and as a courtesy, they wanted me to respond with them.
Is that sort of normal protocol? If you go into somebody else's jurisdiction, you let them know?
Yes.
So that was not necessarily unusual?
No.
About what time did you receive that first call?
The first call was around 2:30 in the afternoon.
Was there are logs kept of those kinds of things? If you get a call, you respond to location?
Yes.
At some point after you received that first call, did you receive any other call specifying a time of arrival for the MSP troopers, anything like that?
I did.
Describe that for us.
I got a second call around 3 p.m. From Trooper Michael Proctor stating that he was about 10 minutes away from the address in Dighton.
At the point that you spoke with Michael Proctor, had you ever spoken to him in your professional or personal capacity ever before?
Never.
Did you know the name? Did you know who he was?
I did not.
Complete stranger?
Complete stranger.
What time did you actually arrive at the residence?
I arrived at the residence, I believe it was 3:27 p.m.
Sergeant Barros, did you, I don't want the address, the cameras are rolling. Did you respond specifically to a residence in the city of Dighton?
Yes.
Did you at that time know who lived at that residence, who resided there?
I did.
How did you know that?
Early in the shift, when I came on at 8 a.m., the midnight shift, the outgoing shift, had told me that a resident of Dighton at that address had called looking for a ride to Brockton Hospital.
Who did you know at that time, or who did you believe at that time to live at the address that you are now responding to?
William Reed.
That was Reed, R-E-A-D?
Correct.
Okay. Did you know anything about his daughter at that time, or did you just know the name William Reed?
I just knew William Reed, the name.
At the time that Michael Proctor called you, did he say anything about what his intentions were once he arrived at the location?
Yes, his intention was to retrieve a vehicle that he said was involved in a homicide.
Did he specifically say to you at 3 o'clock-ish in the afternoon he intended to seize the vehicle?
I believe the first phone call, that was his intention.
Meaning all the way back to 2:30?
2:30 is when he first called me and said that they were coming to Dighton to retrieve a vehicle that occurred in a homicide in Canton.
And you understood that to mean what? Retrieve a vehicle?
Seize.
Thank you. What was your role once you arrived at the scene at the Reed household?
My role was Trooper Michael Proctor asked.
Once you arrived at the scene at the Reed household?
My role was Trooper Michael Proctor asked me to facilitate a tow to tow that vehicle.
Was that a private tow company?
Yes.
And when you say facilitate a tow, what does that mean?
He asked who we used for towing vehicles, and during that period of time, it was Diamond Towing.
Did Diamond Towing ultimately show up, a representative of that
They did.
tow company with a tow truck?
Correct.
A flatbed?
Yes.
Who was with Trooper Proctor when you arrived at the scene?
Sergeant Buchanan.
Had you ever met Sergeant Buchanan before?
Never.
Did you know him?
Nope.
Did you know him professionally or personally?
Never.
Had you ever spoken to him?
Never.
Ever? I'm so sorry. It's getting late in the day, and I guess I'm going too fast. Sorry, my fault. Let's start that just a little bit slower. Did you know him?
No.
Had you ever spoken to him before?
No.
Had you ever heard his name before?
No.
No relationship whatsoever?
None.
Same with Trooper Proctor?
Correct.
Once you arrived at the residence, did you have an opportunity to see the vehicle that was the focus of Trooper Proctor and Sergeant Buchanan's attention?
Yes, once I arrived and I parked my cruiser at the end of the driveway, I observed a black Lexus SUV in the driveway.
What were you driving?
I was driving a Ford F-150 police cruiser.
A police cruiser that's a Ford F-150?
Correct.
They have those?
Yes.
Cool. Were you in full uniform?
Full uniform.
Gun, badge, the whole works?
The whole works.
Did you ever go inside the house?
Briefly.
What was the circumstance of going inside the house?
I went inside to let the troopers know that the tow truck operator was there, and I also went in to ask how we're going to get the tow truck into the driveway because there was about a foot of snow.
Okay. That sort of answers my next question. Did you see whether or not Trooper Proctor and Sergeant Buchanan actually did go inside the residence?
Yes, they did.
For the bulk of the time that they were in the residence, where were you?
Outside the residence.
Were you with the black SUV?
I was in the garage speaking to the defendant's mother.
The defendant's mom?
Yes.
Janet? Okay.
Yes.
Where was the SUV at this point?
In the driveway.
Did you have an opportunity to see the SUV?
I did.
Did you walk all the way around it?
Not all the way around.
Did you see the rear end of it?
I did.
Did you make note of the rear end of it?
Yes.
How long would you say you were at the location in a position to observe the rear end of that SUV? 2 minutes, 20 minutes, something in between? Longer?
I would say not the entire time that I was there, but a good amount of time.
More than a glance?
Yes.
This is the afternoon of January 29th, 2022, correct?
Correct.
Before the vehicle had been seized formally by Trooper Proctor and Sergeant Buchanan, correct?
Correct.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight.
Can you describe for the juror, by the way, which taillight are we talking about?
The right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that description is?
There was, it was damaged, the taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you call it?
The piece was about maybe this big.
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere in there.
I want to show you a photo. Your Honor, with the court's permission, I would like to show Exhibit 13. It's been previously marked.
I think we're still in
Do you
the
see what's
realm of
depicted in this
ambiguity
photograph?
so far, but this
What does that appear to be?
clear
Just
it right
generally?
up.
The right rear taillight.
Of what?
The Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the taillight.
There it
the day I
is.
was there.
Can you do me a favor, Mr. Wolk? With the court's permission, could we zoom in on the right rear taillight, please?
Okay.
Do you see the condition of that taillight as it's depicted in this photo?
I do.
Sergeant Barros, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
Absolutely
What's
not.
different about this photo, sir?
That taillight is completely smashed out.
does it appear that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence?
Objection.
Sustained. Ask it differently, Mr. Jackson.
Of course.
Is it missing more?
Describe specifically, other than the fact that it's
Missing more
different,
plastic?
describe in detail for the jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there. Towards that right side where that large chunk is, that's what was missing.
I'm going to hand you a green laser pointer. If you can, there's two displays, one monitor directly in front of you and one to your right. If you could use the one to your right, it's a little easier on the jurors. Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
May I approach?
Yes.
How's Hank going to be an asshole to this
If the
cop?
entire taillight had been broken out as it's depicted in this photograph, would you have made note of that?
Objection.
Sustained.
Do you believe you would remember if the taillight, well, let me ask it a different way. The piece that you saw missing, but not completely damaged, is the reason that you use the phrase not completely damaged to highlight the fact that there was still more taillight attached to the vehicle that is depicted in this photo.
Objection.
Sustained.
We can take
It's
this
okay,
down.
Ellen. We get it. We get it.
As you sit here and recall back to that, your observations, and you observed this for over the course of how long would you say? How many minutes?
Probably 20 minutes or so.
You actually wrote a report about this, correct?
Correct.
And you documented your observations, correct?
Correct.
In your documented observations, did you use the phrase cracked but not completely damaged?
I did not.
Sustained.
You've testified previously,
I have.
about a year ago.
Yes.
Did you use the phrase cracked but not completely damaged then?
The objection sustained, Mr. Jackson.
Ultimately, was the black Lexus SUV towed and cleared from the scene?
It was.
Is it your responsibility or part of your responsibility to log the time that things like this happen, like for instance the SUV is taken away?
When I cleared from the scene, yes.
What time was that when you cleared the scene?
I believe it was 4:17 p.m.
Suffice it to say that SUV was not seized at a later time, correct?
Correct.
It was not seized at 5:30 p.m.?
No.
I'd like to show you another exhibit, if I could. This is Exhibit 105. Do you recognize this scene generally?
I do.
Do you recognize it as being, what do you recognize as being?
This is the Reed residence.
Do you see some vehicles in that still shot of the video?
I do.
Describe what you see.
That tow truck is diamond towing, and that other vehicle that's at the rear of that tow truck is the Lexus SUV.
If we could, with the court's permission, zoom in. It's high on the screen, correct?
What's that?
The vehicles are high on the screen as we're
Correct.
looking at it. Could we zoom in to the top left portion of the screen?
Okay.
Can we play this video?
Yes.
Thank you, Your Honor. Can you see what's depicted in the still image of that video right now?
I can.
I'm going to ask you if you'll turn to your right, concentrate on this area. This area here. Do you see what's depicted in that still image?
I do.
Does that appear to be a taillight?
Yes.
Does it look clear? Does it look like it's shining red?
Looks clear.
The portion that is intact, does that appear to be brighter red?
Correct.
And the photograph that I just showed you a second ago, is that red portion there?
Can you rephrase that?
Sure. Let's go back. You see the red?
Yes.
All right. Is that the condition of the taillight as you saw it on January 29th around 3:15 or 3:30 when you got to the location?
It was.
Let's go back to the other exhibit, please. Exhibit 13.
That was not your cue, camera guy.
Can we zoom in, please? Can you see that this entire area is now missing?
I can.
Sustained. Just ask it differently.
Sure. The area that I'm circling here, do you see any red lens in that area?
No.
Is that consistent, this photograph consistent with the condition of the taillight as you saw it on January 29th, 2022, at just after 3 o'clock in the afternoon?
Absolutely not.
Thank you.
Lights, please. Thank you. Mr. Brennan.
Thank you. Good afternoon, sir.
Good afternoon.
Have we met before?
We have not.
Do you still work in Dighton?
I do.
At the time you went to the Reed residence, you did not know the occupants?
I did not.
Since then, have you ever met or spoke to William Reed
Nope.
or the defendant?
Nope.
When you went there that day, it was at the request of the state police?
Correct.
When they asked you to come, it's a typical procedure for one law enforcement agency to contact local law enforcement agency?
Correct.
And part of the reason they do that is to bring in separate and independent law enforcement officer to the scene?
Yes.
Because it's your jurisdiction?
Correct.
And they called you before they got to Mr. Reed's house, didn't they?
Yes.
They told you what they were going to do and when they were going to do it?
Yes.
They didn't just show up at the Reed house and then you found out later. They invited you and informed you what the process was going to be.
I wouldn't say that they told me what the process was going to be.
When you got there, were the troopers already there or did they arrive after you?
The troopers were there.
Were they in the house or outside of the house when you got there?
They were outside in a pickup truck.
Did you see them get out of the pickup truck after you got there?
They got out after I identified themselves.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
Did you ever see them manipulate in any way that rear taillight of the defendant's Lexus?
I did not.
Did you see them do anything that was suspicious, inordinary, or unfairly remarkable relative to that car?
I did not.
When they spoke to you, they then went inside the house?
What do you mean by spoke to me?
After they introduced you introduced yourself to them, they went into the Reed house?
Yes.
And then they came out?
They came out much later.
And that vehicle was towed?
Correct.
At no time from when you got there until you left did you see anybody from the state police in any way tamper with that vehicle, did you?
I did not.
Your timeline's off, Hank.
When the vehicle was towed, do you know how long it took to take the vehicle from Dighton back to Canton?
How long?
Yes.
I do not.
You didn't escort it back.
I did not.
You had an opportunity to write a report in this case, didn't you?
I did.
And when you did, you had an opportunity to describe the damage to that taillight in any way you wanted to.
I did.
You could have gone into detail about size of the damage.
I could have.
You could have gone into detail about the shape of the damage.
I could have.
You could have gone into detail about the width of the damage.
I could have.
You could have taken photographs of the damage if you wanted to.
I could have.
In fact, there was
no kidding.
limitation on what you could have written in your report regarding the damage, was there?
No.
You write reports regularly, don't you?
I do.
You're trained at the academy. It's the best way to memorialize events.
Correct.
Because in time,
Here
the
you are
memory is
impeaching
not always as good
Lieutenant
later on than it
Proctor
is at that
again.
moment.
Correct.
What might be important or remarkable later might not be remarkable at the time you're making the observation.
Correct.
So you're taught at the academy to use as much detail as you can so that you can have an accurate memory later on.
Correct.
Because oftentimes, well, you respond to a number of different events and incidents, don't you?
I do.
You write a lot of reports.
Not necessarily now in this position that I'm in, but
Did you at the time?
at the time, correct.
Yeah. And so it's sometimes difficult to remember the details of all events, and you use the report to refresh your memory.
Correct.
When you wrote your report, and you could have put as much detail as you wanted, is it fair to say you only wrote one single line about the damage to the car?
Correct.
The vehicle had damage to the right rear taillight.
That's what I wrote.
Fair to say you didn't document that it was the size of a dollar bill. You didn't say that, did you?
No.
Or that it was 3 to 6 inches. You didn't mention that, did you?
No.
You didn't mention the placement of where the damage was.
To an extent, I did the right rear tail light.
Right rear taillight. You didn't indicate if it was on the side or on the back.
I did not.
You didn't provide any other details of your description when your memory was probably at its best. True?
True.
And would you agree that your memory that day was probably much more accurate than it is today?
I would not.
When you wrote the report, did you ever have an opportunity to write a supplement report if you wanted to give more detail?
I guess I could.
You didn't.
I did.
Inevitably, you were a witness at trial. I'm sorry, you were a witness at a prior proceeding in this case, weren't you?
Correct.
You came in and you swore under oath regarding your memory.
Correct.
And that was probably a year to a year and a half after you first made the observations which you reduced in writing in the police report.
Correct.
And when you made those observations, that was on January 29, 2022?
Correct.
When you came into court and you testified, that was on June 10, 2024.
If that was the date.
You were asked questions to use your best memory to describe the damage to that taillight last time you swore under oath to tell the truth, weren't you?
I don't think I was asked that.
What were you asked to describe the best you could the damage to that right rear taillight last time you were in court on June 10, 2024?
I don't think I was told to describe it in depth.
Were you asked questions about the damage to that rear taillight last time you were in court?
I was.
And when you described the damage, did you do your best of your ability to give as much detail as possible?
I did.
Did you qualify your memory at that time, saying to the best of my ability and recollection?
I did.
And when you qualify as a police officer with the best ability and recollection, that is recognizing that time had passed,
Time has passed, yep.
that you had a report, that you could refresh your memory.
Correct.
And did you refresh your memory with that report before you testified last time?
I did.
And when you qualified that it was to the best of your ability and recollection, that account for the fact that when you looked at the report, there was no detail other than your commentary in your report that the vehicle had damage to the right rear taillight.
Correct.
And so when you qualified, you were considering human factors like time had passed,
Correct.
that your report was respectfully scant,
Correct.
that you had heard a lot about this case since that point, hadn't you?
Correct.
And so considering your memory in June of 2024, when you qualified your answer, was it considering all of those different factors that had passed in between that time?
Can you rephrase that?
Yes. When you decided to qualify your answer and you said to the best ability and recollection, and then you went on to describe what you remember from the break of the taillight, the reason why you used that qualification to the best ability and recollection, is it because of those human factors that had passed?
It's because he's relying on his recollection.
And sir, since the time you came into court on June 10, 2024, have you spoken to anybody from the defense about this case?
Yes.
How many times have you spoken to somebody from the defense about this case after you gave your testimony on June 10, 2024?
Once.
Where did you speak? Who did you speak to?
Attorney Jackson,
Did you speak to him in person or on the phone?
in person.
Okay, don't. Okay. You're not hesitating, are you?
No,
Where did you speak to him in person?
at his hotel.
How did you know where Attorney Jackson was staying?
He told me.
Did you find it odd to go visit an attorney at their hotel and talk about a case?
It was in their conference room.
Find it odd. Go to somebody's hotel to speak to them about a case.
No,
Without saying the name of the hotel, where was the hotel located?
Boston.
And where were you located?
I don't feel comfortable telling you.
Sorry. Did you have to drive?
I did.
So you took the effort to go to see Mr. Jackson at his request. Did you know who Mr. Jackson was?
I did.
On TV?
I did.
When you went there to the hotel in the conference room, who else was there?
Attorney Little.
Okay. Who else?
I'm not sure of the other gentleman's name.
Was one of the gentlemen right here on the end?
The
The good-looking one down there on the right?
No, it was not.
Somebody else?
Somebody else.
Okay. Was there anybody else there?
No.
When you were in that conference room, were you shown your police report?
No.
Were you shown your testimony from the last time you came to the court?
No.
The photograph of the vehicle in the Sally Port, the vehicle with the missing glass, were you shown that?
No.
Had you ever seen that photo before?
Of course.
And you saw it at the last event you testified at, right?
Correct.
And when you were shown that photo during your prior testimony, you never,
He
ever,
wasn't shown it during prior testimony.
ever suggested that that was in any way different than what you had seen in Dighton.
Nobody asked me that.
When you were asked to describe the damage, and you were shown that photograph, you never, ever suggested that there was a difference in the damage as you see it in that photo compared to what you remember, did you?
I don't think anybody asked me to describe that.
Did you ever make a note or say anything that is dissimilar to what you remember at the last event that you testified at?
I testified that that was not the tail light the day that I saw it.
That's when you testified at the last event?
Did.
Yes?
Yes.
You said that photo does not depict what you saw?
Correct.
Yes?
Yes.
And when you testified to that at the last event, who was asking you that question?
District Attorney Lally.
Okay. And you remember making that comment under oath?
I do.
Do you remember that as well as your memory about what the taillight looked like back in Dighton?
I do.
When you were asked questions about that taillight, you had described the taillight as not completely damaged, it was cracked, and there was a piece missing but not completely damaged. Remember that testimony?
I do.
And is that accurate testimony?
It's accurate.
So, in your memory, in June 10, 2024, was that vehicle's rear taillight had a piece missing, correct?
Correct.
You said that your memory about the damage to the taillight, as you recall it when you were in Dighton back on January 29, 2022, you said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
He wasn't shown the taillight photo.
Have you ever read your testimony from your last proceeding?
Never.
But you have a specific memory of discussing that specific photograph? Yes?
Yes.
Any approach?
Yes.
I'm going to show you your transcript of sworn testimony on June 10, 2024. And when you reflect on your memory, understanding some time has passed, you've testified that your memory of distinguishing that photo is reflected in your testimony, right?
Objection.
So ask the question differently.
Okay. Your memory is that you discussed the distinction between that photo and what you saw at the last time you testified.
Objection.
I'm going to allow that.
And as you take a look at that, could you show me anywhere in your testimony, anywhere, where you made any statement about that photo being inconsistent with what you saw in Dighton on January 29, 2022?
It's not in there.
Can I approach?
Yes.
I can put it back on. Thank you. So respectfully, sir, your memory about distinguishing that photo is not as you thought it was and claimed it was in this transcript, correct?
Correct.
And that's not a matter of you trying to fool anybody or lying, is it?
No.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example why at the academy they teach you when you write reports to be as detailed as you can. To accommodate the fact that memories can fade. Right?
Correct.
Memories can change.
I know what I saw, and that wasn't it.
Well, that's not what I'm asking you, because you just testified that under oath you had looked at that photo and distinguished it. But that's not accurate, is it?
No.
And so it's not a matter of you perjuring yourself or lying, it's a matter of difficulties with memory, wouldn't you say?
Yeah. Correct.
And you share those same difficulties with memory as many other witnesses.
Objection.
Sustained.
You have, as is human nature, difficulties with memory at times, correct?
Correct.
And so that very certain memory you had about your testimony last year, fair to say that never happened.
Correct.
You were simply mistaken, weren't you? Or something more, please tell me.
Correct.
When you met with the attorneys in Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, months.
Those things all could have been accomplished by phone, correct?
Could have.
So in the face-to-face meeting, what did you talk about?
Objection.
I'm going to allow it.
Over here. What did you talk about?
Excuse me.
So that, okay.
Over here.
I don't know why there's an implication that they had a different conversation because it was in person than because it's on phone. Is there like some rule that only some things get discussed in person and other things get discussed on the phone? Not at all clear to me that that's the case. I don't know. Hank did damage there. This was the same problem. The irony of it, is because he can't quite do damage to the defense without also doing damage to yourself. Because now you've just like re-emphasized the same problem we had with Timothy Nuttall, your star witness, the one that you led off with, the one that you told you phrased your whole opening around like the story of Timothy Nuttall arriving at the scene and the chaos when it opened, and then I hit him. But he also didn't he have a very vivid memory that turned out to be not true at all. Unfortunate, because yeah, that I think that did do some damage. Not completely damaged, cracked with a piece missing, but not completely damaged. It's not obviously inconsistent at all with what he's saying today, but no. Last trial, he wasn't shown the Sally port. And we've talked about that several times. He wasn't shown that photo or asked about it.
You told us there was some background about being subpoenaed and time. Substantively, what did you talk about with the attorneys when you met them at their hotel conference room?
Other than that, they didn't go over my testimony. We just spoke about that I said that the taillight was not completely damaged.
Okay. Did you get into any detail about the conversation about your testimony today?
No.
When did you meet with them?
I don't have the date.
Last year, this year?
I don't have the date. I don't recall the date.
I'm not looking for a date, just the general year frame. Last year, this year?
Probably we're in June. Early in this year.
Are you having some difficulty with memory about that as well?
On a certain date, yes.
Not a certain date. Was it this year probably, or do you think you met them this year?
This year.
Do you know what month you met them this year?
I wouldn't know the month.
Certainly you talked about this issue with the taillight, didn't you?
Yes.
When you talked about the issue with the taillight, did anybody from the defense offer you any opinions or information?
No.
Did they ask you questions about it?
No.
So you went to a meeting in a Boston hotel in a conference room, and nobody talked about the taillight? Objection.
I'm going to allow it.
That's literally not what he just said. He said he talked about it.
I'll ask another question instead. Have you had an opportunity to see other evidence of that taillight being damaged that morning before you saw it?
On the 29th of January? No.
The video that was shown to you with the tow truck, had you seen that before today?
Yes.
Who showed it to you?
From seeing it on TV and...
Was it shown to you during your conference room meeting at the hotel?
It was not.
So you've looked and studied and watched this case a little bit?
With all due respect, sir, I don't live under a rock. It's all over social media and the news. You can't avoid it.
I'm not criticizing you or discounting you. I'm just asking you. Have you been exposed to this case?
Well, except you are.
Observations in Dighton on January 29, 2022.
I have.
Have you seen other video footage and evidence about that taillight since January 29, 2022?
I have.
Have you seen other information since you last testified last summer about the taillight?
I have.
And seeing this extraneous information, this other information, do you think that played a part in some of your difficult memory? Objection.
I'm going to allow that.
Your Honor, can we approach?
Okay.
Yeah, it's speculative. It's beyond his this is a ridiculous line of questioning. False memory, trying to get him to say false memory. trying to get him to recant. Now we see how they do it, don't we? Now we see exactly what they did to Officer Dever. Lean on her. You sure you didn't get more information after the fact? You sure that didn't maybe influence what you thought? You sure about that? But he's got to try to discredit this guy because, of course, this guy is a cop. This guy is supposed to be on their side. Why do you think he wrote his report as vague as he did? He's supposed to be on their side. The fact he isn't, that's a problem for him.
You've seen quite a bit of information about this case and the issue regarding the taillights since you first made the observations back in 2022. Wouldn't that be fair to say?
It would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
I guess.
No, I don't want you to guess. You testified that you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory as you testified in direct examination under oath and you tried your best about things that just didn't happen, right?
Right.
Would you agree that you have some difficulty with your memory?
I'd agree.
I want to show you some evidence of that taillight before you had a chance to see it in Dighton. If we could have the ring video at 5:07:58, please. Have you seen this video before, sir?
I have.
Okay. Before you proceed, Ms. Gilman, have you seen this on social media?
The news, social media.
Has anybody else shown you this video?
No.
How many times do you think you've been exposed to this video?
Too many to count.
Because you were involved in this case, and I'm going to say as a predicate, there were no orders for you not to look at anything. I'm not suggesting any impropriety. But because you were involved in this case and issues regarding the taillight, do you think you had a particular interest when things like this came on TV and social media to take a look to compare it to your memory?
Did I have a
Yes.
particular interest? No, I didn't follow this case
But you've seen this many, many times.
because of what is out there on social media and the news.
I understand. I understand. Could we play this, please? Thank you. Stop, please. Do you see that white part of the back rear right taillight?
Objection.
I'm going to allow it.
You see that? Sir?
Can you zoom in a little bit more? I can.
You can or cannot?
I can.
You can. C-A-N can?
Yes.
Thank you. Continue, please. Continue. Stop. Can you bring it back and stop?
A lot of red there,
Back more.
except for that little piece on the side.
Open right there. Zoom, please. You see, sir?
You see heavily pixelated stuff.
Sir?
I can see that.
Is that consistent with the damage that you saw when you looked at that Lexus in Dighton hours later?
Consistent.
Can we go to Exhibit 10, please? And before you show it, I have a couple questions. This was a snowstorm, kind of like a blizzard that day.
Yes.
And when you got to the driveway, it had not been shoveled or plowed.
Correct.
There was quite a bit of snow accumulating and ongoing.
Yes.
And there was snow coming down on top of everything, the ground, the streets, the cars, correct?
Correct.
And snow was accumulating, did you notice, on cars and packing onto cars?
Yes.
When you looked at this house, when you looked at the defendant's Lexus in Dighton, you didn't go over and scoop out any of the snow that was in that broken taillight, did you?
I did not.
You didn't try to remove any snow off it or that was accumulated inside of it?
I did not.
And the snow there was snow packed on that car, wasn't there?
There was.
There was snow packed around the light, wasn't it?
There was.
And would you agree with the snow, since you didn't tamper with it or try to remove anything, that could impede your ability to accurately observe the depth of the damage? Would you agree with that?
I would.
If we could have Exhibit 10, please. Does that appear to be the same Lexus you looked at when it was in Dighton? And it's a far view, so I don't want you to guess. If you're not sure, you can tell me.
I wouldn't be able to tell you. I can't.
Please, Exhibit 11, please. Can you take a look to the right? You see that right tail light, the white part?
I can.
Missing, yes?
Looks like snow is packed on it.
Does it look like there's a red tail light there?
Does not.
This is before you saw the car in Dighton? Do you know that, or you wouldn't know that?
That doesn't look like the Reed's driveway.
Do you know if this photograph was taken before or after you made your observations in Dighton?
I do not.
The right rear taillight and the missing parts there, is that consistent with what you saw around 3:27 on January 29, 2022?
Yes.
I have no further questions.
Okay, lights on, please, Mr. Jackson.
Thank you, Your Honor. I'll be brief. Sergeant, did you celebrate your birthday 2 years ago?
I did.
Kind of a big deal. It's your birthday, right?
Yes.
What day of the week was your birthday 2 years ago?
No idea.
Do you have a difficult memory, sir?
Yes.
The fact that you had a birthday, you recall, correct?
Correct.
The day of the week of that birthday may fall by the wayside in your mind, right?
Right.
Sustain this to the form, Mr. Jackson, is your
course.
witness.
The fact that you can't remember the day of the week, does that mean that you have a bad memory?
Objection.
I'm going to allow it.
Correct.
You remember being in Dighton, correct? Being called out to Dighton, to the residents of the Reeds.
Correct.
Do you remember the time?
I do.
Do you remember the weather?
I do.
Do you remember who you met there?
I do.
Do you remember the conversations that you had?
I do.
Do you remember the phone calls that you received?
I do.
The first one?
I do.
The second one?
I do.
Do you remember being in the garage and speaking
Putting
with
that on the
someone?
I do.
report.
Do you remember it was this lady, pretty lady right here in the blue?
I do.
Do you remember meeting Mr. Reed?
Briefly.
Handsome gentleman with the gold tie?
I do.
You remember all that? Mm-hmm. Do you remember the SUV?
I do.
Do you remember the condition of the taillight?
I do.
You were asked whether or not you saw Trooper Proctor in any way manipulate that right rear taillight while it was out at Dighton, while you were there, correct?
Correct.
You said no. Honestly, I never saw him touch it, right?
Correct.
Were you in the Sally Port in Canton PD? I'm sorry, in Canton, in the Sally Port at the police station
I wasn't.
at 5:30 p.m.?
Objection.
Sustain.
At any point, did you ever go to the Sally Port at Canton PD that day?
I did not.
Do you have any idea what did or didn't happen inside the Sally Port?
Objection.
Sustain.
You were asked by Mr. Brennan, you could have taken photos had you wanted to, correct?
Correct.
And certainly you could have, right?
Correct.
So
Was
could a
that your
proctor?
vehicle that was being seized?
No.
You were simply there to assist another officer, right?
Objection.
The form, Mr. Jackson.
Of course. What were you there to do?
Just to assist another agency.
Would it have been normal protocol for you to photograph that vehicle?
No.
Did you see Trooper Proctor photograph the vehicle?
No.
Did you see Sergeant Buchanan photograph the vehicle?
No.
By the way, you and I did meet once before, correct?
Correct.
Was that before or after you testified last year at another hearing?
After.
And you were called by whom last year at the other hearing? The defense or the Commonwealth?
The Commonwealth.
You testified for them?
Correct.
So that's stricken. It's beyond the scope.
Did the Commonwealth ever contact you after your testimony at the hearing last year?
They did not.
Did they ever call you on the telephone?
After?
Correct.
No.
Did they ever send you a subpoena?
No.
And you testified last year that the taillight was cracked but not, or damaged but not completely broken, correct?
Sustained.
You and I met in a hotel in a conference room, correct?
Correct.
Anything sketchy or nefarious about that?
No.
Did I introduce myself to you?
You did.
You happen to know I live in Los Angeles?
Correct.
I don't have a house, right?
Correct.
I don't have an office out here, correct?
Objection.
Sustained.
Do you know whether or not I have an office?
I do not.
Did you and I ever speak, ever, before your testimony last year?
No.
Did I ever tell you how I wanted you to testify?
No.
Did I ever tell you what to say?
No.
Did I show you any testimony?
No.
Did I play you any video?
No.
Did I show you a single photograph?
No.
During that conversation, did you tell me how to subpoena you?
I did.
Did you tell me where the subpoena should be directed?
I did.
Did you tell me your vacation schedule?
I did.
Did you tell me your availability and willingness to testify?
I did.
Did we talk about any other thing of substance other than that and whether or not you recalled what your testimony was from last year?
That was all we talked about.
As you sit here, Sergeant Barros, do you have any difficulty recalling what the condition of that taillight was on January 29th, 2022 at about 3 or 3:15 in the afternoon when you saw the view? Any
No.
difficulty whatsoever?
No.
You remember the condition of that taillight?
I do.
Was the condition of that taillight the same as the photo that I showed you on my direct examination?
No.
Okay, that's all.
You would agree that your memory has changed since last time you testified in this courthouse?
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with your memory of what you saw in Dighton on January 29, 2022?
Objection.
I'm going to allow it. It was opened
That's
up.
not evidence.
It was opened up.
Is it consistent with what you saw on January 29, 2022?
It is.
Thank you.
All right, Sergeant, you are all set. So
Thank you.
Quiet, please.
All right, so jurors, I know I need to talk to the lawyers about a couple of things, so this seems like a good spot to just send you home for the day rather than bringing you out witnessing. So those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be careful with your social media. Remember, tomorrow's a half a day, we'll finish by 1. Okay? Thank you.
All rise for the court, please.
Tomorrow's a half day. We'll finish by 1. Okay. I have a feeling when Bev said we had a full week that her definition of a full week is not the same as my definition of a full week. Half day tomorrow. So are we going to argue some motions now? You were just starting to look at the reconsideration of Easter.
So there have been some motions, I think, piling up. Two I have not had a chance to read yet, maybe more. Commonwealth's motion for reciprocal discovery, and then the defendant put in writing about the discovery from Aperture. I've not had a chance to read the prosecutor's opposition. I'd like to do all that before I hear you on that. But the only one that I did read is the reciprocal discovery. Mr. Yannetti, are you examining both Brian Loughran and Karina Kolakithis?
Yes, and there are 3 issues that I believe we should dispatch with today.
All right, so why don't you, sure, I have time, I just don't know what you're talking about.
May we approach?
Sure.
Don't know why we gotta do this off the record. So 3 issues about Lucky Loughran and Karina Kolakithis that he wants to work out before calling them. Annoying that we don't get to hear what the problems are. Not real clear why we shouldn't be able to know that. So I guess, we're just waiting to see if anything is going to be argued. We do have the 2 new motions filed. Reconsider Easter, give the missing witness instruction, and allow argument. That one isn't particularly pressing because they're not in a position to argue until closing. And the instruction will be given or not right around the time of closing. Pretty sure I remember in Massachusetts, they give the closing first and then the instructions, or it's like they split up the instructions and you get a couple of them before closing and then the instructions on the law, which has always seemed a little bit backwards to me. But I know different places do it differently. In Washington, we instruct and then you go and do your argument. And part of the reason why is because your argument's going to be based on the law. And so if the jury hasn't been told what the law is, they don't really have anything, to work with to gauge your argument or not. But other places do it differently, have you argue and then tell you the law afterwards. And that's kind of my recollection of how it was in Massachusetts. There was some that go before and then the argument and then some after. But bottom line, that particular issue is not pressing until the defense rests and the Commonwealth rebuttal is done. That's not right on the horizon. Michael Easter, however, in reconsidering that is a little bit more time sensitive because at the very least, that needs to be decided before the defense rests. We have no idea at this point when that is. We know we got Lucky Loughran and Karina Kolakithis coming up. But some issues got to be sorted out with them that we don't get to know what they are, apparently. I don't know. Don't know. Oh, I see. I guess Turtle Boy again has some information. Turtle Boy says he is receiving reports. He has received reports that Karina Kolakithis is going to testify that Jen McCabe told her that they have a ring camera video of the accident, basically to try to turn her against Karen Reed. So it may relate to that. If this is obviously new information, they didn't bring this out in the first trial. There may be a need or a desire on the part of the defense to add some context here, which is the initial media reports that were coming out about the case, where the media was told the police have ring camera video. And we've talked about this a couple times too, how that particular statement in and of itself is true, but the way it's presented in these reports are extremely misleading, because it sounds like what they're saying is that they have ring camera video of Karen hitting John with her car, when in reality they just have ring camera video that they got from John's house that shows nothing at all, shows nothing like that. So the defense may want to have some context for that. Remember how all that ties in with the group chat as well. This is the same time frame where Nicole and Jen and Matt and Brian, and there might be others too, all on that group chat, talking about, Carrie's telling them everything. We passed her the phone, all that kind of thing. There was the conversation that they had about the media, the Channel 4 being at D&E. And, tell them the guy never came in the house. This is in the same time period as those reports coming out about the police have ring camera video that they're going to be able to use. And so there's an inference here I'm sure the defense would like to draw that this is sourced to Jen McCabe and the same folks on the group chat. They're just putting misinformation out there to try to target Karen. And so this overlap in this information, if it's out there in the media while in the same time frame, while this group chat is talking about what information should go to the media and so forth, and she's also feeding the same story, behind the scenes to Karina Kolakithas, doesn't really look good in terms of just it looks like damage control. It does look dishonest. They don't in fact have ring camera video of a collision, or we probably wouldn't be having a trial right now. I'm sure is what they foresaw that on the group test too, group chat too. It would be quite an episode if she didn't take a plea. So that could very well be what they're talking about vis-a-vis Karina Kolakithas. If this is new information relating to something she was told by Jen McCabe. Something she's told by Jen McCabe is potentially hearsay, right? Instantly, lawyer, as soon as you hear I was told or I heard, whatever, boom, hearsay. Okay, so now what? Does it fall into an exception? Is it testimony? Yada, yada. Okay, it's not being offered against Karen, so we don't have to worry about a confrontation problem. But now, is it hearsay? Is it being offered for the truth of what it says? Is it being offered to prove that there is in fact ring camera video? No, it isn't. It's being offered to prove Jen McCabe, her state of mind and her duplicity in, trying to frame Karen Reed, trying to shift blame onto Karen by, fabricating, or at the very best, repeating unsubstantiated gossip. I think that's really the best kind of cast you can put on something like that. The very best case scenario, she is reporting unsubstantiated gossip that, as it turns out, could not be further from the truth. But it's not offered for the truth, so it's not hearsay. So to the extent that is the concern, should be able to resolve that one pretty quickly. That one shouldn't cause us much in the way of a struggle. Doesn't come up with is it a prior inconsistent statement? Have they laid the foundation to impeach Jen McCabe? None of this is impeachment. This is just completely independent source of evidence about Jen McCabe and her credibility that may be one of the issues. If they could be arguing this is a specific instance of dishonesty. You don't usually get to do that to challenge a witness's credibility. Why don't we just pull up the rule? Got to find it. Witness's character for truthfulness or untruthfulness. Here we go. This could be part of what they're dealing with. This is, I'm just going to go ahead and put it on the screen because why not? We're waiting for them anyway. Section 608, witness's character for truthfulness or untruthfulness. This is dealing with specific forms of impeachment. You can bring reputation evidence as a character for truthfulness or untruthfulness, but only after their character has been attacked. This is the one that's at issue. Specific instances of conduct. You cannot. Specific instances of misconduct showing the witness to be untruthful are not admissible for the purpose of attacking the witness's credibility. So that might be what Hank is arguing about it. That this is like a backdoor, backdoor way to present a specific instance of challenging Jen McCabe's credibility. They would have to have an alternate purpose. It's not specifically dealing with credibility. It's going to what? Her guilty knowledge, consciousness of guilt. I don't know. It definitely reads more consciousness of guilt if we can show that the rumor originated with her. But if she's just repeating a rumor, then maybe it just tends to show she's a gossip. Frankly, the record, probably bears out at least to some extent anyway. She's the one at the middle of all the communications, isn't she? She's the one that's busy talking to all the cops. So those are what I anticipate they're struggling with issue-wise. If that Turtle Boy's report is correct, and she's got this information about Jen McCabe. Jen McCabe tells her they have this on Ring camera video. They can, shows Karen hitting John or whatever. That could be what we're dealing with. We're sorting out, okay, it's not hearsay. It's not being offered for a hearsay purpose, but does that mean it's a proper purpose? Is this being used to implicitly impeach Jen McCabe's credibility, or is there some other purpose for which it's being used that is allowed? Lucky Loughran, no idea what we're talking about up at the stand vis-a-vis Lucky Loughran. Just know that there are issues that they have to sort out. While I'm thinking about it too, guys, I was like, I had to pull this up. I'm just going to share the whole tab because I've never heard of a scissor bite being referred to as a mechanism. The scissor bite is it's how the teeth overlap. It's how they lock in like this. The canines, one in front of the other, and they overlap each other, and then the incisors, the top ones sit over the bottom. See, I learned about this because my very first dog, my very first Vizsla that we got, he was supposed to be a show dog. And it turns out that he wasn't going to really be very good as a show dog because he was extraordinarily handsome, but he had a slight overbite. His bite was not correct. His lower teeth, overlapped very slightly over the upper teeth, instead of like you see in this picture. But everything else the overlap, the canines and so forth. That is what I have always understood to be a scissor bite. So the AI says in dogs, a normal or ideal bite is often referred to as a scissor bite. This means the upper incisors, front teeth, slightly overlap the lower incisors, and the lower canine teeth fit between the upper canine and the lateral incisor. This bite pattern with the upper jaw slightly longer than the lower is considered functional and helps prevent problems with wear and tear on the teeth. So when they talk about scissor bite, they're talking about bite in terms of dentition, in terms of the mouth, the dental pattern. They're not talking about bite as in an action that you engage in. That's my understanding. So I got very confused with that testimony and where the kind of misunderstanding, if it is, just maybe equivocation about scissor bite came in. I couldn't tell if it was the article. I couldn't tell if it was Dr. Russell, but I'm just like, this is not how I've ever heard scissor bite referred to before. Looks like they are done, but we will verify. Yeah, looks like we're pretty good and done. So I will take it off the screen, make sure it's mute. Well, so not a extremely long section since we came back after lunch, just finished up with that redirect and then recross and then redirect of Dr. Russell. Didn't really see anything. Didn't really see anything in that kind of jumped out as, especially distinct from what we dealt with in direct or on cross. Just talked more about the studies. She's the one who said the scissor bite was the scissor activity. I don't know that that's what that means, but I mean, either way, I thought it has to do with the teeth. But walked through all these different studies. I think overall, it's very annoying to watch. I mean, Hank Brennan had a pretty good day. There isn't really a way around that. But I think he had far more success with Officer Barros than he had with Dr. Russell. Dr. Russell was perfectly happy to disagree, with the I mean, it's not even insinuations really that he was making, because he'll just come out and explicitly say, your opinion is completely uninformed, isn't it? And she's like, no, I disagree. So I think she did good about holding her ground and, not getting upset at the rudeness of the treatment she was getting that she certainly did not deserve. But then, things like, well, did you understand it was going at 24 miles an hour? It doesn't matter, because she's treated all of these injuries in the ER, which is the basis of her experience, the visual recognition of the injuries, not identifying, not reconstructing, not imagining a scenario that led to the injury. She deals with the injury when it's already presented. That's what she's seen thousands of. So most of the time in the ER, she has no idea what the speed is. She doesn't know what the movement is or the position is. She's still able to recognize what injuries they have depending on the types of complaints they come into the ER with. The ice is not the same as lying in the snow. That I knew he was going there. I knew he was going there. Of course, there's no Amica cream, so it would be ice. Why ice? Ice reduces swelling. Ice reduces swelling. But yeah, if you pack it on your arm like immediately or whatever, it might reduce swelling. But you know, cat's track of snow around your body, it's going to melt when it hits your body. Your body is going to continue to go through those inflammatory and hemorrhage types of actions until there's enough snow or ice there to slow them. And presumably that would give some time for bruises to develop, hemorrhages to develop. I mean, you would think. We finally did hear about John Walsh. He doesn't think that it was a dog attack, but she doesn't know if he's ever had any experience with looking at dog bites. Seems like a pretty good point to me. I have never handled a patent application. Never handled a patent application. I would have no idea what that process looks like, what to expect from it. Nothing at all. And so if someone were to ask me, if someone were to give me a document and be like, Andrea, is that a patent application? I think other than like if it says on it patent application, I'm not going to know. I'm not going to know. Let alone, you know, if it's like, God, is this a good patent? Is this going to win? No idea where to go. It's outside of my experience. I'll talk to you about criminal cases every day of the week. But you don't have experience in something like that. Don't know how good of an opinion you're going to have. I mean, I could even take it to immigration. I have to know a little bit about immigration because there are consequences of criminal convictions and criminal charges and stuff like that. There can be immigration consequences. I have to be somewhat familiar with it. Does that mean I'd be able to walk into immigration court and know which way is right and which way is left? No, I'm not going to know what's happening. I'm not going to know what to expect. I don't know what to predict. Don't know what likely outcomes are. It's just outside of my experience. So I thought that that's a good and important distinction to make. Of course, you probably wouldn't recognize dog bites if you haven't seen very many dog bites. But if you've seen a lot of dog bites, yeah, seems like you'd be more likely to recognize them. I would love to be able to see her collection of photos and show us the pattern that you're describing. It's pattern recognition. So show us the pattern, show us examples of that pattern. But we didn't get to see that, whether because they just didn't solicit that, didn't try to seek that out, whether they tried and it wasn't allowed, no idea. But we don't get to see that. And it's unfortunate because I do think sometimes, pictures are very telling. Pictures can help you understand things in a way that words can have a hard time doing. So would have liked that, but doesn't seem to be on the table here. So then we got Nicholas Barros, who we do remember from the first trial. Right off the bat, his cooperation, his cooperativeness with the defense was pretty clear. He wasn't really like that in the first trial. He seemed, I think, not like closed off, not hostile. He definitely wasn't hostile, but just very reserved, very cautious, doesn't want to say very much, just going to answer, the minimal, and that's that. He did seem more kind of cooperative this time. And I think the biggest example of that is when we go and show him the photo of the taillight and ask him in the Sally Port, is that what it was? Absolutely not the condition of the taillight when he saw it. Absolutely not. Not just, no, not it. Absolutely not. Very definitive and no question in his mind. He describes the particulars. Just this part over on the side is where a piece was missing. The stuff in the middle was completely intact. But then we went through cross-exam. He was doing pretty well, but then he remembered. He had this remembrance, this memory of testifying in the first trial and being confronted with that same photograph and saying it wasn't like that. And it didn't happen, guys. That didn't happen in the first trial. It didn't happen. We've talked about it many times. He was never shown the photo. It was that that question that's too dangerous for either side to ask, so they didn't. This year they did, and they got the answer, but hadn't done that before. Hadn't done that the first time you testified. So yeah, that's damaging. It's damaging to, you know, have a memory of something like that, that isn't correct. So I think that's really all, you know, that's all Brennan achieved, but that's enough. I mean, that's pretty significant. He agreed that everything that he's seen since the taillight, since he first observed the taillight back in 2022, he agrees. Guess it might have impacted his memory. So, Mr. Jackson, you know, tried to redirect it, pointed out all the other details he remembered. It would have been nice to tie that to what's in his report. You know, Mr. Brennan is tying it to what's in his report. You didn't put it in your report, so could have changed. So if he's got other memories of things that are also not in his report, you know, but are accurately reflecting what happened, is it in his report that Buchanan and Proctor were sitting in the truck when he got there? Is it in his report that he went in the garage, that he talked to Mrs. Reed, that they were in the house, that it was, you know, a while that they were in the house, that he waited outside, that he observed the car for about 20 minutes? Like, is any of this other stuff in the report? Might have helped to tie it into that. Just to be clear, he's allowed to have memories of things that are not in his report. He is allowed. Now, you can question it, but it's not like a rule that if it's not in your report, you can't possibly remember it. Cops remember stuff not in their reports all the time. Pointed out, I mean, I think not obviously directly, but just through the questioning, whole line of questioning from Mr. Brennan about, well, you didn't write it in your report. You didn't take a photograph of it. No, Hank, he didn't take a photograph of it. But your guys did, of course, didn't they? Oh, wait, no. Oh, wait, no, I guess they didn't either, did they? And it was their car, their murder weapon. They already knew they were seizing it before they even got there. When they called at 2:30, they already knew they were seizing it. Already knew, in their opinion, it was involved in a homicide before they ever talked to Karen. So, who exactly should have been photographing that vehicle in the driveway? I mean, I think with a lot of this stuff, the problem is that if it washes out at neutral, then you have to hold neutral against the Commonwealth, because the Commonwealth is who has the burden of proof. So if the defense guy didn't take a photograph of it and the prosecution guy didn't take a photo of it, whose problem is that? It's the prosecution's problem, because it's the prosecution with the burden to prove condition of the taillight. So that was pretty much it for our afternoon. And now Bev's not reading the motions, but yes, there are some. And so with that, why don't we go ahead and finish where we were at, looking at Michael Easter and his motion, the motion to reconsider. Let me go ahead and get this back up. Here it is. This is probably the most visible. So, you know, I'm skeptical that they are going to get the relief that they're asking for, but I want to see where we get. So where we'd been at, there's case law, okay, as set forth in Commonwealth versus Reynolds. Defense should not be forced to accept the Commonwealth witnesses' testimony regarding what constitutes standard policies and procedures based on what they are willing to admit. In this federal case, the court noted that just because the defendant could have attacked the investigation solely through cross-examination, this did not preclude the defendant from introducing expert testimony on the issue. It's a shame that this is just a trial court decision from the Southern District of Ohio. Doesn't have precedential value, but surely that's persuasive. This was such a terrible ruling in the first place because the presumption is if the evidence is relevant and helpful that you get to present it. It's not we have to point at something in the law that says I can. I point at the rule that says relevant evidence is admissible. I point at the Bowden cases that says you can present evidence on the insufficiency of the investigation. The burden is to point to where the law says you can't do that, particularly when it comes to the defendant offering evidence in defense. Just that little constitutional right that you have to not be railroaded by the state. You do actually get to put on a defense. So terrible ruling in the first place. Really no question about that. But given that was her rationale, it's kind of a shame we don't have something binding, but I don't think we do. That was the whole point. As the Reynolds court emphasized, the defendant should not have been precluded from eliciting evidence on the question simply because the Commonwealth asserted that the investigation was adequate. The defendant is not bound to merely accept the opinions or admissions of the Commonwealth's witnesses and is entitled to present its own expert to explain what the appropriate standards are. Here's another Eastern District of Michigan. This is a trial court level decision permitting expert testimony on proper police technique based on professional standards, model policies, and experience. Here, the defense must be allowed to introduce testimony to affirmatively show how the investigative conduct in this case failed to meet accepted standards, not merely suggest as much through implication or adversarial questioning, particularly where here, the law enforcement officers failed, unsurprisingly, to concede that their own conduct was deficient. We said at the time, really, through vigorous cross-examination, you got a high opinion of yourself and your legal practice, Judge, because anybody who's ever cross-examined a cop knows that they are not going to be like, why, yes, Mr. Defense Attorney. Of course, this fell short of the standards and procedures that we're expected to follow. You have to force them to acknowledge it, and you have very limited ability to be able to do that on cross-exam. Concern I have, not sure they tried all the options that they have to try to get those kinds of concessions, and she might hold that against them. Witnesses' admissions of deviation from protocol opens the door to expert explanation of what the proper protocol is. So both we get an expert because they didn't deny it, and now because they did. So recent trial testimony has materially altered the posture of this evidentiary issue. Lieutenant Paul Gallagher and Trooper Yuri Buchanan each testified to conduct which clearly deviated from standard law enforcement protocols, but refused to concede any wrongdoing. Over the course of 2 days, Lieutenant Gallagher testified to his account regarding evidence collection outside of 34 Fairview Road, stated that he used a leaf blower to clear the area and uncover crime scene evidence, a method ripe with a substantial risk of disrupting or destroying evidence, was proper and effective in this instance. Further, he testified that because of the weather, it simply would have been impossible to follow protocols. You couldn't take 15 minutes to go to Canton PD to get the evidence collection kits, but you took however many minutes it took to go over to Kelleher's house to get the red Solo cups, Finally, Lieutenant Gallagher admitted that he chose not to search the home adjacent to the crime scene owned by a fellow officer, falsely claiming lack of probable cause and that it would be improper for him to obtain consent. That testimony was incredibly misleading, and there is a significant risk that jurors will give his testimony undue weight merely because he is a law enforcement officer and lay witnesses are unfamiliar with the legal standards attendant to criminal cases. I'm still real iffy on the probable cause, guys. I know. I'm real iffy on the probable cause. No question that they should have gone up and asked to search. You can always ask. It's a law enforcement officer. They have nothing to hide, right? So you can always ask for consent, and then you don't need a warrant. And there's no question that they didn't do that. But where I think the problem was with Gallagher's testimony, the way I see it, I certainly don't think that whether or not there is probable cause is a kind of factual question, that there's a real clear black or white, yes or no. I mean, in some cases, maybe, maybe it's real black and white, but it's a totality of the circumstances test. It's always going to be, it's going to be contextual. It just depends on what the officers knew at the time, and what the, inferences are that would tend to show there's evidence in this particular location, evidence of a crime in this particular location. It doesn't have to be like a 51% more likely than not. It just means a reasonable likelihood that you'd find something that would be helpful. So I've been real iffy on the probable cause. That's not my issue. My issue is with him saying, I could end up on a Brady list if I requested a search warrant. No, you couldn't. You couldn't. You don't end up on a Brady list because you file a request for a search warrant and a judge finds it deficient. You don't end up on a Brady list because of that at all. You end up on a Brady list if you lie in your application. Lieutenant Gallagher, who asked you to lie in your application? Nobody did. Nobody did. So that's what I don't like, what I think is misleading, because it suggests that the only way to go and ask a judge for a warrant would, inherently result in some kind of negative consequence to the officer if the evidentiary basis isn't sufficient. And that simply is not even close to true. It's not even close to true. Trooper Yuri Buchanek testified over the course of 3 days regarding his involvement in the investigation and asserted that this investigation was conducted with honesty and integrity. Honor, in fact. Didn't he say honor? The defense is entitled to rebut his self-serving claims. Trooper Buchanek admitted he never entered the house to search for evidence, interview witnesses, or photograph the scene. Furthermore, he failed to explain the divergence from the normal chain of custody protocol, noting that while certain evidence was discovered on February 3rd, 4th, and 10th of 2022, it was not written in a report until November 4th, almost 18 months later. He also fails to offer an explanation for failing to interview two potential witnesses, Ricky D'Antano and Heather Maxson, who were at 34 Fairview Road until over a year later. Buchanek admitted that there was evidence logged that he himself turned over where he could not identify who eventually filled out the evidence label. He claimed that there was nothing unusual with the handling of the evidence in this case. Proper chain of custody protocols are not common sense issues that are apparent to laypersons. The defense is entitled to call an expert witness to testify regarding proper chain of custody protocols. The investigation in this case was clearly inadequate and deviated from standard policies and protocols. See, now I don't like this. I don't like this. If you're saying on the one hand, you need an expert to show, then it's not clear. If it's clear, you don't need an expert. So I don't love this rhetoric. It doesn't work in this particular context. The defense is entitled to call an expert witness to establish that this case did not conform to standard or accepted protocols. The Commonwealth therefore opened the door to testimony by a qualified expert who can clarify for the jury what these protocols actually are and why these departures matter. Just as jurors are routinely aided by expert testimony, police regularly testify about information for which specialized knowledge would be useful, even if the information could be general knowledge for a certain juror. And he goes with the example of, oh God, it's always the drug experts, the cops who do like a few drug buys and then, decide they know everything about street lingo and prices and how drugs are stored and all this type of stuff. And it often gets a little bit ridiculous. Because of course you can tell by looking at the drugs whether they're from personal use or for or something you intend to distribute. Thus, Ms. Reed should be permitted to proffer testimony from a seasoned FBI agent regarding investigative principles, policies, and professional standards. His testimony, rooted in the MSP Policy and Procedure Manual and decades of experience, falls well within this permissible scope. Want to see where this is going, because I might have a little bit of critique of this as well. In Commonwealth v. Wood, the SJC explicitly upheld the right of a defendant to call a forensic expert to challenge the adequacy of an investigation. Okay, this looks good. This is a case law that appears to be directly on point. The court emphasized that the jury had the benefit of 1, cross-examination, 2, closing argument, and 3, quote, the calling of its own expert as part of the Bowden defense. That trifecta is precisely what the defense seeks to employ here, and the removal of one of those legs unjustifiably undermines the defendant's constitutional right to present a complete defense. Okay, I got to pause because I got to look this up now. 469 Mass at 277. It's not going to give me that, but what's the name of the case? Wood. Commonwealth v. Wood. Okay, I want to see what it says, because it does not look to me like an accurate representation of the holding of the case. It's a little bit hard to say what the case held unless you know what is the issue that was actually decided by the court. And so how did this come up? What was the context? Okay, what page was it on? 277. 277. Okay, finally, although the judge limited testimony regarding Thompson's prior drug use, he did allow evidence of Thompson's use of crack cocaine on the night of the murder and the days preceding it. Defense counsel was permitted to ask whether Thompson used crack cocaine the night of the murder, whether crack cocaine was found in the pants he was wearing that night, or were they his pants? Whether he had arranged to hold crack cocaine for a drug dealer named Tony or T. Defense counsel was also permitted to elicit testimony from other witnesses to the effect that Thompson smoked crack cocaine in the hours preceding the murder, and that the crack pipes were found in his bedroom. Okay, this is all about drug use, so I don't see where we're getting here. Okay. The defendant also argues, okay, I'm just going to pull this up. Defendant also argues that Shaheen's statements about Tripp should have been admitted, both through her own proffered testimony and that of Boston Police Detective Russell Grant, to whom she relayed the information in furtherance of a Bowden defense. Pursuant to a Bowden defense, the defendant may introduce evidence regarding the police investigation in order to create an inference that the evidence at trial may be inadequate or unreliable because the police failed to conduct the scientific tests or to pursue leads that a reasonable police investigation would have conducted or investigated, and these tests or investigation may have led to significant evidence of the defendant's guilt or innocence. The failure of police to investigate leads concerning another suspect is sufficient grounds for a Bowden defense. See Commonwealth v. Fenney. That's what is at the page that they cited, and that is not a holding that a defense gets to present expert testimony on the Bowden defense. So if I follow this through and keep reading past what they cited, okay, so the judge excluded these statements. So as part of the investigation, Detective Grant interviewed Shaheen on February 22nd, 2004, during which she provided essentially all of the third-party culprit evidence that her proffered testimony would have encompassed. That evidence was properly excluded, however, because its probative value was negligible. At best, the defense would have shown that police failed to investigate Thompson as a suspect, despite being aware of his drug use and his deteriorating relationship with Tripp. However, where there was no evidence suggesting that Thompson killed Tripp or was in any way involved in her death, the judge properly concluded that the evidence would have been far more prejudicial than probative. In any event, defense was permitted to challenge the adequacy of the police investigation as a whole. Counsel for both defendants extensively cross-examined Grant about his investigation, emphasizing the fact that Grant was aware Thompson had repeatedly lied to the police and that Grant had done very little to find T, despite having information suggesting that he had allegedly fronted Thompson an 8-ball of crack cocaine only days before the murder. Defense counsel also argued in his closing the police in this case did not do the job that each and every one of you should expect to be done, and argued that a further investigation of Thompson's drug use might have uncovered a third-party drug dealer or user who may have committed the crime. Thus, where the issue of inadequate investigation was fairly before the jury, the defendant suffered no prejudice from the exclusion of the proffered evidence. I had to go and look, guys, because as soon as I saw this this citation and the way that they described it, it's not what the case held. Guys, I gotta call things like I see it. The case did not hold that you get to call a forensic expert to challenge the adequacy of the investigation. We literally just looked at this page. There's nothing on that page. Nothing in it about getting to call an expert, a forensic expert, to challenge the adequacy of the investigation. Here's one part we missed. Note 16. Let's go ahead and come back. Let's go all the way down. Let's look for note 16. Defense counsel through cross-examination and the calling of its own expert. Okay. This is not a holding. This is not a holding saying you get to do that. It's just a fact that was present in this particular case. And it ends up being helpful, I guess, in this case, because it's not helpful for the defense in the sense that it means they found that, any error wasn't harmful. Any exclusion wasn't harmful because you had your own expert. That's not a holding that says you get to present expert testimony. Maybe this is like a legal distinction that isn't particularly clear, but the holding of a case is the legal rule that's decided by that case. It's how it's applied to these facts, or sometimes it's like a lot of times in published decisions, it's a new rule. It's identifying what's at issue and how does the rule affect the outcome. There is no rule stated in any of this that you get to bring a forensic expert to present a Bowden defense. It's just that's what happened in this particular case, but that wasn't challenged. It's not an issue. It's not for the court here on appeal to decide or not. So I got to kind of take issue with this memorandum, that legal argument. I don't agree that is what the case says. Even if jurors may intuitively recognize some investigative irregularities, they are not equipped to assess whether those actions violated codified procedures, create contamination risks, or reflect investigatory bias. The argument that a lay jury can adequately gauge the seriousness of Lieutenant Gallagher's use of a leaf blower or Trooper Buchanan's failure to appropriately comply with chain of custody protocols without the aid of expert testimony is unsupportable under relevant case law. So therefore, they were allowed to testify that, they acted with honesty and integrity, and the defense should be able to present expert testimony to rebut that. Well, I got one other beef. I got one other beef with this motion, which is it doesn't have an offer of proof. It really doesn't have an offer of proof. It's identified all of these things that they say, okay, Trooper Gallagher or Trooper Buchanan and Sergeant Gallagher said these things, and we want to rebut that. What would he be rebutting it with? The closest you've gotten is just, it's this guy relying on the Massachusetts State Police protocol. So that to me seems pretty directly relevant to Yuri Buchanan. He's in the Massachusetts State Police. He's going to be presumably subject to those protocols. Not seeing how that is going to govern Lieutenant Gallagher. Lieutenant Gallagher is part of a different department, different agency. Different agency can have different procedure, different protocol. Don't know if Canton Police Department has their own policy or procedure or anything like that when it comes to evidence collection using a leaf blower. Honestly, guys, why are we fighting the leaf blower? The leaf blower is good for the defense. The fact that the leaf blower was so effective is what's good for the defense. It was so good at removing all that snow that we can see there's no tail light here. I don't know why I don't know why we're impeaching the leaf blower. Leaf blower is far from the worst thing I think that they did that morning. But it's helpful. It's helpful to the defense that they did that, because if they hadn't done that, we wouldn't have any idea where there is a bunch of tail light under the snow out on the yard at 34 Fairview. Because they did that, now we know this big massive area they cleared, none. And not just none, but also they didn't blow any away, okay? These 40 some pieces of reflective red and clear plastic. You blow that away, you think you're going to get a little, light reflecting on that, maybe notice in the snow, a piece of red plastic sticking out. Even if you uncover it and it blows, blows a little bit away or something like that. I feel like that's helpful to the defense. So I don't know why we're impeaching it. But that general description that it's just going to be Michael Easter using the Massachusetts State Police protocols and the generally accepted kind of protocols. It's just not a very thorough offer of proof. If you've identified all of these things that you say are problems that they testified about, like, for example, Lieutenant Gallagher didn't go seek a warrant. He said there was no probable cause. What exactly is Michael Easter's testimony going to be to show that there was? That's kind of what I need for an offer of proof. What is his basis to say there was probable cause here? Or even if there wasn't probable cause here, there was, a basis to ask for a warrant. That's what we still don't know. We're still just kind of in the dark. And so from my standpoint, motion to reconsider, to the extent that it is largely an exercise in making your record for appeal. Judges are rarely going to backpedal on the decisions that they've already made. This isn't a particularly good or helpful record for me on appeal. Because if I'm going to go and argue this was error for Judge Bev to exclude that, I have to show what is the practical effect on the trial. And the only way I know that is what exactly is Michael Easter going to say? If all I know he's going to testify generally about these topics, I don't know what that means. I don't know what that means. I have no way of being able to show the jury would have looked at this situation differently if they'd only heard Michael Easter's take on it. We don't know what Michael Easter's take is. So from a standpoint of, this motion being there to preserve the record for the appeal, it has not done the job at all. Really hasn't done the job. We need an affidavit for Michael Easter at the least. So I don't think we're going to get it. I don't think that's going to be, don't think that is going to be granted. I don't love the argument. Don't love the way that it's presented. Don't think that they did what they needed to do, to lay the foundation to get a fair shake at reconsideration. You needed, if you got the MSP policies, you needed to go stick those under Yuri Buchanan's nose. And then, yes, I know he'll do the same dance he did with everything else the defense stuck under his nose. He doesn't know what it is. He's never seen it before. He can't speak to whether it's authentic or not. He doesn't know if you've done anything to it. Okay, now you're able to show. Can't achieve the goal of questioning him about the policy just through cross-examination. He won't authenticate the policy. Therefore, if nothing else, I need Michael Easter to come in here to authenticate the policy so that we know this is what was in effect, that Sergeant Buchanan was supposed to be governed by, that Michael Proctor was supposed to be governed by when they were conducting this investigation. If he won't give you that, you got a built-in showing now. This is why you need Michael Easter to authenticate it. I don't love how this issue's been handled. It seems it seems a little bit sloppy. The lack of a record is not good. It's just not good. I understand you don't want to tip your hand too much as the defense. You don't want to give them, give away the case. But you got to balance that with, do you want a realistic shot at getting what you're asking for? And if you don't, do you want to have the record you're going to need to make an issue out of it? Just not sure we got either here. So a little bit disappointing, guys. Well, Tuesday's been real frustrating, hasn't it? Not necessarily our favorite day. Let's see what you guys have been thinking. Christy, at work listening to Hanky Panky be a snarky, see you next Tuesday. And it makes my ears hurt, but I love listening to your opinion and commentary. Andrea, keep up the great work. Well, thank you so much for that. I try to have a little bit of a better tone and presentation than Hank Brennan, but I will be the first to admit that is an extremely low bar to set. It's not that hard to not be a raging bitch every time you open your mouth. Sabina D. Andrea, does the repetition of the same question when the witness is consistent and the length of this cross actually convince any juror? Because he is annoying AF. I would be bored out of my mind. Don't know. We got a little bit of that that read from Jess Machado is in court right now. And so she gave us a little bit of a read on how the jurors were reacting to a lot of that stuff. But it sounds like it's mixed at best. Here's her, this is right when we came back to, looks like this is talking about during the examination of Russell. So I'd like to see if she's got any observations from Barros. No, she didn't. Not that I saw. Yeah. So all we have are some observations from when Dr. Russell was on the stand. Here's what she says. Juror is looking at the screen, arms crossed with annoying look, looking extremely bored, head going back and forth. Already just seems very different. Some annoyed people and somebody who's following it like a tennis match. Looking at the notes of the juror on the side of him. Can't see number 6. 7, taking notes, staring at Karen Reed. Note taking, looking down at notes, looking at Alessi, looking across the room, expressionless and void of emotion, lifting his head to look at Russell, taking notes, head tilted back into the side, chewing gum, sitting straight up, looking back and forth, taking notes. You know, what do you take away from that? I don't know. I don't know that there's anything really that you can take away from that. So I think it's just going to sit differently with different people, guys. People are going to have different reactions to it. There may very well be some people who consider that that aggressiveness, you know, to be effective. That's what they're looking for, and that's what they respect. It might be part of the culture. I've talked a couple times about, like, here they call you guys massholes. heard that expression out there before. You guys flash your lights to give the other person permission to use their own right of way. You would never do that. You would never do that in Washington. In Washington, you would cause an accident by being too polite at the 4-way stop, waving the guy through who doesn't have a right to go, and then you confuse everybody else. Just follow the laws. There's a lot of different cultures and norms and things like that. So I don't know this jury. If we were down in like Atlanta, maybe, I don't know Atlanta very well, but you know, I'm just thinking the South in general. Do you think this attitude by Brennan would be flying? I don't. Oh no. The land of bless your heart. They're not going to like overt rudeness like this. But he's not in Alabama, is he? He's up there just south of Boston, and this might be what they like and what they expect. So it really doesn't work for me. I find it, find it hostile and rude and uncalled for. But I come from the land where people will bend over backwards to let the non-right-of-way person go first at the 4-way stop. So just can't really have any opinion about how it's landing on the jury. You know, I don't know them. But the hammering. I mean, maybe some people do think that that's effective. Byron Butterfield. On this photo of Julius Caesar's body, can you say with a reasonable degree of medical certainty that this individual wound was caused by Brutus? Couldn't it have been Cassius? Yeah, which one is which? Which one is which? You just got to look at the group as a whole. That's not a bad analogy there. I kind of like it. It doesn't matter. It doesn't matter which one caused, which wound. Now, if we didn't know who left Julius Caesar bleeding to death on the steps of the Senate, would we be able to look at his wounds and know if it was a single attacker or multiple attackers? What would we use to figure that out? I'm guessing we would use some kind of pattern recognition. We'd look at the wounds. We'd look at the shape, the size, the depth, the length. Is it bladed on one side, bladed on both sides? Look at things like that. Look at the angle that the blows are coming in from. Are they consistent with a single attacker or need multiples? I think we'd look at the patterns to figure that out. But that's just a ballpark guess on my part. Nasir Puto. While our bias may hate him, any tweets from jury reactions to this cross, I think he's doing great undermining her findings. She's just too agreeable to his slick pushbacks. I thought she held up pretty well. I didn't think that she was overly agreeable. She definitely conceded, plenty of things. But to me, that's the difference between an expert that has some credibility and an expert that doesn't. Is, are you going to concede reasonable points from your opposition? And we see a very vastly different picture from Dr. Russell than we saw from Judd Welcher. Judd Welcher won't even concede that the Lexus did not, in fact, and we can say with certainty, blast off into outer space. Dr. Russell is willing to concede more reasonable things. Yes, it's correct. There's no specific standard for how to diagnose a dog bite. There's probably no specific standard to be able to diagnose, I don't know, a cat scratch. To be able to diagnose, I don't know. Just trying to think of other, a scrape that came because I fell and, scratched my head along like the carpet or something, and an abrasion because, I don't know, playing softball and I got my glove and I hit myself, like, are there standards to be able to diagnose each of these things? Of course not. Of course not. It's just that if this one has something distinctive about it, a pattern that you see repeatedly, and you've seen it over and over and over again, I don't know. I mean, it is a tough one. It is a tough one. But, yeah, she's willing to concede there's no standard. She's not going to, be like Welcher and just kind of make something up or be, be snotty back, snotty about it. I don't think you know what a standard is. I think you misunderstood. Your question doesn't make sense. She didn't pull any of that stuff. So I think there's different ways to take that. Did she concede anything fundamental? I didn't really see that she did, but it doesn't matter what I saw. It matters what the jury saw. And I really don't know. Don't know how they were going to take it or not. I haven't seen jury reactions specifically other than that one that we just read. And it sounds like it's mixed at best. Bethany, it doesn't bother me she talked with Alessi. She didn't change her opinion, unlike Hank talking to Burgess and then he changed his whole report. That's the difference. That is the difference, isn't it? And it's also a good explanation for the defensiveness and for the accusation. You gotta go to war on Alessi doing something that's so innocuous that you yourself, in fact, did something very similar. It's just you did the worst version of that. I think that's a very good point. Virginia, we refer to it as working dog or dog sport community with subcategory personal protection. If Hank's expert uses the term dog bite community, he was told to do so. I'll take your word for it. I don't really know. I don't know what the communities, I guess, would be here. It seems to me like there would be different ones. The canine dog community is going to be one. Guard dogs, protection dogs. And is there even going to be, like, maybe there will be a community, but is it like the only community? Kind of doubt it. There's probably a dog fighting community that, I don't necessarily want to know a lot about, but it's going to be out there. They're going to deal with a lot of the same stuff too. In community, it starts to become a little bit arbitrary, how that kind of thing gets broken down. That's just part of why the standard is so bizarre. The relevant scientific community. Well, what is that? Is there even a scientific dog bite community? I don't know. We'll see what Hank's expert uses in terms of his parlance. See if it looks like anything that makes sense to us or not. Mama J, if she didn't break the tail light till 5:07, then they couldn't have caused John's injuries because it wasn't broke when she dropped him off, right? Yeah, absolutely. If the tail light wasn't broken when she left 34 Fairview, then the tail light did not cause abrasions like that to John. So it's a very easy shortcut to solve the problem if the jury thinks she didn't break her tail light until we see it on that Ring camera video at 5:07 when she backed into the car. then she didn't cause those injuries. It's just we don't know if they're going to decide that. That's one of the ultimate issues, isn't it? Was there a collision at out front of 34 Fairview? Mickey P. He knows Dateline is explaining grief reaction after the fact. Also, she was told he didn't go inside by people she assumed truthful. So obviously thought something must have happened between the car and the house. Yeah, the whole reliance, it seems such a weak, just a weak argument to me to be putting so much reliance on these things that Karen has said in the interviews when, yeah, it seems pretty common sense and pretty obvious that she's talking about how she was processing this at the time. She's trying to put herself back in that position and explain what that was like. She's not saying I now in January of 2024 or whenever, whenever the particular interview was given, that I'm grief-stricken then. She's describing what her mental state was that morning. And so, yeah, I mean, the reaction that morning, we heard it on the freaking 911 call, okay? On that, the one that was picked up on her phone, where you can hear all of the surrounding context. Yeah. Yeah, you can hear frantic, not rational, consistent with just how everybody has described it. Consistent with what Dr. Russell described too. So explaining what it was like to be in that state after the fact, it just doesn't seem to be the dunk that Mr. Brennan seems to think it is. Lawyer nurse, we learn as ER physicians practitioners is MOI, and that's what she's drawing on. I wish she would say that. We complete ITLS and we ask the paramedics about damage to vehicle. If trapped by compression, blood loss at the scene. I don't know what some of these acronyms are. MOI, what's MOI? Stands for, mechanism of injury. Okay. That's what she's drawing on. I wish she would say that. We complete ITLS. What is ITLS? ITLS stands for International Trauma Life Support, a global program focused on providing training and education for emergency care providers to improve trauma care, equips providers with the knowledge and skills needed to rapidly assess and manage trauma patients, including life-threatening conditions, using a systematic approach based on evidence-based guidelines. So rapid assessment and intervention, evidence-based, training, etc. I mean, it makes sense that there would be different things that would matter if you are led to believe this was a motor vehicle collision. I would think that very first and foremost, we'd be concerned about internal injury. If I'm told somebody's a pedestrian and they're hit by a car and they don't obviously have like a broken leg or something like that. I mean, even if they do, am I not going to instantly be concerned about internal injuries? I just kind of assumed you would. Maybe I'm wrong. Maybe it depends on the context. Maybe it depends on the car. Hit by my little BRZ. Okay, maybe not. It's well below my hip where you'd be getting hit by that car, but you get hit by the pickup truck. I could be taking the full blow of that in like the center of my chest. Just depending on, how you're oriented to it. I would think internal injuries would be something that would be of a concern. If trapped by compression, blood loss at the scene. The compression is when the car gets crushed and the person is like crushed in the car. And so that's like the pressure on the body, and that can have a few different effects. It can have a suffocating effect. You can't breathe. You can't breathe if you're being compressed by the car. And so you might die because of that. But also if you have an injury, You know how like if you've got a cut and you like squeeze, like you got a cut here and you squeeze here, you can make the blood come out. The same kind of idea. You could potentially affect blood loss and things like that. So I can imagine a lot of things that would be relevant in the ER. If you have the information that there was a motor vehicle colliding with a pedestrian, there's a lot of ways that could help you to know that, and ways that would guide your treatment. Doesn't really seem like that extraordinary a proposition to me. To truth for liberty. I think what Dr. Russell is saying about certainty is like legal evidence minus individual wound equals reasonable suspicion, but group of wounds equals probable cause. Yeah, it could be. I mean, you take any one fact in isolation, and it's, you know, not necessarily going to get you in the house, but you take the multiple facts all together in concert collectively, and what that tends to indicate, and that can all add up to probable cause. So, I mean, I feel like I understand what she's saying about certainty, just in the sense that there isn't a standard. There isn't like a chemical test that you can run that has an error rate of, 0.05%, so that when you get a positive chemical test, positive chemical result from this test, to 99.95% certainty that the condition is what it is. You just have a person who has to diagnose, has to have some certainty to be able to diagnose, because you have to be able to treat somebody. So you have to have some confidence in your diagnosis in order to treat somebody. But it just doesn't mean you're 100% totally accurate all the time. Like if my doctor was that certain, I probably wouldn't want to be at that doctor, right? Because they might be overlooking something. You don't necessarily want them that confident. You don't want them to have ruled out things that they shouldn't have ruled out. But I think it's a pretty good analogy. The difference between the individual wound in and of itself doesn't mean anything, but when you put them in this grouping like this and you look at it in the totality of the circumstances, yeah, you get closer to more of a probable cause. Harley 62, Andrea, as I told you guys, getting hit by a car, having my pelvis and hip broken. One thing something when I was in the ambulance, I kept repeating, I'm sorry, I shouldn't have crossed the street. Oh, we're talking about that reaction. Yeah, I get it. I mean, everybody is going to react differently under traumatic circumstances like that. Absolutely makes sense the way that Dr. Russell described it, that some people are going to blame themselves. And even if it's just, it's not really that you're blaming yourself. It's just that it's setting in. Like life can change in a second. Life can change in a second. And you're trying to grapple with all of that because you went from just a second ago having a perfectly normal day, walking around in your perfectly normal body, doing perfectly normal things, and boom, it's changed in an instant. And now you're not sure if you are going to walk normally again, if you're going to live pain-free, if you're going to be able to, have kids, take them to sports, play with them, etc. You just, you have this appreciation for how much can change in an instant. And so it's normal for people to grieve that, the change of what you were before and what you knew and what you were comfortable with. And now you don't know if that's going to be your future. Makes perfect sense to me that people would be like, God, I wish if only I had, because you would think how, what agency did I have to be able to avoid this outcome? You can't change it. You can't go back and do anything now. It's too late. But I feel like that's a very normal process for people to go through. Oh, if I'd have only gone to visit my mom first. Oh, if I'd have only stopped to pick up the gallon of milk. If only I had turned right to pet that cat instead of, going left to continue on the way. Like, there's just so many. If only I'd stopped to get the coffee. Here I thought I needed to be on a diet, so I didn't get the coffee, but now here I am, hit by the car. It's really normal to go through all of that stuff. So none of that seemed particularly, out of line or nonsensical to me. It makes perfect sense. That seems real. It seems consistent with how people behave. Hypnotizes lobsters. Do we think defense isn't confident with the jury? Mistrial ask. Welcher also made an unsolicited misleading comment re DNA to sow doubt with jury. I don't know. I mean, everything else being equal, if you can ask for a mistrial with prejudice, you're going to do that, because that's not an issue of, I want to swap out this jury for another one and just get a new trial. It's an issue of, I want us to not have to try the case anymore, because if the prosecutor is going to flagrantly misbehave and they're going to break the rules and, hit foul repeatedly, despite warnings that they just ignore and go back and keep doing it again. If they're going to play foul, they don't get to benefit themselves from that. So if they've made the trial unfair, they don't get another one. I don't know that particularly indicates lack of confidence in the jury, because it's just, if you can get the case thrown out, you're always going to do that. It's better for Karen if the case got thrown out right now than if it goes all the way through, just in terms of, 1, the certainty of the outcome, 2, the cost, continuing with the trial, the stress, the added days, et cetera, et cetera. It's time that is irreplaceable that she'll never get back. You would take the mistrial dismissal with prejudice. As much as you want the vindication of a jury verdict in your favor, it's very vindicating. And if Karen walked away with just a dismissal, there would always be people be like, that's a technicality. She got off on a technicality. So there's no win in that situation, really. I mean, obviously there is. An acquittal is better than a non-acquittal, but this is just the same problem we keep talking about. As soon as John O'Keefe died, there was no justice in this case. As soon as he ends up on the front lawn, there's no justice. There's no justice. There's no justice for Karen. There's no justice for John. There's no justice for Chloe, Once the bad thing has happened, the court process doesn't fix that. Doesn't fix any of it. So never going to get any of that back. Welcher also made the unsolicited misleading comment about the DNA. Yeah, he cited the taillight DNA as part of the basis for his opinion that there was an accident. How did that fit into his engineering calculations exactly? I'm afraid that wasn't really spelled out. How exactly that provided him with a engineering basis to conclude that there was an accident here. It's funny, everything that he pointed to, that he relied on, tends to be that non-scientific stuff, the witness testimonies, DNA, the taillight on the lawn, all that stuff. That's not stuff you engineered. So not the proper basis for the opinion, which is why I went looking in the case law and found that Barros is a case that we talked about earlier with the standard for the expert testimony and the problems with confrontation. Lauren Boborin, will Alessi's due process claim save record for confrontation clause? It will not. It is not enough. So I did real quickly here. I can pull up a little bit of what happens after that. Here's Barbosa again, a little bit further down in the opinion. It doesn't mean they can't raise it. It means that it will be subject to a different standard. And so here's what it's going to look like. Having concluded it was error to admit in evidence Lynch's testimony, we have to look at whether a new trial is required. So the defendant did not object to the admission of the testimony or otherwise preserve this claim of error. So it must be examined under the miscarriage of justice standard. It just basically means if you didn't object, it doesn't take it off the table, but you have to apply a different standard. And so they look at whether an unpreserved error created a substantial likelihood of a miscarriage of justice, considering the totality of the evidence admitted at trial. I don't think there's anything in that footnote that is particularly helpful. So as far as the preservation, that's what they're going to have at this point. They can raise it, but it is unpreserved. They have not specified confrontation clause. They have not specified Crawford. They've not specified that specifically is the issue. They talked about foundation. Alessi talked about the foundation of the opinion. And he's right, it's not in evidence, but the rule contemplates you could do it if they bring it into evidence. But that's not clearly going to satisfy the confrontation problem, certainly not without a commitment from Hank on the record that he's going to be calling Terry Kuhn to get that into evidence so that she can be cross-examined. So they can raise a confrontation issue. They're just going to have to satisfy this miscarriage of justice standard instead of what is presumably a more lenient one of just ordinary harmless error. La Casa Academy. What do we think are the chances that Dever actually said wicked long time to the FBI, but their notes de-Bostonized it? Maybe. Is that a Boston thing? Wicked long? That seems to me like seems like maybe 90s speak, like 90s kid. Maybe aughts kid out at the skate park be talking about like a wicked long time, maybe. I don't know. Is that Boston? Is that Boston lingo? Gonna have to take your guys's word for it. Possible. I don't know. Don't know what to make of that one. Bev sitting on the scales. If I'm on the jury, I'd be so confused. Is Hank changing his theory now to the branches causing the scratches, not the taillight? Reasonable doubt. Question we're all asking. We're all asking, what exactly is the theory of all of this? Because don't forget, we still have to account for the spoiler hitting the eyelid. Okay. Would love to ask Dr. Russell about that one. What do you think about the spoiler hitting him in the eyelid at 24 miles an hour, but only in a glancing blow? Just trying to have it every which way. It's it's Schrodinger's impact. It causes damage where it needs to and not where it doesn't. But yeah, it's the tail light. It's the microscopic pieces rubbing on him as he slides across the ground. It's the bushes over there. If it's any of those, the inability to be able to tell me which one of those it is, if all of those are possible, then you have not proven. You definitely have not proven beyond a reasonable doubt that he has those injuries because of a car collision. And you certainly haven't proved, regardless of any of that, that those injuries are so characteristic of being hit by a car that it makes sense that Munnynck and Proctor would be like, oh, we think maybe there was a car accident, but we need to go to the hospital to check and be real sure by looking at him and then see the arm. And we're like, oh yeah, definitely car accident. Literally nobody. Literally nobody. That didn't happen. Nina's fear, but how does the defense now get around the jury simply hearing that there was no dog DNA found? Doesn't matter anyway. Doesn't matter anyway. They're fine with it. Judge is fine with it. Got to go down that line of questioning. Doesn't matter that that analyst has not been produced for cross-examination by the defense. Didn't matter. So there's nothing to get around. The jury gets to hear no dog DNA. Pig DNA, but no dog DNA. Bethany, so they didn't swab the clothes until over a year later. Yeah, no, they didn't swab the clothes. That's why they didn't swab John. They didn't swab John's wounds. They didn't swab the holes around the clothes until much later on. Yeah, isn't that wild? It's just as soon as they knew what the defense theory was, then they're like, ooh, we better go try to disprove that. No dog DNA, but here's some pig DNA. Okay, guys, I'm going to check. Just while we're here, let's find Terry Kuhn's testimony from the first trial. She was on day 12. Here's my day 12. Here's Terry Kuhn. Because like I said, I kind of remembered there was an issue. DNA, of course, it was Lally. We had to talk about the DNA. DNA is the building blocks of the cell. We make it's like a PCR is like a photocopier to make 1 million copies. So in this particular case, she got the swabs. They were asking for dog DNA testing. Received a submission saying the sample was taken from a shirt. Everything arrived sealed. Tested all the samples. Did not see any canine DNA. Looking for nuclear DNA. They did meet the ID test, which is a general test looking for 12 species. Did not see any fluorescence for canine DNA. You need more than one peak to ID species. They saw pig on both swabs. It's a sensitive test and can be from food. So maybe this is not the one that had the interference in it. Let's see about Cross. Didn't get cuttings of the clothing, just the swabs to test. She has no idea how the agency collected the swabs. They're going to have different issues like that. No validation to prove that something like throwing clothing on an ambulance floor could be a source of contamination. I remember she was a bit defensive as a witness. If the item is not packaged properly, it can encourage bacterial growth, destroy DNA. Her personal process is to circle the area where she swabs and then go back so you can go back and identify where it was taken from. Swab moistened with sterile water, air dry it in order to send. Don't package biomaterials in plastic because it would encourage mold growth. You definitely wouldn't use a solo cup. She wasn't really provided any information about the samples. Talked to them about what they wanted to test and identified what they were looking for. She doesn't get to choose how the DNA is given to her. Knowing if there is dirt or blood present, here we go. Knowing if there is dirt or blood present would be helpful because there could be inhibition. So a gunnet dye is an inhibitor. It means it makes it difficult to detect DNA if the inhibitor is present. She was not told that the blood had been on a garment treated with gunnet dye when she sent the samples. The DNA, here we go. The DNA said, the result said no DNA, but there was the presence of inhibitors. Her result did say inhibitors were present. So that means there's 3 possibilities always. DNA is degraded, why you don't get DNA. DNA is degraded, the DNA is there but inhibited, or there's no DNA. So in this particular case, we have inhibitors present. So that's a possible explanation for why you don't get DNA results from it. So the inhibitor stops the PCR process. It stops the enzyme from being able to make copies. And in that case, you can't say there's no DNA there. In this case, she says a testing could not detect it in the qPCR nuclear. I'm not sure what that is. We did in the last trial from Terry Kuhn talk about absence of evidence is not evidence of absence. They did get the pig DNA. That could come from dog treats. Pig ears are a dog treat. Possible the shirt was contaminated. Not aware of a problem with feral pigs in Massachusetts. Saliva contains sloughing cells, like keratinized tissue, perhaps. Claws would not be a good source of DNA because they are made of keratin. Huh. No kidding. No kidding. More keratin. You could get DNA from the claw itself, but probably not touch DNA, but that hasn't been tested or validated in a lab. In this case, it looks like it's potentially degraded. In their test, they also did a test of an inhibitor. And in that test, it worked very well. There was no inhibition, and that was the test where they found pig. So I guess they had something. Somehow they were able to get the pig and not the dog, regardless of the inhibition. Don't quite understand that. So anyway, that's the testimony that came out from Terry Kuhn. So does that seem like stuff that might be important in evaluating this fact that there is no dog DNA? Kind of seems like it does to me, because you got inhibitors present, then inhibition might be your issue, not the fact that there is no DNA. It's that the detection of the DNA is inhibited. We heard about that in Delphi because it was a problem with all the items that they had pulled from the river. All the items that had pulled from the river were, they had mud, they had dirt, probably bacteria in the water, all those types of things. And those environmental contaminants can act as inhibitors. And so, no high expectation for recovering evidence from those items. Still tested them, all except for that green bandana looking thing, the one item that we're like, that doesn't seem to belong to either of the girls. Weird how that's the one item didn't get tested for DNA recovered from the creek. Anyway, that's that's the rough outline of Terry Kuhn and what she said in the last trial. So are we safe saying there's no dog DNA, or is that something that the defense should have been able to cross-examine on? Well, I definitely know what I think about that. I think that's an issue. Misjudged the defense. I opine with 100% personality certainty that the pig DNA found on John O'Keefe's clothing belongs to none other than Hank Brennan. Oh, there were a lot of Proctor jokes when that first came out, weren't there? Proctor and Buchanan. No surprise at all that they found pig DNA. Bev sitting on the scales. I'm gutted we didn't get a reasonable degree of dog bite certainty. Hank is letting his game slip. I was thinking about this when I had stepped aside during the break. Like this whole reasonable degree of, I'm just going to start making things up. When I'm going to be doing something, I'm going to be talking about, whether I'm doing it with a reasonable degree of car washing certainty, or, am I able to complete my task with a reasonable degree of grocery buying certainty. Why not? Apparently these things can be compartmentalized like that. Just depends on the community. I'm not, as I sit here right now, part of the grocery shopping community, but I will be at some point. So Gonna have to get in that mindset before I know what I know. Susie, do the direction of puncture tearing on holes in hoodie match the direction of teeth claw marks in terms of apparent entry and exit? I don't know that we know that. I think part of the issue is that again, you got a lot of variables here, not just like what's the position of the bite and stuff, but how's the fabric positioned relative to the skin? How is the skin? How does the bone, being underneath the skin affect the grip of the dog? Like all those things, it's just probably too much to hope that the clothing can bunch real easily. And you kind of expect that it would. A little thin cotton hoodie, you'd expect that that's gonna probably bunch up a little bit. It's not gonna be, pulling up tight against his skin at all point during a dog attack. So no, I'm not sure that we know this. We just know that there are those puncture holes, and they are round in shape, and it's got the thread coming out the front side, just like it is if you snag your clothing on something that just goes a little bit inside the weave and then, pulls it back out. Looks an awful lot like that. But nothing else I think that would give us a clue about the directionality or like where do these. Now, if the jury could open up the plexiglass and like handle the sweatshirt, they'd probably be able to look at that for themselves. They can just open up, they can hold up the sweatshirt and see, okay, here's where on the arm the holes are. And so here's where that would visually correspond, on a person's arm. And then how does that look like relative to John's arm? I would think that they could do that if they could get through that plexiglass. But not entirely sure how it's been mounted, if that's feasible at this point. Don't know. The rural juror, this methodology is second nature to her, and Hank just doesn't get it. In medicine, we do this all the time, i.e., we don't look at one single lab result to make a diagnosis. We look at several or all to decide what is going on. Honestly, you do the same thing in the law. You don't just look at one fact. You really need to take account of all of them, because if you have a tendency to just ignore the bad facts in your case, it doesn't actually make them go away. So often the jury will end up hearing about them anyway. And so if you haven't accounted for them, you're probably going to lose your ass at trial. It's really not an uncommon practice, probably in lots of fields. But, if your tendency is to cherry pick and ignore the stuff you don't want to see, and if confirmation bias is what comes naturally to you, then yeah, maybe this would look sus, I guess. How could you possibly know? Well, because you've done it many hundred, if not thousands of times. Look at this wound, see the wound, hear the story, identify, treat, etc. The Sally Portal. I might be late to this info, but just learned Buchanan was put on the Brady list May 9th, second day of his testimony for conduct in his case. Can defense bring this up? No, because the Brady list is not a thing. It's not a thing. I know there's websites out there that call themselves like the Brady list or whatever. These are not a thing. They have no legal significance at all. A Brady list in general is a colloquial term for what some, usually prosecutors' offices, sometimes it's law enforcement agencies, some, but not all of them, will compile on their own for their own use to help them comply with their Brady obligations. When you have to disclose impeachment evidence, and if you have a cop who's, for example, just gone through an IA process and there's been a finding of some kind of act of dishonesty, now that cop is going to be a witness in other cases. You the prosecutor, you're going to have an obligation to turn that over to the defense so that they can cross-examine that witness on his dishonesty. But it's just, it's a thing that they do if they choose to, for their own convenience and for whatever purposes they decide to use it for. Some of them may keep it entirely internally. Some of them may routinely release the Brady list to the defense so everybody's on the same page. Here's the cops who have had problems with credibility and what the source is and so forth. It's just entirely within the judgment of the agency how they want to handle that type of thing. There's no obligation whatsoever for them to create a Brady list, as long as in each individual case involving an officer with impeachment issues, those issues are disclosed. So no, they can't bring it up because the Brady list is not actually a thing. It doesn't mean anything. It's just an organization or, you know, somebody with a website that is compiling what they think are instances of law enforcement misconduct. But depending on the site you're looking at, some of them are not particularly well substantiated. Some of them are based on like allegations that are made in emotion, allegations that may very well, you know, not be true because we don't know, because you're not basing it on an order or on findings. You're basing it on emotion. Somebody said something happened. Let me tell you, that happens a lot. A lot of allegations against police officers, and a lot of them, you know, are not true or are exaggerated or something like that. So no, unfortunately, put a lot of grains of salt on anything you see that calls itself a Brady list. Norman Corey, when see 1,000 dog bites and treat them up, can spot them easily. Good mechanic can hear a noise coming from the lower part of an engine and tell you what it is and that you most likely drove with no oil. Yeah, there probably is a lot of overlap like that. You know, they can hear instantly, like you got a timing problem, you know. Probably even tell you like right off the bat, you know, here's exactly how miscalibrated you are. Stuff like that, because you have like the firing pattern, you know, for the pistons, and people can detect like if it's off. It's kind of crazy. People who are super car people really get a lot of detail out of the car. Oh, the weird thud, you know, they're going to know exactly what that weird thud is. Avoid the weird thud. The weird thud is usually not a good thing. But I think this is the point. This is pattern recognition. If you see a lot of patterns, you will recognize that pattern. If you don't see the pattern, you probably won't be so good at recognizing the pattern. But we all see patterns every day of our lives. We all see patterns every day. You know, I notice the birds that show up at my feeder outside my window. So if there's a bird that I've never seen before, shows up, different bird, I'm going to notice. Other people that don't watch my feeder all the time, they're not going to know. What's the pattern? What's the normal pattern? Well, they show up at about 10:30, and it's usually a big old flock of juncos, but the juncos will have some you know, Eurasian sparrows, and sometimes some white crested and things like that. Maybe some house finches will be mixed in. But then if like I don't know, some kind of wren shows up, it's going to be out of the pattern. It's not the normal group of birds that's showing up that morning. I'm going to know that. I'm the one who watches out my window and watches the birds. But somebody who's not familiar with my feeder and hasn't watched it a whole bunch of times isn't necessarily going to have any idea that wren is a little lost. This ain't his crew. Stacy Labruno, do you think the defense is making a mistake not calling Proctor? There's no downside even if he gets to explain himself. It's his investigation they need to question him on in front of the jury. The texts are not enough. I don't personally think so. I think it's good for the defense to not call him, because the burden is on the prosecution to justify his investigation. They don't have to question him on it. I think they've already established through Buchanan that there's plenty to be concerned about. So I don't think they have to repeat that with Proctor. And I do disagree that there's no downside. I think there is a downside. I think it's way better for the defense for Proctor to be the ghost. As soon as Proctor is a living, breathing human person, it's much more difficult to hang whatever kind of wrongdoing or bias or malice or whatever, it's harder to hang that on him. It's much easier to do it in your imagination when you don't know anything about him as a person. So as soon as he shows up in the stand, flesh and blood, you've taken it out of the realm of, I could imagine this happening, to now I'm going to seriously grapple with, did this guy actually do these things? And there's a risk they'll be like, nah, he wouldn't do that. Yeah, he had problems, but I see that as a potential downside. So to me, I don't have a problem with them not calling Proctor. I think it's not a bad decision. I think it overall reflects much worse on the Commonwealth that Proctor is not being made a witness in this case than it does on the defense. Sandy B. Karen backed into a pig that was on the side of the road. John heard the crash and came running, and Karen was still going backwards and sideswiped John. I solved it. Oh, I thought maybe she hit the pig, shattered her tail light. John came running up. He slipped on some of the tail light. He fell, and there were shards on the ground where his arm was, but he slid, and the momentum took him all the way over to the flagpole. And that's that. That's what I thought. And Cat 100, I think defense wants jury to see minimal obstructions versus Commonwealth's constant objections whispered. I submit, so far, rather effective. Great coverage, Andrea Mods chat. I mean, they clearly have a different approach. They are being much more collegial than I would probably be inclined to be, just given the mood of the opposition. They are being far more courteous to him, clearly, than he is being to them. Not really feeding him his own medicine. It's a decision to do that. I don't know why they're making that decision. I don't know what their rationale is, but it does seem to be a decision. I don't think they're just sitting there, zoning out or whatever, like not paying attention or missing things or stuff like that. They've just made the decision that they're not really going to interfere unless, I guess, it's particularly bad or particularly objectionable. I would probably be erring on the side of objecting a lot more. Maybe they're seeing too, she's letting him do what he wants. She is letting Mr. Brennan run around the courtroom, stinking it all up. She's allowing it to happen. So the more you object and get overruled, the more it looks now like you're the difficult person. And this masshole over here is the one that's doing things right. So it could just be as simple as that. They're not objecting because they think they'll get overturned, and then the jury will think they're being difficult, trying to avoid, bad information from coming out, stuff like that. Can be a risk, no question about that. Haddocks, Aha, Texas. Is anyone allowed to ask how the Commonwealth knew that Dr. Russell had a convo with Alessi when they were the only two in the limo? That's what a boomer would call a black town car, by the way. She might call a town car a limo. That was kind of my thought too, but I don't know. I don't think he did know. I think he just floated a balloon because he knew that Dr. Russell is extremely honest and would answer it honestly. I don't think he did know. He's asked pretty much all of the witnesses who have come up about conversations that they had about, this or that. So I think he just got lucky that they had in fact discussed, looking for the transcript. And she's honest. If they had had any conversation, she's going to disclose it. Think Welcher is going to disclose a conversation like that? I'm skeptical. I'm very skeptical. But when your witnesses have integrity, that means they'll give you the bad as well as the good. And I think that's largely what came out from the defense's witnesses today. Nobody's case is 100% good all the time. No witness is 100% good all the time. There's always something. There's always something. And so it's just really the difference, I think, between the defense's witnesses and the Commonwealth's witnesses. To me, it speaks to integrity. When there's bad stuff, you'll admit it. And not deflect, not be like, your question doesn't make sense, not fight it. Robin Hall, dog bite community equals the stands of dog dentition. Yeah. Dog dentition is still out there rocking in the free world. Maybe that is the dog bite community. AKA Trad's photos. I 100% think this is the most important witness in trial 1 and now trial 2. Also got to send you some photos of my new chicks. Yeah, I want to see the new chicks. Trad's photos here has Americanas too. So same breed of chicken. It's the one I've been looking for a while now. Jeff was able to find earlier this year. That's all our chicks are Americanas, and they're kind of fun because they have these like furry, almost looking faces. Yeah, these very full faces. They're an American breed that is derived from a breed that's from Chile that is not really itself a breed either, but is a cross of 2 indigenous breeds, one of which has no tail, which is kind of fun, rumpless. Those are kind of neat looking birds. And then the other one has ear tufts, which also happen to be lethal. It makes them look like they have big lamb chops coming out of their face, but it also happens to be lethal, this gene. And so that bird is not particularly valued because, you lose a lot of chicks trying to breed that bird. So a lot of the American species have been trying to breed out, those lethal characteristics, but still get the good parts of the Araucanas, like the blue eggs are so fun. So I'm not sure if we were on Barros in this one or if we were on Dr. Russell when this comment came in. I don't know. Who's the most important witness in trial 1? I kind of thought it was Lucky, but the jury didn't agree with me. Apparently, according to juror Ronnie, jury didn't agree with me at all. They threw Lucky Loughran out right away. I thought Lucky was very, very significant, not just because of what he saw, but his presentation. His presentation comes across as sincere. I don't know. I've seen stuff around like saying he's got like cognitive deficits or things like that. I have no idea if any of that is true. But he does come across as somebody who might have a hard time, constructing a complex lie and then sticking with it. But his way of answering the questions, very fast, very direct, very straightforward. He knows what he knows, and he's not trying to stretch it. So when he knows it's a forward edge and Lally calls him out on how could you possibly know it's a forward edge, and he can tell you, well, the fin shape is different than, this or whatever. Like the guy knows cars. He's a car guy. He's one of these crazy car guys who could probably hear the thumping and know exactly what the problem is. Be like, you need to check your transmission right now. Yeah, I don't know who the most important witness is. Barros, I think he had the potential to be really good, but I think Hank did some work on him. He did his job. He undermined that. Is it enough? I don't know. But the fact that a cop is willing to come out and say that's absolutely not it, isn't his whole incentive to just fall in line, not say anything, protect the thin blue line? Is Hank going to be like suggesting in closing that he's just another fame whore? Saw it on TV, wanted to be famous, went to the defense. Like, I don't know. Michelle, I used my sister's razor to shave my legs once when I was too young to shave. I lied to my mom and said I fell on the concrete and skinned my leg. The bush taillight theory might be dumber than my 6-year-old concrete hair removal lie, but none of these are dumber than I slipped in the snow on the driveway and I caught myself by the knuckles. I made a fist to catch myself and skinned up my knuckles. I think that might be one of the dumbest lies I've ever heard in my life. I really do. I've heard some dumb lies. That one is a pretty dumb one. Pretty dumb one. The only one I can think of off the top of my head that might be worse than that is when I have a client who's accused of theft and from a supermarket. And basically, it was just trying to remember how he was running the scam. I don't even remember now. I don't remember if it was the one where, no, it wasn't the returns. I don't know. Anyway, he's accused of theft, and it's in the supermarket. Guys at supermarket, they have cameras now, like pointing. Often the camera is tied in with the, register type of system that they use. So like the transaction and the time and all of that stuff is like all linked together. Just so you know, word to the wise. And anyway, the guy's defense is that it's not him. And dude, we are sitting here watching this video of you at the register. It's clearly you, okay? And no matter how many times you say that doesn't even look like me, dude, it's you. It's exactly you. It's got the same tattoo. It's you. It's not me is not a good lie. That was a really bad lie. But that one was also just, circumstantial. If they didn't have video evidence, maybe it wouldn't be such a bad lie to say it's not me. But when they got you on video saying that's not me on the video, not particularly good lie. But I don't think any of that's as dumb as I slipped and fell on the sidewalk and scraped my knuckles. I don't think felling on the concrete and skinning your leg is a bad. I don't think that's a bad lie. For I scraped myself up, trying to shave my legs. Didn't know what I was doing. That's a funny story. Mike Scott, how did HB show video to imply taillight was broken after crashing into John O'Keefe's car? Though Welcher stated it didn't break there, though they touched, suggesting the smash must have been an impact with John O'Keefe. Did Hank Brennan show video to imply taillight was broken after crashing into John O'Keefe's car? Yeah, time-wise, that's why he showed the 507 ring camera video to Barros to try to say this is, this is the condition after it. Yes, after it backed into John, but backing into John's car is irrelevant in their estimation, in their analysis, because, like you said, Welcher said that didn't cause any kind of break. So any break had to precede that, would have had to have been the night before at 34 Fairview. Yeah. I think that's what he's trying to get at. And he's trying to say that the ring camera video is more consistent. The taillight is more consistent with how it looked in the Sally port than how it looked, as Officer Barros described it. I don't see that. I see a lot of red in that taillight, and you can try to blow it up all you want. All I get is a bunch of large pixels, very pixelated. You don't get the level of detail that you might like to have out of that camera, but like the one where you see the white, looks pretty clearly like it's at the side. But then we have the whole complicated factor of, are you gonna see white light if you just break the red part of the tail light? Kind of have reason to think that's not how it works. Thank you to Be in Trouble 31 for making that very clear to all of us. So yeah, I think that's generally what he was doing to try to imply. Had to have been from the contact with John O'Keefe. That's why he likes that early morning video. Edward Kirkpatrick, neither Lally or defense showed him Sallyport video, showed him Sallyport photo. Hank tricked his memory. I don't know if Hank tricked his memory or not, but yes, he was not shown that. Didn't come up in the first trial. How did it come in? How exactly did Hank bring it up? They were talking about whether the defense showed him stuff. We were talking about the meeting in the conference room in Boston. He denied that he was shown any reports or testimony. He was not shown the Sallyport photo. I think he volunteered. He saw it at the last trial because Hank was going through asking him, did they show you the report? Did they show you, did you read your prior testimony? Did they show you this photo from the Sallyport? And he volunteered that he saw it at the last trial. And then if asked, he said, nobody asked me if it was different. And that's sort of correct. I mean, nobody asked him if it was different from the Sallyport photo, but he didn't see the Sallyport photo in the last trial. And so then he brings out that he testified that it was not, the Sallyport photo did not show the taillight the way that he saw it, and that Mr. Lally asked him that. He never read his specific testimony, but he remembers discussing that specific photo. So I think he might have volunteered that, at least the very beginning that started us down this road, that he saw the Sallyport video or the Sallyport photo at the last trial. I think he volunteered that. But from there, it could have been, down the road, downstream from Hank's questions about the prior trial. But I think he volunteered. Tara Rayner, normal iPhone battery temp is 0 degrees Celsius to 35 degrees Celsius. The battery testimony means poop, but nobody has mentioned the normal optimal operating temps. Not yet. Not yet, they haven't. But yeah, there's a pretty wide variety, I think, of what's. I mean, this would be a big range of normal operating temperature. I know my problem. I don't have problem with the cold battery. I guess we did know when we're camping down in South America, you gotta stick your phone down there in your sleeping bag, and preferably like near your stomach, near your core. Then your phone will stay warmer and you won't lose your battery as fast. Sorry for the slurp. But that's not normally what I run into with the phone. Problem I run into the phone is we're outside with it in the summer, and then you like put it down somewhere and the sun is blazing on it. It takes like 90 seconds before the phone is going into shock because it's overheating. But it's true. The jury doesn't have a frame of reference for what this battery testimony is significant for. What's it supposed to mean? Ian Whiffen didn't give them any, just stuck it in a freezer and it went down. Oh, okay. Good science there. But what the actual temperature meant. Wonder if we're going to get some answers from ARCA on that. Why would it sit at like 50 degrees, 55 degrees, whatever it was, for an extended length of time and then just suddenly drop again? I don't know. Vanna, couldn't AJ have asked Barros, the clearest image of the taillight I showed you doesn't match how you remember it, does it? The rest of the photos aren't clear, so that could have been kept vague. Well, this question in and of itself would be objected to as leading. She wouldn't allow him to ask that question. But he could ask, all of these different images of the taillight that you were shown, which one is the clearest? It's the one in the Sallyport. And does that depict the taillight that you saw at Dighton? No. No, that's not how it looked like. I mean, I think the point generally came across. He stands by, He stands by the testimony that the taillight is not in the condition that it was in the Sallyport photo. I think there's a very legitimate question whether the condition in the Sallyport photo is the same as the condition in, for example, that dash cam screenshot that we keep looking at. I was also a little bit surprised that according to Barros, the piece that was missing was the piece over on the side, because I just kind of assumed if there's a piece missing, it's that rectangular piece that they never recovered any of the pieces for. But not that one, apparently. Hard to put all this stuff together. Bev sitting on the scales. How do you think it will land with the jury that all of a sudden Hank questioning timely reports when MSP didn't do some for 18 months plus? I don't know if the jury is going to register that particular time difference, but the hypocrisy, you know, if they haven't caught on to that, then I got to wonder what they've been paying attention to, you know, like, yes, that's why you write reports and that's why you write details. In many ways, this cross-examination of Nicholas Barros is pretty routine. I mean, this is pretty standard practice for a defense lawyer with a cop on the stand. You tie them to their report. You talk about why you file the report. You're trained in the academy. It's going to be a memory aid. Every detail is important. We've heard Mr. Yannetti do this a bunch of times. Now we hear Hank doing it. It's really routine for cross-examination of a cop. It just stands out with Hank because you don't apply that standard to your own cops. You never ask these questions of your own cops, the ones that you're trying to rely on, when half of what they said, if not more, up there on the stand is not in their reports. It's not in their reports. They didn't write that shit down. You want to get up there and blame him for not taking a photo? Whose freaking case was it? Whose case was it? So I think this point might be too subtle to land with them. It wasn't particularly called out, but if they haven't caught the double standard already, then they're probably, you know, not looking for it. It's pretty much there in plain sight. Jack Spears, I'm watching from the UK. I'm shocked how this judge is ruling. Anyway, Andrea, you're iconic and I appreciate your knowledge. Well, thank you for that. Nice thing to say. I just can't be shocked by Judge Cannoni anymore. It's become a little bit too predictable. You know, I just expect she's going to bend over backwards to do what the Commonwealth wants. And if she can't possibly find a way to justify it, then she'll rule for the defense. But in her mind, like, I don't even know how you think through this issue with the foundation and not run into the confrontation problem. I just don't know how you reach that in your mind and don't immediately, especially as a former defense attorney, how do you not instantly be like, there's a testimonial hearsay problem there? I just don't get it. But she doesn't want to. She doesn't want to be helpful. She doesn't want to see things. She doesn't want to make this process easy for the defense. So it just can't, it doesn't shock me anymore that she doesn't. You know, she exercises what discretion she has and, you know, potentially exceeds it as well to give the Commonwealth every possible advantage here. I mean, we can say one thing: if the Commonwealth can't win this case with that judge giving them the assist, nobody was going to win this case. Michelle J., do all of the videos, Lexus backing, being towed, Sallyport, etc., shown in court get to be used during deliberations? Thanks, Andrea, for all you do. So typically the way that it works, the jury doesn't have a way to play the videos themselves. They aren't normally sent back into the deliberation rooms with like a laptop or a you know, projector that they could plug a USB into or something like that to be able to watch the videos. So they have to normally ask for permission to do that because the court's got the equipment there in the courtroom. Not impossible. They could have their own laptop or something like that. I'm just saying it's not really common, not the norm as far as what I see. So they can typically ask for it to be replayed, and that will typically be granted. But sometimes the court will put limits on things like, you can watch it back once, you can watch it back twice, but we're not going to let you sit there and watch it over and over and over and over and over again. And at least the rationale for that is that they don't want the jury to put undue weight on any one particular piece of evidence. I think it's more important than the other evidence. You're supposed to consider all the evidence as a whole, that type of thing. And so if you pay all this extra attention to the video and like freeze the video here and get up and squint at the video and try to see exactly where the outlines of the broken taillight are and that type of thing, then you would be disregarding witness testimony, for example, about the taillight. Now, of course, in my own opinion, might be a lot of very good reasons why you would do that, because witness testimony often doesn't amount to shit. It's nothing. Talk is so cheap. Talk is so cheap. Memories are bad. People are just not as reliable as they would like to think that they are. All of us told that story about my memory from like before I was 2 years old, Mount St. Helens exploding. Don't think that's possible. Really don't think that's possible. We're kind of all in the same boat when it comes to issues of reliability and just how we perceive and store and recall events. So a lot of good reasons why you might be like, yeah, this video is better evidence than what some people said, but under the law, you're not really allowed to have that opinion. They're supposed to be equal, so you can't give undue weight to the video. So very common for there to be restrictions on it. We'll come back, we'll play it for you once, and that's it. We'll come back, we'll play it for you. If they ask, we'll play it a second time, and that's it. A lot of discretion with the judge with how to handle that type of thing. So to answer your question, yes, generally speaking, it will be made available to them, but there may be restrictions on that. Jennifer King, why does Brennan mispronounce Alessi's name intentionally? I don't know. It seems to be a little disrespect thing that he does. Can't even be bothered to call him the correct name. Perhaps Mr. Alessi is particularly under his skin because Mr. Alessi is particularly bright, particularly gifted. Not to armchair psychologize too much, but this is playground. This is playground bully stuff. Alessi. When you got a witness up on the stand who's bitching about her name being mispronounced, when we don't know who you are and you don't matter and nobody's going to hear your name again in 72 hours, all right, maybe they'll hear it in 72 hours, but nobody's going to care if it's Dever or Deaver. Doesn't matter. You got a witness up there freaking out about their pronunciation of their name while you're down here, perfectly well, because we hear the judge calling him Mr. Alessi all the time. And you still just insist on getting it wrong? Yeah, it's definitely intentionally. So it's just playground stuff. Trying to show disrespect to needle him. I think it's as simple as that. I just don't think it's particularly working, but I think that's what it is. D. Brown, 83. Can Alessi file a motion for mistrial based on right of confrontation tomorrow, or is that over? He can try. I mean, better late than never, but now the issue is it's out. the jury's heard it. The cure, once again, is just going to be for the Commonwealth to call Terry Kuhn, have her testify subject to cross-examination about her testing and the limitations of the testing and interference and all that type of thing. That would, at least in theory, cure a confrontation problem. Should be prior, but you can be maybe less technical about that as long as you got the chance to cross-examine it all. So, you might put them in a position where they would need to do that. I mean, my answer is better late than never. Try. Might not get you anywhere. Probably won't get you anywhere. But at least you've got it on record that you recognize and appreciate that is a significant part of the issue here, is the confrontation problem. Duncan, Idaho, I had a hickey on my neck when I was in the Navy. And when my CO asked me what it was, I told him I had run into a doorknob. The bush taillight theory is dumber than my hickey explanation by far. I think your hickey explanation might be dumber than the previous comment about the concrete while shaving. I don't know how you run into a doorknob at throat level. How many doorknobs are at your throat level? Or were you like gorilla walking, where you get in that squat and kind of walk? Yeah, I don't know. That's pretty bad, Mr. Idaho. That is a pretty bad lie. Beagle Mom, what do you say about the descriptions of the jury today? Reboard writing. I think, number one, it's always very difficult to infer what any of it means. It's just, you can't read the jury's mind as much as we'd like to. I think the information you can actually get about what they're thinking is pretty minimal. At best, you can see, are they interested? Are they not interested? Are they engaged? Are they not engaged? You can sometimes get a little sense of that. But by and large, it seems like the reactions are mixed. Some people are bored. Some people are vividly taking notes. So it's not hitting everybody uniformly exactly the same way. And that makes sense because everybody's an individual. They got their own perspective. They got their own way of looking at things. They got their own sense of what is going to matter to them and what isn't. And so if those things don't line up, then they're going to react differently to what they hear. So the jury is it's not monolithic. And I think the description of the reactions that we got from Jess Machado, I think it tends to show that. So, well, we got a half day tomorrow. I knew. I'm sorry. I knew when Bev said full week next week. I knew that was some bullshit. Okay, she doesn't have the stamina to do a full week, 5 full days in a row. I'm not buying it. I'll believe it when I see it. I don't think she has the stamina for that. So we kind of knew something like that was going to be coming. We strongly suspected anyway. So tomorrow we get a half day. That'll be kind of nice, I guess. We get a little extra afternoon. We can watch more Phillies baseball, although that's not particularly bringing joy these days. Oh, my Lord. If you took my advice over the weekend, watch some Phillies baseball. Sorry about that, guys. It's just the way it goes. It's the nature of this team. You're top of the power rankings. You're on, a winning streak. 9 games, I think, 10 games, somewhere in there. I think 9 games. And then, you got the best record in baseball, and then you got to go get your ass handed to you at home, 19-2 or some ridiculous thing like that. Get totally swept at the bank. That's what it's like being a Phillies fan. So it didn't bring a lot of joy lately. So not necessarily greatly looking forward to that tomorrow. But hey, that's just Part of the game. Part of the game. You get the high points, you get the low points. It's just what happens when you watch, 160 games a year or whatever it is. It's a long season. Long season, a lot of baseball, a lot of time to be really, really terrible. So, maybe we'll do that tomorrow, but maybe not. I saw too, there is another new filing here. Dee Dee's got it, of course. Dee Dee has all the good stuff. So what I think I'm going to do is, because I want to look at that. We'll talk about that tomorrow when we come in before our court gets going. We'll take a look at this motion. It's a Commonwealth motion to preclude new opinion testimony by defense expert Derek Ellington. Don't know what that is about. So, but it's from the Commonwealth wanting to once again interfere with the defense case. Why this is late in the day, I don't know. We'll see. We'll see. But we'll take a look at that tomorrow morning before we go into... Hey, you're allowed, okay? You're allowed because it's baseball. And yeah, I know. I'd be doing the same if we did that to you in your home park. I would be doing the same. It sucked. Thanks for noticing. Appreciate that. Well, at least, it was the Brewers. It wasn't like, the A's or something. Oh, Lord. No, we couldn't quite sweep the A's even. We had to let ourselves get beaten by the A's. So guys, we'll be back tomorrow morning, normal time, but we'll have a half day. So we have that to look forward to, but we'll start off tomorrow taking a look at that new motion that's been filed about Derek Ellington, see what that's about. And then in the meantime, maybe Bev is going to actually read some of the stuff that's getting filed and do something about it. We'll see. It'll be kind of interesting to see how that plays out because, boy, it sure seems like when the Commonwealth files a motion or makes a request, about what they do or don't want to do, all of a sudden the Commonwealth comes in. Let me find the example. Oh yeah, Commonwealth just wants them to not ask questions about Trooper Paul, out of the blue. We'll deal with that. And nope, we'll do a whole voir dire and stuff like that. Can't go into that. But defense has to file a motion about, what they need to do with their case, and we're gonna wait till she feels like getting around to it. So we got defense motions filed that are pending. Now we've got this motion from the Commonwealth. I'm just going to be interested to see, is there any kind of rush to get to the Commonwealth's problems like there is not to get to the defenses? We shall see. So guys, with that, we're going to wrap it up for day 26. Another day in the books. Probably not our favorite day. Wasn't a lot of fun watching Dr. Russell just get disrespected like that. It's not fun. It's not called for, but that is the circus that Judge Cannoni is allowing and even enabling in her court. She's okay with it. So it continues to happen. All of these times that Mr. Brennan has been, sustained for the things that he does, his argumentativeness, his rudeness, his comments, etc. Has it stopped him from doing that? No, of course it hasn't. Because Bev has no control over the courtroom. She doesn't want to have control over the courtroom. She's going to let him do whatever he wants to do. And so if he wants to be, rude and belittling to somebody like Dr. Russell, just because she has an opinion that happens to be pretty devastating to his case, then Bev is going to allow that to happen. And we don't know if that's going to have an effect on anybody's view of the substantive issues of the case. Really don't know. The jury's watching that and thinking, oh yeah, you know what? He's so contemptuous of Dr. Russell that she probably deserves it. She probably is shady. she did volunteer. She took it upon herself to contact the DA and knew that they had a relationship with the defense team. We really don't know. Don't know how that's landing. It's a very uncomfortable place to be, isn't it? It's very much a limbo state when you're in trial. The worst limbo is after all the evidence is in and the arguments are out and we're just waiting for the jury verdict. Because then you're at the point of like everything is done and there's literally nothing to do but wait until you find out. Am I guilty, going to be punished? Am I innocent, going to be set free? It's a really bad limbo, but even just at a point where you're this far into the case and you just want something definitive, it's very uncomfortable to be in limbo where there's still more to come. We don't know what's coming. We don't know how all this is going to play out. It's an uncomfortable place to be, but we are still making progress, guys. We're getting through it. Still a lot more to come. I had to check and look at the last trial, remind myself, how did the defense close the last time? How did they finish their case? They finished the case with ARCA. I have a feeling they're going to do the same thing here. Don't know, but it makes sense. Start off with the data, end with the data. Start off with the critique of the Commonwealth's analysis, end with your own analysis. End with the guys that are going to be hard for Brennan to talk around and so forth. But I tell you, I'm at this point, I am fully backed off of that position that, he wouldn't possibly be an asshole to ARCA because he would know the jury was going to hate that. Oh, no. I retract. I officially retract that. Don't think that's what we're going to get. I think we're going to get a very rude, very belittling, very demeaning type of cross-examination of ARCA. Fully expect that now. We'll see how it flies. A cool breeze. We do say wicked and mass for very or fricking. Good to know. Good to know. I love to know the little regional things that people say. We were always kind of big on rad over here in Washington. Things were really rad. That's also definitely showing my age. All right, guys. We'll soldier on. We'll soldier on. Where there is a defense case, there's going to be Brennon Cross. So we do just kind of have to grit our teeth and bear it. This is the price, and that's why he's doing it. It is the attrition. He wants it to hurt. He wants us to have to suffer. Wants us to have to suffer in exchange for calling witnesses. Yeah, I can take on that challenge. I can take that on. You can't get into a boxing ring expecting that you're not going to get any punches. You're going to get hit. The absolute best boxers in the world will still get hit hundreds of times over the course of a fight. You're going to get hit. It's just, do you accept that as a trade-off to land your own? As long as you can land your own punches, it's a perfectly good trade-off. So, only issue I think with today is the question of was Hank successful at undermining the points that were made? Barros, unfortunately, I think you hurt him. But we also suspect that the tow driver is waiting in the wings. We know he's on the witness list. So if the tow driver can substantiate what Barros has to say, then perhaps it's not such a problem, not so damaging. But just sitting here right now, wouldn't surprise me if the jury's been like, okay, go ahead and disregard Barros. Dr. Russell, dog bite. It's definitely a dog bite. Can't say with 100% certainty, but the pattern fits distinctly. I think a lot of it just depends on how much faith they put in Dr. Russell. That's why, it'd be so helpful to be able to see some of her collection, some of her photos. Show us the pattern. Show us the pattern in other contexts so that we can see the pattern emerge. It's just so much more persuasive to have the reasoning illustrated like that than to just kind of have to accept it on faith that you tell me there's a pattern. Because that's where, then if Hank is successful at bringing her down in the estimation of the jury, then they're just less likely to give her that credit. Take it on faith. She's got this, particular expertise. She's seen hundreds, if not thousands of these wounds. She would recognize the wound. She recognized this wound. You just don't know. You don't know. So we'll see. Another round coming tomorrow. Expect the defense to take punches, guys. It's part of the case. Bad facts are always part of the case. So we just got to see how they deal with it and how they're prepared to respond, what they have lined up, and ultimately are these trade-offs worth it? It doesn't hurt them to call Nicholas Barros, even if Nicholas Barros, ends up being effectively neutralized by his bad recollection of the first trial. Doesn't mean it's bad to call Barros, but it's just it's just unfortunate. But that is how memory is. It's true. It's true. It's such a funny thing. So many vivid memories, and you got to wonder how many of them. Very vivid memory of that volcanic event before I was 2 years old, but don't see how that's possible. I really don't. So got to be skeptical of my own mind. All right, guys, with that, we are going to go ahead and wrap it up for the day. We're about 9.5 hours in. Not too bad. Not too bad. Pretty good day we put in today, guys. So we'll be back tomorrow. We'll take a look at that motion about Derek Ellington, see what that has to say. We'll get our half day in, and then we'll see where we're at. Hey, if it's a half day, maybe we won't have to deal with Brennon Cross. No, I bet we will. It's just going to be our cost for getting through the rest of this, guys. So it is what it is. We can do it together. We can tolerate it together. That's one of the best reasons to watch the trial in a fun group like this, like we have with the chat. Very insightful chat. The great mods that keep everything running smoothly. Feed me information in the feed and stuff like that. So really appreciate everybody's contribution. And now in particular, it can be especially helpful to have other folks sharing in the experience. If you're finding that maybe you don't enjoy this part as much, or it's not as fun, it's good to have people to rely on and to share it with. So all the more reason to be very thankful for all of you joining us day after day to keep taking in this trial till it's done. So with that, guys, enjoy your afternoon, enjoy your evening, enjoy your night, enjoy your morning. I don't know where you are. Those of you in Australia, have a great day. Probably just waking up now. And everybody else, your deep breath, your recenter, remind yourself all this stuff. It's not that it's not important. Justice is very important. What's happening in cases around the world and around the country is very important. But there's other things that are important too. And your own experience, your own happiness, your own tangible manifestation in the world, these things matter too. So don't be afraid to get out of your head if you one of the people that finds yourself maybe trapped in there thinking about stuff, worried about stuff, anxious about stuff. Don't be afraid to get out of your head and just be. Just go be for a little bit. It's a nice thing I always like about hiking and stuff like that. You just turn the brain off. Just go walk, look at things. Such a peaceful kind of experience to get out of your own brain. Haven, AJ, they have an F-150 police cruiser. Cop, yes. AJ, amazed. Cool. I cannot stop laughing at this exchange. Only in America, man. Only in America. Have a F-150 for everything. Yeah, that was pretty funny. It is kind of cool. You know, cooler than like the Bearcat and stuff like that. You know, the whole paramilitary stuff. I can see reasons why you need a police pickup truck. Why not? Why not? I don't know about a regular patrol vehicle, but this is exactly why these types of conditions are why you would have something like that. All right, guys, we're heading out. Enjoy yourselves. Take care of yourselves. But I do look forward to having you back here tomorrow to keep us all company. We'll get through it together. And we'll just see where we end up, guys. A lot of case still to go. So with that, appreciate all of you. And we will see you back tomorrow morning.